log back out. And then join without audio. That way when I play the body cams, I won't.
Are both these screens on? These two to my left. You can see them, I can't.
The bigger one is on, but it's not showing the Zoom, and the other one is not on.
Okay. What is on the biggest screen?
You.
Me. All right.
Like the
Oh, it's not connected, so let me add it. Okay.
I don't know how to not join with audio.
mm-hmm.
Usually when I share the video, I just do it through the Zoom.
Okay. She said where she was coming from.
Oh, she's in the lobby.
So she needs to come up here today.
Yeah.
So have her text me that she needs to come up today. Don't look for her. Why does she go to the lobby?
Probably has to like put up her gun or whatever.
No, they do that at the door. You mean the lobby on 3 or the lobby downstairs? Those.
How about now?
It's on.
Great. Thank you. Oh, okay. Can you, this screen, does it go through you?
Yes.
Okay, can.
Oh, I mean, so I can.
Yeah. I have the, well, you've got it. Deidre sent you the meeting ID.
Good morning.
My apologies.
It's all right. You're in luck. We're still waiting on the officer. This one up here? We'll see. Let me look in a sec. I just need to move. Thing.
Yeah, that's fine.
Okay, yeah.
It's up.
Yeah.
Thank you.
Yeah, stipulations, put it on the record.
Again?
If y'all have stipulations, put them on the record at the start.
Which lobby? I'll go walk her up here. She'll tell us where she's at. She wrote 3 times. She can answer her phone and text her there. She wrote it down on 3.
Judge Officer Philemon is in the building. We're just trying to
Excellent.
get her to this courtroom.
She's been here before. I bet she can do it.
three lobbies, but now that she was fine.
Mm-mm.
She's not in.
Usually it's me.
I'm looking through her phone. Check down on three.
Judge Officer Philemon is here.
Great. All right, Mr. Hirsch, have you had a chance to get settled?
Do you need
Yes.
me to do anything?
All right, well, let's go on the record. Ms. Rivers, we are here in State versus Emmanuel Tezera. It's indictment 23 SC 191863. We are waiting, I think, on a couple more jurors. They're not supposed to be here till 9 anyway, which is in about a minute. We're waiting on 2. Is it the first 2? Because there were 2 people we didn't make voice contact with.
One of the first 2, number 1 and number 7.
Number 1 and number 7. All right, if you'd let Ms. Hansberry know, so she can reach out. 7, we did have voice contact with. Number 1 and number 2, we just left messages and emails. Clearly they went through for one of the people because that person's here. Thanks. All right. We need to take up the, we did connect with juror 1, who's technically juror 2 from yesterday, but the first juror who was selected, so she ought to be here soon. We need to take up the question of Jackson Deno and the voluntariness of Mr. Tezera's statements to any of the law enforcement officers who will be talking about things he said. I know from our suppression hearing of several months ago, Officer Philemon testified, and she relayed in that hearing some of the things that Mr. Tezera said. And my recollection, Ms. Nix, and this is pre-Mr. Hirsch, is that by that time, the investigator Skidmore, had decided that both Ms. McCall and Mr. Tezera were effectively in custody. They were both going to be arrested for the domestic incident that had happened. Ms. McCall was handcuffed and taken away. Mr. Tezera wasn't handcuffed because of his injury and his need to get to the hospital. But that didn't change at least Skidmore's perception that Mr. Tezera wasn't free to go. I don't know what Mr. Tezera thought, and we'll work through all that. But at a minimum, we need to make a little bit of a record about what it is you are hoping to get into evidence during the course of the trial.
Yes, sir. And my understanding of the facts are that at the time that the defendant made the statements regarding that the items in the hallway were his, Investigator Skidmore had not come to a conclusion that he was going to be arrested.
Okay.
Investigator Skidmore was still investigating, and a lot of the probable cause that led to the arrest of Mr. Tezera, at least with regard to the domestic, happened after he had already been taken to the hospital when Investigator Skidmore spoke with Ms. McCall. Officer Philemon she can testify to what she knew at the time. I can go ahead.
Okay, well, why don't we do that? So Officer Philemon 1, I appreciate you coming in early. We're gonna hear from you in just a moment without the jury here. And then we've got to bring the jury in and take care of a few things before you can then be called to the stand to testify in front of them. Ms. Nix explained that you will be the state's first witness, so we'll minimize your weight, but you will, after you share a few things with us outside the presence of the jury, we're going to need you to stick around, but you'll just need to be outside the courtroom. But I appreciate you coming in early. All right, if you want to come on up to the witness stand.
Raise your hand, one sit. You swear firm that testimony will give. You state spell your name for the record.
Ludina Filemo, first name Ludena, last name Philемond.
Officer Philemon, where are you employed?
Excuse me, I didn't hear you.
Where are you employed?
City of Atlanta.
What do you do for the city of Atlanta?
I'm a police officer.
And were you working in that capacity on June 11th of 2021?
Yes, ma'am.
Did you respond to any calls at 1888 Emory Street Northwest?
Yes, ma'am.
When you arrived, did you speak with anyone?
Yes. I spoke both to Mr. and the person that he was involved with in a altercation.
Okay. You spoke with the defendant. You pointed over to the defense table as the person sitting at the defense table, the person that you spoke to.
Yes, ma'am.
Okay. Can you describe him, like what he's wearing, demographics, things like that for the court?
Sure. He's sitting over there with a blue grayish suit, white shirt, burgundy tie,
Glasses, no glasses.
no glasses.
All right, you've identified Mr. Tezera.
All right. Okay. When you spoke to him, what were the circumstances surrounding? What was the, where was he? Where were you? Tell us about what happened when you first arrived.
When we first arrived, I saw him in the hallway. He was bleeding. He had no shirt on, had his pants on, but was bleeding. And he said that he has been stabbed.
When you got there, Officer Philemon, were there other officers already present, or were you the first responding officer?
Me and an investigator were the first responder.
Did you show up literally simultaneously, or the investigator was there before you?
We show up together.
Okay, is that Skidmore?
Yes,
So you and Skidmore walk into this hallway and see what you're describing?
yes, sir.
Okay. And was Mr. Tezera alone in the hallway, or were there other people with him?
At the time we arrived, he was alone in the hallway.
Okay, no shirt, pants on, bleeding from some part of his body. Okay.
All right.
And were you the one who asked Mr. Tezera what's going on, or was it Skidmore?
I asked him as soon as we walked in, I said, "What's going on, bro?" Which I did ask him. Then he started telling us what was.
And that's where he said, "I've been stabbed," and whatever else he said. Okay, thank you.
What happened next?
When we got there, he told us that he's been stabbed and his girlfriend stabbed him. So we knocked on the door and his girlfriend came out, and then fire, which Grady was not on scene at the time, fire started attending to him. His girlfriend opened the door and I detained his girlfriend. He came outside with her hands up. I detained his girlfriend, and at the time, fire was attending to him while I was detaining, and Investigator Skidmore was actually talking to his girlfriend.
Okay.
And
Did-
When you say fire, you mean like fire and rescue EMT types?
Yes.
Okay, was there actually a fire? So they were there with hoses and
No,
everything?
no. The fire, the EMT fire responder, first responder.
Okay, so they were there for first aid reasons?
Yes,
Not a
not for
Fire.
fire.
okay.
And you said that Investigator Skidmore was talking with Ms. McCall. Did you speak with Mr. Tezera?
Yes, after I stopped attending to Miss not sure her name. Then I went over to where EMT and started talking to him.
Okay. What did y'all talk about?
Well, one of the things he was more concerned about was his belongings in the hallway. And then what I was more concerned about his health because he was bleeding. But I wanted him to get the medical attention that he wanted, but he was more concerned about his belongings in the hallway.
Okay. Was he in custody at this time?
No,
Was he told he was detained?
no,
Was he told he was not free to go?
no,
And did he appear to be under the influence of anything?
not that I could tell.
Okay. When you arrived, did you believe him to be the victim?
Yes,
Okay. And you stated that he was concerned about his belongings in the hallway. Did you ask him about the belongings in the hallway, or did he just start talking to you about them?
he just started talking to me about them.
Okay. And what was he saying about those belongings?
He said, those are my stuff in the hallway. They're very important stuff. My father was gonna come pick them up.
He stated that his father was going to come pick them up.
Yes.
Okay. Did he do anything to try to get his father to come pick them up?
Yes, he did.
What did
He
he do?
called his father a couple times, and the last time he called, I told him before, he called his father again. His father was in the shower. That's what he told me.
Okay. And you stated earlier that you were concerned about his health and well-being. Did he wait for his father to arrive before leaving for the hospital?
Well, once Grady came, Grady said that we needed to go. So I did tell him and ask Grady about his things in the hallway. And Grady said that he could not carry all of them in the ambulance with him. However, he could pick whatever the most important to him. So we did go to where his stuff were in the hallway. He picked up a backpack and started putting things in it where investigator Skidmore said, leave it, this is a crime scene. And we left without picking anything and we went to Grady.
Okay. Did the defendant appear to understand why you and Investigator Skidmore were there?
Yes. Somebody called 911 and he was stopped and we were there to render aid and help.
Okay. Do you know who it was that called 911?
I'm not sure if it did or his girlfriend did.
Okay. Did you make any promises to him if he made any statements to you?
No.
Did you make any threats or any threats to him if he didn't tell you anything?
Nope.
And from your understanding, the defendant was not in custody at the time?
It was not.
Okay. All right.
So Grady and fire aren't the same. There were EMTs from some local fire department who were there when you were there. And then Grady, as in the ambulance people, they showed up and they're the ones who said, let's go. You got to go now. Don't worry about all that stuff there. You can only take one bag.
Well, Grady said he can't take everything because in the hallway with him, but whatever is most important to him,
Got it.
he could take.
And those were your words. That's right. But I just want to make sure Grady is different from what you were calling fire.
Yes.
Okay.
Grady is usually take a little time to get there. So when we go, fire and I, we actually arrive on the scene together.
Okay.
Which is before Grady comes, they assist and to whatever extent they could assist until Grady gets there.
Got it. And when they got there, they said, we need to get this guy to the hospital. And that's when this whole conversation about, can you bring something? And Skidmore said, you can't take anything.
Yes.
Okay.
How serious were his injuries?
I'm not a doctor, but he was bleeding. There was blood on the floor. He was bleeding and there was blood. And from what I hear, the EMS were talking about, he was stabbed several other places besides where most of the blood was coming from.
And was he in was he agitated from these injuries or in any kind of heightened state of emotions?
No.
Okay.
I don't think so.
And you stated earlier that he was more concerned about his belongings than his injuries.
Yes, ma'am.
Okay. No further questions, subject to redirect.
Okay. Mr. Hirsch, do you have any questions for Officer Philemon?
Yes. Good morning, officer.
Good morning.
How are you today?
I can't complain. You?
Good. I'm great. So when you get there, you say that you and Skidmore are first there on the scene from Atlanta Police Department.
Yes.
At that point, is fire there?
We all came together.
Okay, so you came with, how many folks from fire were there?
I don't recall because it took us a long time to get to that. It took us a minute to get to that apartment complex where he was at. Like,
Okay, once inside the complex, it took you a while to find the actual apartment.
no, it took us a minute to get inside. Once we got inside, we had to ask a couple people where to go. Probably about, let's see, 1 female, 2 male. I'll say approximately about 4 or 5, 4, 3 or 4.
All right, and if this was a domestic violence stabbing, why was fire there?
The reason is when we come, if Grady is not with us, we always call for the fire department just in case they need any help to render any type of first aid help, and this is where they come in.
All right, and then in addition to fire, were there EMTs there, or is that this emergency or ambulance folks there, or is that the same as fire?
No, the ambulance folks came afterwards.
Okay,
And that's Grady.
That's Grady.
Okay.
all right, and when they came, is that when my client got into the ambulance?
No. So when they came in, I guess fire had already, I don't know what they were doing to him, what render aid or whatever. When they came in, they talked to the first EMT, which was fire. I don't know what they said, and then they decided, let's go. We had to go.
All right, so there's a body cam in this case and photos, right, correct?
Yes, sir.
And when you see Mr. Tezera in that, he's got a bandage around his arm. Who put the bandage around his arm?
The fire people will be the EMT that came with us, the very first one, not Grady.
All right, do you know how long that took?
Not sure.
During the time that is that the first thing that happens is he gets bandaged?
I think so.
You think that took 10 minutes?
I have no idea because I wasn't attending to him. I was attending to somebody else when they started rendering aid to him.
All right, if you could speak up a little bit for me.
I'm sorry. I said that I was not paying attention to what fire were doing at the time. When they were helping him out, I was handling something else afterwards, and I went over there.
All right, and do
Do
you know what you were handling?
Yes, I was handling the girlfriend at the time.
All right, Cameron McCall. Did you put Cameron McCall in handcuffs?
Yes, I did.
How long do you think you were interacting with Cameron McCall?
Probably approximately 10 to 15 minutes. I'm not
Okay.
sure.
I'm going to pause you for a quick second. How are we doing with jurors? Everyone's here. Okay. Keep going. Our jurors are here, so we'll stay focused on the Jackson Deno part of her testimony.
And then after you attend to Ms. McCall, do you talk to is it Investigator Skidmore? Detective Officer Skidmore. Do you talk with Officer Skidmore before you go and sit with Mr. Tezera?
I don't recall.
Okay. Skidmore was acting as lead in this case, is that right?
No, because somebody else came and told me, another officer came and told me that he was the primary officer.
All right. Who was and when you say primary officer, we say the lead officer, the lead
Yes.
detective? Who was the lead detective?
Officer, don't recall his name right now.
Uh-huh.
She said she doesn't recall his name right now.
Okay. Now, after Mr. Tezera is bandaged, if he wants to walk away, say, hey, thanks a lot, guys. I'm out of here. I'm going home. Would he have been allowed to leave?
We wanted him to seek medical help, so
I understand what you wanted, but what I'm asking is what if he wanted? In other words, if he's like, I'm good, see you guys later. Would you have allowed him to leave?
yes, because he was not in custody.
And had that been the case, then he would have been able to take all his belongings.
Yes,
Now, there's a little bit of a miscommunication between yourself and Officer Skidmore in terms of what he can take to Grady. Is that correct?
well, I asked Grady because he was concerned about his belongings. I asked Grady, and Grady said he could not take the things. At the time, to me, he was a victim.
Right.
So I asked Grady, and Grady said he couldn't take everything. However, he could take whatever is most important to him, which as a victim who wants to take a lot, I said to him, okay, let's go grab, you can't have everything in the ambulance. Let's go grab whatever is important to you.
Right, maybe a laptop, medication, toiletries, wallet.
Whatever is most important to him.
All right. So, but then when he began taking stuff, Officer Skidmore said, no, you're not allowed to take anything, regardless of what Grady says. You're not allowed to take anything because this is a crime scene.
Yes, sir.
So you say he was free to go, and if he left at that time, he could have taken everything with him, correct?
So you covered that already. She
All right.
did say that.
But that was a miscommunication with Officer Skidmore.
At the time, I didn't think he was a suspect, so yes, he could have taken.
Those are all the questions. Thank you.
Okay. Any redirect?
Just one, Officer Philemon, what was the state of his belongings? Were they clean? Did they have anything on them?
They were just in the hallway.
Did they have blood on them?
I'm not sure if they have blood on them or not.
Okay, that's all I have.
All right. Officer, thank you. The investigator will let you know where you can be comfortable until the state's ready to call you. Is Officer Philemon still forecast as your first witness?
Yes, sir.
Good. So all the jurors are here. When they come in, I have to give them an initial charge, and then it'll be opening statements from the lawyers, and then you'll be up. So we'll move as quickly as we can.
Thank you.
Thank you. Mr. Peoples.
Yes, good morning, Judge.
Good morning.
If I may, in the schedule of the lineups for today, the forensic chemist, Summer Hutton, she's scheduled to testify in DeKalb. And so we're trying to coordinate the time for her. If it's after lunch, how long is the lunch period?
Lunch is 12:30 to 1:30. I have a meeting, a Zoom meeting, that'll go from 12:30 to 1:30. So normally lunch is sort of defined by where are we with the witnesses, but no matter where we are, we'll stop real close to 12:30. Maybe we'll be done with the witness, but I may have to interrupt a direct or a cross so I can get back there. I'm running the meeting, so I need to get on.
Okay.
So I don't know if that helps. And obviously we can put Ms. Hutton on in any order. If she needs to go first, she can go first. But as she's managing her schedule, the window would be between now and 12:30 or between 1:30 and 5-ish.
Okay.
Okay, sure. I hope that helps.
It does.
Mr. Hirsch, tell me what concerns you have about the voluntariness of Mr. Tezera's statements, which seem to be limited to, hey, that's my stuff. I want to take my stuff. Not particularly responsive to interrogation. In fact, I think it would be a strain to call any of the interaction as an interrogation. Layer on top of that, it's not clear to me that Mr. Tezera was in custody. His belongings might have been in custody because Skidmore viewed it as a crime scene. But we can hear from investigator Skidmore outside the presence of the jury, if you want, about his perspective about whether Mr. Tezera was in custody. But even then, I don't, now that I've heard Philemon for a second time, I think it's a stretch to characterize her interaction with Mr. Tezera as a questioning of him. It's like, hey, let's get you onto the ambulance, and he wants his stuff that he is identifying as his stuff. But I'm just giving you my read of it. I'm happy to be shaped by your read of it.
Your Honor, actually, the testimony makes me just ask the court to reconsider its motion to suppress. In other words, the state wants it, and as far as the statements, he wasn't in custody. So, you know, maybe they were spontaneous, maybe they were non-responsive. But as far as the statements, he's not in custody. He could have left and taken his stuff. Well, if he could have left and taken his stuff, then there's no reason, there's a Fourth Amendment violation for them not letting him take his stuff and not letting him leave.
So I think that's a Skidmore question. I don't think investigator Skidmore would tell you that he could leave with his stuff. I am viewing this akin to traffic stop, and the front seat passenger says, hey, you've run my name, you've run my number, I got a broken finger, I'm okay with my broken finger, I'm going to treat it, I can go. Could I take the car? You may not take the car because we stopped this car and we're going to impound this car. So if you want to revisit suppression after Skidmore has testified to the jury, we're not going to have another suppression hearing.
No.
I'm happy to hear you out on that. But I heard a lot from investigator Skidmore, a very able defense attorney who brought the motion.
Yes.
And I didn't find it to be the way you're describing it. I draw a distinction between Mr. Tezera's ability to leave and his ability to take things with his blood on it. Because I think you'll hear from other witnesses that there was blood on some of these bags and there was a volatile scene, and it wasn't clear whose was what. And maybe he says it's his, but maybe it's McCall's, and should he leave with her stuff? So it seemed plain and appropriate to me that Skidmore wanted nothing to leave the scene in terms of what's out in the hallway. But we'll hear from him and you'll get to explore that on cross.
Right.
But back to your question, which prompted this examination of Officer Philemon. Do you have concerns about the admissibility of your client's statements to Officer Philemon?
Yes, Your Honor, I'll stand on Jackson Denner that he was in custody, wasn't able to leave based on the testimony, not just of Officer Philemon, but the testimony at the suppression hearing where Skidmore says plainly and clearly he was not allowed to leave. We had officers on him the whole time. He was not allowed to take his stuff. He was going to be under arrest. Or I don't even know. He differs on whether he was going to be under arrest and whether it was PC, but he clearly says he was detained and couldn't leave. So based on the totality of that hearing and this hearing, I believe that he was under arrest and that his Miranda warnings were not read to him, and they should have been, and he's responding to the questions officers asking him.
Okay. Ms. Nix, anything you want to add?
Judge, what matters is that the defendant did not believe that he was in custody. I mean, Officer Philemon just testified that she believed that he was the victim in this situation, and it wasn't until further investigation that they developed probable cause in order to place him under arrest. But even if he was in custody, which I don't believe that he was, the Officer Philemon was not asking him questions like, hey, is this your stuff? He was saying, that's my stuff. So Miranda would not apply because he wasn't being asked questions. under the totality of the circumstances, these statements were voluntary and therefore are admissible.
Okay. I agree. I find from the evidence presented here that Mr. Tezera was not in custody, so it was not a custodial encounter between Officer Philemon and Mr. Tezera. But assuming that he was not free to leave, because if he tried, Skidmore would have said, don't let him go. Although I think you're right, Ms. Nix, the framework is, what did the defendant think? And we don't have his testimony, but I could see an argument that an objective observer would think he's not free to leave. There are a bunch of officers and everyone is funneling him towards an ambulance and no one is saying, or if you want, you can just go wait for your dad. That didn't seem to be presented to him as an offer or an option. But assuming for purposes of this discussion that Mr. Tezera was in custody, I further agree with the state's position that this was not an interrogation, that there were spontaneous statements, and then it was Officer Philemon reacting to things Mr. Tezera was saying and asking, that's my stuff, I want my stuff, I need to take my stuff with me, as opposed to Officer Philemon going down the hallway saying, is this your bag and what's in it? And is this your bag and why did you put it here? She was reacting to things Mr. Tezera was doing and saying, and was fully prepared to let him take his stuff with him until a senior officer interceded to say, nope, you can't take your stuff with you. The stuff is in custody. Tezera may be in custody, maybe not. I don't think that's what defines the issue. I just don't see that an interrogation occurred. And so Miranda wasn't required in that setting. And so the Jackson-Deno analysis really doesn't apply because it wasn't an interrogation. Okay, so for now, she can testify to that effect, and we'll see if there are motions after she testifies, and if there are motions after Investigator Skidmore testifies. Anything from the state before we bring the jurors in?
No, sir.
Mr. Hirsch, anything from the defense?
No, Your Honor.
Okay, let's bring our jurors in, please. Showed it to him. Were the scales good to you this morning? Are you trending in the right direction, Mr. Peoples?
I am, Judge.
Good.
I am, Judge. So I'll let you know how it goes.
My son has some recommendations for maximum weight gain.
I'll get with you.
Thank you. Good morning, ladies and gentlemen. Please take a seat. Thank you all for being here more or less on time. We were a little nervous because we didn't connect with everyone voice to voice yesterday, but everyone eventually got the word and made it here. We had to take up one legal matter outside your presence, so that's why we're starting a little later than 9. But we actually got here around 8:40 to knock that out. It just took a little bit longer than we thought. So we're starting a little later than I had forecast, but that will happen from time to time. You showed up exactly where you need to show up. Where you come, when you're coming back from lunch, when you're coming back tomorrow, et cetera, will be report to that jury room. So you go to that door, press the buzzer, come on in. More than one of you can go in at once, and I or someone on my team will let you in when you buzz. That jury room is your space. The waters in the fridge are for you. If they run low, let us know. That Red Riding Hood basket full of snacks. Those are for you. Don't bring the snacks out here. Feel free to bring the water out here. Nothing wrong with having water out here. But that is your space. And if anything is running low or it's too hot or too cold or the restrooms aren't clean, let Deputy Gordon or me know, or Ms. Hansberry. Did you all meet Ms. Hansberry? She's dressed really colorfully today. If you saw the colorful person. That's my judicial assistant, and she will be making sure everything is okay if you let her know. We are ready to get started. In a moment, I'm going to give you some preliminary instructions, legal instructions, and then we'll have opening statements from the lawyers. But before we can do that, I need you guys to take a second oath. Yesterday, you took the voir dire oath, but you're about to take the juror oath, your oath to serve as a juror. So if you all could stand and raise your right hands. Do you swear or affirm that you shall fairly try this case between the state of Georgia and Emmanuel Tezera, who is charged with trafficking cocaine, and give a true verdict according to the evidence? Please say yes if you so swear or affirm. Yes. Does anyone not so swear or affirm? Okay. Thank you. Couple of housekeeping matters before I get into the charge that I'm going to give you. From here on out, you'll come into the courtroom and you will leave the courtroom as a group of 14. We can conduct no business unless all 14 of you are here. So if we're waiting on one, we're all waiting on one, and let your colleague know, hey, the rest of us were here on time. It'd be good if you could be here on time as well. We'll break for lunch around 12:30 today, and that lunch break will be about an hour. Tomorrow, we start at 1. I'm one of our drug court judges, and every other Wednesday is drug court. And so I will be working with participants in drug court until about lunchtime. So tomorrow, you won't get a lunch break. You'll get a brunch and breakfast break. You can do whatever you want with your morning. No one's going to tell your employer that you're not here. So you manage your morning as you see fit. But we need you here a little before 1 so that 1 o'clock we can bring all 14 of you in. It would be great if tomorrow we could go till 6. I know I said 9 to 5, but we're starting at 1. But your commitment was 5. And so I'm going to check with you at the end of the day. You may have childcare, pet care, plant care, reasons why you cannot stay past 5. And so it's not a forced request. It's a, hey, we could squeeze in another hour if you could be here till 6 tomorrow. Thursday, we're back to 9 to 5. I think we're going to be done with the trial on Thursday, but we'll see what kind of pace we have today with the state starts, so with the state's witnesses. Note taking, you all have notepads, and we provide you with a pencil because that's all the county can afford, but you're welcome to use your own pen if you want to use a pen. And you are free to take notes. You are not required to take notes, but know this, we do not replay witness testimony. If you're back there during deliberations saying, man, did that guy say it was raining or not raining? We can't give you a transcript because that transcript won't be prepared yet. Ms. Rivers is taking down everything that's said when you all are in court, but she's creating right now a preliminary transcript. It doesn't become an official transcript for a bunch of months because she's working on a previous trial in her spare time. So you will be relying on your individual and your collective recall when you deliberate. That's why we give you notepads. You may choose to write some things down. Do not try to write everything down. 1, you can't. But 2, if your head is buried in your notepad, you're going to miss what might be an important tell as you're watching a witness testify. I'm going to tell you in a minute about your role determining the credibility or believability of witnesses. One way we as humans do that is we say, hey, when she was getting questions from the prosecutor, she was looking at the jurors and engaging you all. But once the defense attorney started asking questions, she turned away or started to sweat, was reacting very, very differently. Now, it could be hot flash, but it could also be that tells you something about the way you're going to judge that witness's credibility. And you will miss that if you're like, okay, what's she saying next? What's she saying next? So don't bury your head in your notes. Your notes need to stay private, as in you don't share them with anyone else in your group until you begin your deliberations. And then you're free to use them as an aid to your recollection. But if juror 1 remembers independently that the guy said it was raining and juror 2 wrote it down, the fact that it was written down doesn't need to change your mind. It could. I'm not so sure. And if 5 people wrote down it was raining, maybe that convinces you, yeah, it was raining. But they need not take precedence over your own recall. And finally, about notes, they will be destroyed at the end of the trial. They're not made part of the record. So if you're writing down, gosh darn, that judge is you go ahead and write that. I won't read them. They literally get shredded and they never see the light of day. The lawyers don't get to read your notes to see what your sense of the case was as we're moving through it. All right. One last rule of the road before I give you some law. The lawyers are not allowed to interact with you outside the courtroom when all of you are present and I'm present. This has a kind of funky corollary that if you're walking down the hallway because it's a break and you're trying to figure out which way is the vending machine or what's a good place to eat, you guys work around here, they're going to treat you like you have COVID and the plague. They can't have a conversation with you, even it's as innocuous as is the men's room this way or that way. Because you can imagine if you're walking down the hallway and Ms. Nix is chatting with you and Mr. Hirsch is at the other end of the hallway and sees these jurors talking with the prosecutor in the middle of the trial, he's going to think, what's going on here? He's entitled to know what she says to you all. I'm entitled to know. So I don't think you'll bump into them out in the hallway, but if you do and they turn and walk away, they're not rude. They're just following the very clear instruction that their interaction with you is here in court with all of you present. All right. The defendant, Mr. Tezera, is charged in the indictment that I'm getting my hands on with a single offense. It's a crime, what's alleged, meaning a violation of the law of Georgia. I'm going to read you the specifics of what Mr. Tezera is charged with. Reminder, you'll have this document with you, so you're welcome to write down the legalese of the allegation, but this indictment goes back with you all for your deliberations. The allegation, the one allegation in the indictment, is that Emmanuel Tezera, on the 11th of June, 2021, here in Fulton County, was unlawfully and knowingly in possession of a quantity of a mixture of cocaine, and that mixture had a purity of at least 10%, and the weight of the mixture was 200 grams or more. That is trafficking cocaine. Now, as I told you early yesterday, and I'm going to repeat again, this charge, this indictment, is not evidence of guilt. In fact, to this charge, Mr. Tezera has entered a plea of not guilty. She says not guilty here on the indictment. That's the issue you all are here to resolve. The state says this thing happened, and Mr. Tezera did it, and Mr. Tezera is saying not guilty. The indictment, the plea of not guilty, are evidence of nothing. Mr. Tezera sits before you with the presumption of innocence in his favor. This presumption remains with him unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt. You're going to hear that phrase many times during this trial, that Mr. Tezera is guilty of the crime charged. A defendant should not be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. This burden of proof beyond a reasonable doubt, stays with the state throughout the trial. There's not a point where they tap out, said, we've made it, and then I turn to Mr. Hirsch saying, okay, you better start doing something. There is no burden on the defendant. Mr. Tezera does not need to testify if he chooses not to. Mr. Hirsch doesn't need to say another word in this case. I suspect he will. He's a zealous advocate for his client, but because there's no burden on the defense, Mr. Hirsch might not give an opening statement. He may not ask questions of the witnesses the state calls. And most certainly, he doesn't need to put forth any evidence. At a certain point in the trial, I'll ask Ms. Nix, call your next witness. She'll say the state rests. Mr. Tezera has an absolute right to present evidence if he wants to, but no burden to do so. So I may turn to Mr. Hirsch and say, well, I will turn to Mr. Hirsch and say, well, you call your first witness. And Mr. Hirsch may say, the defense rests. And that's fine because they have no obligation to put any witness on or share anything with you at all. But they have the right to. And so it may be when I turn to Mr. Hirsch, he says, great, our first witness is so-and-so. And they present their side of the case, should they choose to present a side of the case. Now, this burden of proof beyond a reasonable doubt does not mean that the state must prove the defendant's guilt beyond all doubt or to some mathematical certainty. The state's burden is reasonable doubt. And that phrase means just what it says. It's a doubt based upon common sense and reason. It's not a vague, arbitrary, or speculative doubt. It's a doubt for which you can give a reason, and that reason arises from your consideration of the evidence, lack of evidence, or conflicts in the evidence. If, after giving careful consideration to everything you've heard and seen in the case, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit the defendant. But if no reasonable doubt exists in your mind as to the defendant's guilt, you would be authorized to convict. Now, the basic structure of a criminal trial is as follows. In a few moments, both sides will be given a chance to present opening statements. This is a preview or outline of what they think the evidence will show or won't show. So Ms. Nix or Mr. Peoples will get up and say, this is a case about whatever they're going to say, and you're going to hear from this person who will tell you this and that. It is a preview, but it is not evidence. Nothing the lawyers say in this case is evidence. They are advocates. They are trying to convince you, convict, acquit. But what the lawyers say is not evidence. So if Ms. Nix gets up and says, you're going to hear that there were 400 pounds of this on the floor of an apartment, that's her forecast. But unless and until you hear a witness convince you of that, then there's no evidence to that effect. Mr. Hirsch will be given an opportunity to give an opening as well. He can give it right after Ms. Nix. He can also reserve and give his opening when the defense presents a case, if the defense is going to present a case. Once the openings are done, then the state will call its first witness. And when that first witness answers the first question, you will have begun to receive evidence. It's what witnesses say, i.e. testimony, and exhibits that are admitted, a picture, a document, a video. That's the evidence that you consider in reaching your decision. At some point, as I mentioned, Ms. Nix will say, well, the state rests. At that time, we'll see if the defense is going to be presenting any evidence. With no burden, they don't have to, but they're certainly entitled to. Once both sides have rested, the attorneys get a chance to get in front of you again, and this time present what we call closing arguments. This is when they heartily and zealously advocate. Ms. Nix or Mr. Peoples will be advocating for a conviction. They're going to tell you all the reasons why the evidence shows Mr. Tezera is guilty. And Mr. Hirsch will be given the very same opportunity to argue the contrary, that the evidence is insufficient, it's conflicting, it doesn't move beyond a reasonable doubt. When the lawyers are done with their closing arguments, which won't be evidence, it's an effort to persuade, then I will give you a final charge. That's when I'll tell you what the elements of trafficking are and talk to you a little bit more about reasonable doubt and intent and identity and things like that. And when that charge is done, you get the case, you go back, and only then do you begin your deliberations. During trial, as you have no doubt seen on TV, lawyers have an opportunity to object. A lawyer will stand or at least say, objection, hearsay, objection, leading, whatever the objection is. I have a duty to rule on those objections. My rulings are simply that. They are rulings. Overruled, denied, sustained, whatever my ruling is. Nothing I say during the course of the trial should be interpreted by you as some comment on the strength of the evidence or the strength of the case or the credibility of a witness. I'm merely applying the law as I understand it to the objections that are made. If I sustain an objection, then the lawyer who asked the question needs to ask a different question or move on. If I overrule an objection, we keep going in the direction that lawyer was trying to go. Every once in a while, I may, in response to an objection, tell you to disregard something you were heard. If I sustain an objection, but it's after the witness started answering, the lawyer who made that objection may say, Judge, I move to strike that testimony. If I sustain it, I'm going to tell you, hey, disregard what you just heard. That may seem like an unfair request. Judge, I heard him say whatever he said, but I mean it. You should cross it out if you wrote it down. And if during deliberations, one of your group says, hey, remember that guy said that thing? And you remember, but wait, the judge said to disregard that. you need to do that. Before you say, but if that's the central piece of evidence we think, and you're telling us to disregard it, how do I unremember that? That will not happen. If what you hear is so problematic that you heard it, I don't tell you to unremember it. I grant what's called a mistrial. We bring in a different jury to hear the case another time. We do our best to avoid mistrials. So I don't think you're going to hear a witness say something and you were so startled by it, and then a lawyer says, wait a minute, they need to unremember what they just heard. That's not fair to jurors. And the remedy, as I said, is to we start this all over. Not with you, but another 14 jurors. Lawyers are also able to make motions, and the only distinction you need to worry about between motion and objection is motion means a break for you. A motion is something much more substantive and involved than an objection, and they don't want to talk about it in front of you because in talking about it, they're going to be sharing with me what they don't want you to hear, and they can't do that with you here. So if you hear a lawyer say, Judge, I have a motion, I'll either ask, could we wait till a break? Or, okay, you all need to step outside. We try to handle those kinds of things during your lunch break, after you leave for the day, or like we did this morning, because there was a motion made even before we had started. We try to do it before you show up, but things can happen. Trials are dynamic. And so there may be a motion that requires an extra break. Know that we are trying to use your time as efficiently as possible. I've talked about the lawyer's role, advocating, objecting, etc. My role, ruling on motions and objections and giving you the law. And I want to emphasize again, nothing I say should be deemed by you as any indication of what I think about the strengths or weaknesses of the case. That's not my role. I'm here to see that the case is tried consistent with the laws of Georgia. You have important roles in this case. You are, above all, the fact finders. You are deciding what happened in this case. While I'll be giving you the law, and you must follow that law, you'll be applying the law to the facts to see, has the state proven beyond a reasonable doubt, element 1, element 2, however many elements there are to trafficking cocaine. You will also be determining the credibility or believability of witnesses as you do your job. In thinking about credibility, you're free to consider all the evidence you've heard in the case. You may hear 3 witnesses testify in a way that makes witness 4 seem more or less believable, and you're free to connect testimony in that way. You're also free to judge the manner in which the witness testifies. This is your perception of how that witness is receiving questions and responding to them, as well as the witness's interest or lack of interest in the outcome of the case. You may, as fact finders from time to time, have questions of your own in the middle of trial. I don't understand what this witness said, or I want to know a little bit more. The lawyers didn't go quite in the direction I wanted to go. You are free to ask questions during trial, but you do it in a very specific way. At the end of every witness's testimony, I will ask you, if you have questions, to write them on those note cards. You can see on a little bench in front of a few of the jurors, the note cards. Make sure you got your own little set. You can be writing the questions down during testimony. But what I see is jurors often then cross them out because the questions get answered as the lawyers go further. But at the end of each witness's testimony, I'll ask you if you have any questions. And if you do, you'll get a chance to write them down. You'll give them to Deputy Gordon. I will review those questions with the lawyers, because in the same way that lawyer X is free to object to lawyer Y's question, the lawyers can object to your questions. Your questions may be legally improper. They may be fascinating questions, but it calls for hearsay or gets into an area that isn't sufficiently relevant to be admissible during the trial. But you don't know those things, and you don't need to worry about those things. You ask your questions. If they are legally proper questions, I will ask them of the witness. The lawyers aren't going to know which one of you asked the question. The witness is certainly not going to know which one of you wrote the question down. I will ask the questions of the witness, and then the lawyers will have a chance to follow up. You should draw no conclusions from the fact that your question was not asked if your question is not submitted to a juror. Just know that it was not a legally proper question. That's it. But don't think, oh, what's the judge trying to hide? It's just, if the lawyer had tried to ask that question, the lawyer on the other side would have said objection, and I would have sustained. That's all it means if your question doesn't get asked. And keep in mind, questions are not evidence. It would be wrong to derive something from an unasked question anyway. Only the answers are evidence. It's important that you pay close attention to the testimony as it's happening, because again, we don't recall witnesses if during your deliberations you say, oh, could we get this witness back in here? We've got a few more questions, or we don't remember what she said about something. If at any point you need a break because we've been going too long or something is distracting you that you need to take care of, let me know. If at any point you cannot hear the witness, tell me and I'll get the witness to get right up to that microphone. And if there's something being played on a screen and you can't see it or hear it, let me know. Now, the screen stuff we can replay. And if videos are admitted, they will be part of evidence and you can review them again during your deliberations. In fact, you'll be the first jury to get to use our new setup. You may have seen that big screen in the jury room. That is for you to replay video evidence should you need to. Rather than have to trundle back out here and we play it in here and you don't get to talk while you're watching it. You'll be able to play it back in the jury room. So let me know if you need a break or you can't see or hear something. It's also important that you view the evidence with an open mind and resist the temptation to reach early conclusions. You may hear from two witnesses and say, I figured this one out, but you don't even know what the law is around trafficking cocaine and what the state has to prove. So keep an open mind. Also, do not begin your deliberations early. You're going to get lunch today. It's fine for you to eat as a group. You're not required to eat as a group, but some of you may have lunch together. Don't talk about the case. Talk about anything else. It's a pretty big universe. It's anything but the case. It would be inappropriate for you to start getting an impression or sharing an impression that you think the case is going well or not well. Internally, you're going to have that, but you don't share it until all of you have heard all the evidence, the closing arguments, and the law that I'm required to give you. It is important that in the same way you aren't talking with each other about the case, that you not get any outside input. When you go home tonight and someone says, hey, how was it? Tell them it was fine. Pick a one-word answer. Fine, great, super, maybe a few words, best day of my life. But don't go beyond that. Well-meaning people are going to say, well, wait, but did this happen? Let me tell you, I was a juror just last month. And when this happens, this is what it really means. Maybe, and maybe in that case, but not this case. You need to be in an information cocoon during this trial where what you get happens only here in court. So when the trial is all over and you've finished your deliberations and finished your service, you can talk to anyone you want. You can get online. If you're a vlogger, do your vlogging about it. You can write a book and sing a song. But before then, you need to be really boring with the outside world. Yes, I've got jury duty. I can't talk about it. Let's talk about something else. Can't talk about the Olympics anymore because they're over. Also, no outside research. The reason why you are empowered to ask questions of the witnesses who testify is to avoid the curse of Google. We have had to retry many cases because a curious juror said, hey, you know what I did last night is I got online and I looked up that apartment complex, the Millworks, and I got an aerial view and X and Y and Z. You have introduced outside information that may be inaccurate because that was a Google satellite photo from 15 years ago, or it's from today. And this case happened in 2021. The Millworks doesn't look now like it did then. If it's important for you to know what the apartment complex looks like, these lawyers can get pictures in front of you. But you should conduct no outside research. If you've got a question, you write it down, and if it's an appropriate question, it will get answered. But if it comes to light that a juror or jurors engaged in outside research, it will likely mean a mistrial. And if we figure out who the juror was, adverse consequences for that juror. I'll be reminding you every break, no outside research, and I really mean it. These are good lawyers. They're going to get in front of you the information they think you need, but you can supplement it by asking questions of witnesses. You may not supplement it by hitting your cell phone during a break or talking with someone outside the court. That is it, my friends. In a moment, we're going to hear from the lawyers. Just keep in mind, again, when you need a break, let me know. We typically take a morning break. We'll do that probably after a witness or two. We always take a lunch break, and there'll be an afternoon break as well, supplemented by any additional breaks you all need. When you are taking a break, you're free to use this whole hallway as long as you're quiet. There's actual sunlight at the end of the hallway, an elevator bank this way where you can see outdoors. As long as you don't need to be yelling into a phone, it's not a problem to spread out down that hallway. But I have colleagues and they'll come fuss at me if you guys are playing loud music outside their chambers, but you don't need to remain just in the jury room. Last thing, there are no assigned seats unless you need to be at it's my left, the far left of the jury box, because you might need to stand up to stretch a little bit. I strongly, strongly encourage you to pick a different seat when you come back in. You will have a different experience. The 6 of you are particularly close to witnesses and you're going to see it better. The 8 of you are further from witnesses, harder to see, maybe easier to see the screens. But if you really, really have a favorite seat, keep it. But otherwise, don't always take the far corner seat. Be in a different spot each time. Okay? Thank you for listening. Ms. Nix or Mr. Peoples, it is time for the state's opening.
Thank you, Judge. Morning, ladies and gentlemen. Happy Tuesday. As I said before, my name is Megan Nix. I'm an assistant district attorney here in Fulton County, and I'm the prosecutor in this case. This is a case against Emmanuel Tezera. He's charged with trafficking in heroin. Ladies and gentlemen, they caught him red-handed. This case started because the defendant and Cameron McCall got into a domestic dispute. They were fighting. Officers responded to a 911 call, and when they arrived, they found Mr. Tezera in the hallway with his stuff. He had an injury to his arm. He was bleeding. He bled on his arm, he bled on his hands. Folks, it's not disputed whether Ms. McCall and Mr. Tezera got into a fight. We're not here about that. They both got some good licks in, and we're not prosecuting either of them for this fight. What we are prosecuting Mr. Tezera for are the drugs that were found in his belongings that were in that hallway. Mr. Tezera, after this fight, he's injured, just been in a fight with a girl he was dating. He decides he's gonna leave. As he would, collects his stuff, starts putting it in the hallway, says, I'm out of here. His blood gets on some of these items. Officers arrive and they find him standing with these items. He says, yeah, these are mine. This is my stuff. EMS arrives, starts treating him. Officers arrive, start trying to figure out what's going on. When they arrive, they see someone that's been pretty seriously injured, who needs medical attention, who's telling them there's a fight. I'm not here with my stuff. I want to get treatment, and I want to leave the situation. Brady Hospital sends an ambulance, and the ambulance takes Mr. Tezera to the hospital. He can't bring his stuff with him. He's got too much stuff. Ambulance is small. Hospital doesn't have enough room for him to bring all of his stuff. So, as is their policy, when something is left, can't put it back into his apartment, Ms. McCall won't let him. Ms. McCall's taken to jail because of this fight. So there's just his stuff's in the hallway. Are we just gonna leave it there? No. It's gonna get stolen, right? So officers hold on to it for him. But because it's their policy, they have to look through it There's a number of different reasons for this. So that if Mr. Tezera comes to the police department to pick up his stuff, he says, hey, there was a PS5 in this, and it's not there, you guys stole it. The officers can say, nope, we looked through it, there was no PS5 in it, we inventoried everything that was there. And so we didn't steal your PS5, you're making that up. Also, officers want to make sure they're not accidentally bringing a bomb into the police department. Or something dangerous, firearm, a knife, something like that. Mr. Tezera said he's been stabbed, there's blood all over his stuff. Officers think there might be a weapon. Officers inventory his things, and they're expecting to find clothes, toiletries, other personal items. But they find something that they weren't expecting. They found nearly 300 grams of cocaine in his belongings. Belongings he said were his, the ones that had his blood on him, that had his blood on them, and belongings that he claimed. We expect Officer Foster to tell you he was inventorying these items, and he gets to a white bag. This white bag, I described as kind of one of those reusable grocery bags, and the handles are soaked in fresh blood, bright red blood, just like the defendant's hands had been soaked in his own bright red blood. And that's where they find nearly 300 grams of cocaine. The charges in this case, it's pretty simple. It's trafficking in cocaine. You might have an image in your mind of trafficking, meaning, let's go through a tunnel from Mexico into California. The law states, and Judge is gonna tell you this, he's gonna instruct you on what the law is, and it matters that the defendant was in possession of the drugs and that it was in a certain amount. In this case, the defendant was in possession of nearly 300 grams. For us to be able to prove trafficking, you need to prove that it was at least 200 grams. It's my job to show you, through the evidence that is presented, that Emmanuel Tezera unlawfully and knowingly was in possession of cocaine or a mixture of cocaine of a purity of at least 10%, and the weight of that mixture was 200 grams or more. We expect you to hear from Ms. McCall. She'll tell you that she and Mr. Tezera were in a fight, that they fought with each other, that she injured him. He ended up with a laceration cut that was bleeding. She'll tell you that he took his stuff out of her apartment, put it in the hallway. We hear from several officers, Officer Philemon and Investigator Skidmore. They're the first two officers on scene. They arrived with EMTs, EMS, and the EMS started to treat the injuries of Mr. Tezera. The officers got to work figuring out what happened. They arrived, they just see someone who's been injured. They gotta figure out what's going on. Make sure that if an arrest needs to be made, that one is made. You'll also hear from Officer Sook. He arrived on scene not long after Officers Philemon and Skidmore, and he locked down the scene, make sure that the people on scene are safe, make sure that nobody's messing with anything, make sure that if something happens, that someone is available to respond to it. You'll also hear from Officer Foster. Officer Foster was pretty new on the job. And when you're an officer that's pretty new on the job, sometimes you have to get the kind of boring work of inventorying people's property that they had to leave somewhere. Officer Foster wasn't expecting to find anything of note. He was expecting to find just personal belongings. He wasn't expecting to find nearly 300 grams of cocaine. You'll also hear from Summer Hutton. Ms. Hutton is a specialist. She is a forensic chemist with the Georgia Bureau of Investigations and the Department of Forensic Sciences. It's her job to test substances that come to her and determine what it is, what its purity is, and how much it weighs. She'll tell you that she received the substance that officers believe to be a controlled substance, to be cocaine. She tested it. She'll tell you how she tested it and what her methodology is, and that she determined that it was cocaine of a purity of more than 10% and in an amount of more than 200 grams. Mr. Peoples and I are going to ask you to do a couple of things for us. Please listen to the evidence as it's presented. Take notes if that's how you, if that helps you remember. Some people can just remember things. I can't keep anything in my brain, so I always take notes. And use your common sense. We ask jurors to come and make decisions like this because you all have common sense. You can look at the facts of this case and say, does it make sense that Mr. Tezera was in possession of these drugs that his blood was on? Folks, they caught him right-handed. Blood on his hands, blood on the bag that the drugs were in. Mr. Peoples and I will have the opportunity to address you again after you've heard all the evidence. And at that time, we're confident that you will agree that Mr. Tezera is guilty of trafficking in cocaine. Thank you for your attention this morning.
Thank you, Ms. Nix. Mr. Hirsch, are you going to give an opening at this time?
I will, Your Honor.
Your jury.
Thank you. Morning. There's a difference between having blood all over your hands because you've been stabbed, being the victim of a crime who calls 911, having the police ignore you, so you end up with blood, stab wounds, and red hands. Red hands from his blood because Cameron McCall stabbed him. There's a difference between that and how the state interprets that. The state interprets the blood on his hands as being caught red-handed. But like tons of facts in this case, they are simply mistaken. They are wrong. In just about every conceivable way, the Atlanta Police Department screws this case up. My client is staying at Cameron McCall's house. Cameron McCall is a biological male. She identifies as a woman. Her name is Miss McCall. I tell you that because in domestic violence situations, obvious one is going to come out, but also in domestic violence situations, a lot of times gender matters, or strength matters, or size matters. So Miss McCall is staying at her apartment. They've been dating for some period of time. They met at a club. He comes back from running an errand. She goes through his phone. She says, "Can I go through your phone?" He says, "Sure. Here's my passcode." She sees something, a text, which she interprets, she thinks means that he was cheating on her. Not particularly relevant whether she was right or wrong, but she was wrong. So she says, "Get your stuff, leave." So he's like, okay. He starts picking up his stuff. As he's picking up his stuff, she gets mad at him. At some point, she puts bleach on him, on his face. She stabs him with a knife. Not only does he say it, but he has a stab wound on his arm, and there's a knife. She takes a vase and smashes it over his head. He says that. She says that, and there's a knot on his head. And during this period of time where he's going back and forth, even after he's bleeding, he's all over the apartment. You can tell because there's blood all over the apartment. He's going back and forth, they're still talking. At some point, he restrains her, puts her in some sort of bear hug. She starts putting some, get out, okay, I'm leaving. She starts putting some stuff out into the hall. Some of it is his, some of it is hers. She knows the police are on the way. You will hear this from Mr. Tezera. It will be corroborated. Essentially, everything the defense tells you will be corroborated. And just about very little of what the state says will be corroborated. We don't have the verdict. It's not our job. But there is so much evidence here to show that my client is innocent, which is totally irrelevant. I'm not sure he's innocent. We just have to show he's not guilty. In other words, they can't meet their high burden of proof. They can't show beyond a reasonable doubt that he possessed those drugs. The police make mistake after mistake after mistake. They use bad judgment. And this is the point in opening statement where I get to tell you all the mistakes I expect you to see. But I'm not going to do that. Just do what the state asks you to do. Just listen. And the reason I'm not going to do it is because they don't even know the mistakes they've made. So they're going to find out on cross-examination when you all find out. I'm not going to tell them their own mistakes until I have them on the stand. I will tell you this. My client is epileptic. He gets seizures. There was a motion here in this case a few months ago, a hearing. The night before, he had a seizure. He gets seizures, it's well established. He tells the police that. He has seizure medication in his bag. Before going to Grady, they say, okay, grab your bag if you want, if you need something. So he goes to grab his seizure medication, his computer, and then the detective, I think Officer Skidmore's like, no, you can't take it. There's 6, 7 bags outside, some of which he put out there, some of which she put out there. She knows the police are coming. The bags that have his stuff are like book bags and like carrying bags. The bags where the alleged drugs, this white powdery substance is found, is just like in a white coat shopping bag. Is his blood on it? Yes, his blood's everywhere. His blood's on the door. He doesn't own the door. His blood's on the floor. He doesn't own the floor. His blood's on the counter. The evidence will show he doesn't own the counter. His blood's on the knife. The evidence will show that he doesn't own the knife. He tells the police, I need this because I have seizures. He does, in fact, get seizures because he's epileptic. And from that, the police conclude that everything out there is his, and he was taking the drugs. That's the totality of their investigation and evidence. Assumptions, conclusions, misinformation. And speaking of misinformation, there'll be some pieces of evidence missing in this case. I look forward to you hearing what they are. Thank you.
Thank you, Mr. Hirsch. Ms. Nix, if you call your first witness, please.
Yes, sir. State will call Officer Philemon.
Good morning, officer. If you'll come on up to the stand, please.
Raise your right hand. You swear or affirm that the testimony you will give will be true, the whole truth, and nothing but the truth, so help you God. Clearly, you have a seat. State and spell your name for the record.
Ludina Filemo, first name Ludena, last name Filemo, Philemond.
Good morning, Officer Philemon. Where are you employed?
City of Atlanta,
What is your position with the city of Atlanta?
police officer.
What do you do as a police officer?
Serve and protect.
What kind of ways do you serve and protect?
I enforce the law. I help people who's in need, can't help themselves.
Do you respond to 911 calls?
Yes, I do.
Were you working on the late evening of June 11th, 2021?
Yes, ma'am.
Did you respond to any calls?
Yes, I did.
Where was that? Where was that call that you responded to?
I believe it was at 188 Emory.
Is that in Fulton County?
Yes.
And what did you know before you arrived?
All I know was domestic, somebody was stabbed.
All right. Do you know how that call came in?
To the radio 911 dispatch.
So someone would have called 911 asking for help?
Yes.
Your Honor, may I approach the witness?
You may. Both you and Mr. Hirsch and Mr. Peoples may approach witnesses without asking. I'll just let you know if that is revoked.
Showing you what's been marked as State's Exhibit 1. Do you know what these two items are?
Yes, ma'am.
Can you tell the jury how you recognize them?
Well, this is a photocopy of my body cam, video of my body cam.
So let's talk about the sheet of paper. Do you recognize this?
Yes,
What is it?
it's concerning the body cam, copy of my body cam.
So is this a certification of a 911 call?
Yes,
Okay. And well, state will look to that State's Exhibit 1, which is the 911 call and the business record certification.
No objection.
Okay. You have a DVD in your hand. Is that part of one? Is that 1A or is that a different exhibit?
This is the CD with the 911 calls on it, and then the business record certification.
Are they both labeled 1?
They are labeled 1A.
What, or 1 and 1A? Just label them not identically, please. And then for the record, just state which is which.
Thank you, Judge.
Thank you.
Business record certification is State Exhibit 1 and State Exhibit 1A is the 911 calls. This one with the 911 calls.
Okay, so it's not body cam, it's a 911 call.
Yes, sir.
Okay. Do you have an exhibit list?
Yes.
We sent it, Your Honor. We forwarded it yesterday. I thought,
Okay, I'll look for it. You forwarded it to whom?
to the court.
Okay.
I thought I did.
If I get it, Mr. Hirsch, I'll send it to you as well. I don't remember seeing it, but I'll look, just so I can keep track of things. But there's no objection to 1 and 1A. They are both admitted. And you're free to publish whatever you want to publish from that.
Thank you.
I don't have an exhibit list, so if you could resend that and send it to Mr. Hirsch, that would be great. Please.
first one.
Yeah, first one.
Ellen and one operator 7943, what's the address of your emergency?
My phone is right now. I was in the phone with a lady already. I'm in 11888 Henry Street Northwest. Apartment 65, and I've been cut, I've been bleeding, and then I'm in my ex apartment, so yeah.
All right, hold on one second. This is the cab. Let me check.
Did you try sharing it through the Zoom rooms to see if it's louder? That sounds like you played it on your own speaker, which is fine. But if you are on this session, we can also try sending it, see if it plays through the larger speakers.
Yeah. 1 second, John.
Okay.
Always technical difficulties.
Always.
What is the beer emergency? We need one second, let me find my location. I'm sorry. Let me find my location, but I don't know where I am. Okay. I just stayed here for 3-4 days. That's your man. Hey Siri, what's my current location? I'm in the apartment. Are you where, sir? I'm in the apartment. I'm in my ex-apartment. My ex-girlfriend's apartment. Okay, what's this guy in the fight? And she stabbed me, cut my hand, all that shit. And my hand is bleeding very much. So you been stabbed, sir? Yes, ma'am. I've been stabbed. Okay, what's the okay, what's the name of the complex? And she put a grease on my face and all that. Okay, sir, listen to me. Sir, what's the name of the complex? Give me 1 second, let me try to find out a complex. I was there for like a month or 2, so I literally just working on a relationship. So give me 1 second. Okay. Okay, can you ask someone the address of the name of the complex, sir? Give me 1 second. I got not somebody to Hey, bro, you have a gentleman that's sad, but he's trying to locate his address. He's at an apartment, he's trying to have someone the address. give me 1 second, man, I'm trying to find it. I'm in, it's near the, what's it called, road, Emery Street Northwest. It's like close to budget. It's like, near to the, what's it called, the highest, street. The highest place.
Rectangular complex in time period?
No, it's close to the street. The complex, I don't know about her. But the other,
Okay, so what's the place that you're telling me the higher place? What is that?
yeah, the highest, it's a hotel, highest place.
Oh, higher place.
Yes. It's 188 Emery Street Northwest.
Okay. 188 Emery Street Northwest. Atlanta, are you that's a lot?
Okay, that's the Halifax number. It's 188 Emery Street Northwest.
The Emory that you're speaking of is
E-R-Y.
M-R-Y.
E-R-Y Street Northwest.
So 88 Emory Street?
Yes.
Okay, so it looks like that's still working.
And we need like face right after she's stabbing, come on and so we come on.
Okay, Millwork apartment. What apartment are you in, sir? Hello? Hello, sir? Okay, Atlanta, are you there?
Yes, I'm still here.
Okay, did we lose him? It doesn't look like he disconnected the line. So he said something about him being stabbed in his face and where?
She was stabbed face to face by a girlfriend.
You got a name for him?
No, man, we were trying to get the address.
What's our operator? 7320, you are? 7320,
Okay.
you have police and fire?
Yes, ma'am.
And Rob?
Yes, ma'am.
Okay, and I'm gonna try to give him a call back.
Okay. Okay, all right, thank you.
All right, thank you.
Bye-bye.
Go ahead and, 143, will that is your emergency?
Hello, my phone just turned off. I was in the phone with that lady already. I'm in 1888 Emery Street Northwest, apartment 265, and I've been cut, I've been bleeding, and this, I'm in my ex apartment, so yeah.
All right, hold on 1 second, this is the decab, let me transfer. The captain, emergency 911, what is the emergency? Hi, decab, this is the possible transfer. Address is going to be 1888 Emory Road, Northeast, that's 1888 Emory Road, Northeast. One. Down area? EMORY.
No, it's E-M, like S Tezera Street, Northwest. And apartment number 265.
I'm showing that to be an admin, sir. Okay, we can handle it, thank you. All right, Oliver.
Yes.
Hold on, all right, I have 188 Emory Street Northwest.
Yes, ma'am.
All right, and what is this in reference to?
My ex-girlfriend, she just called me, like I'm bleeding like crazy. She stabbed me on my hand, and it's like bleeding like crazy. So yeah.
Okay, yeah, I see that we already have a call in for this. Did you call in previously?
Yeah, but the phone got cut, so it doesn't have signal under this apartment.
Yeah, I wanted to update the apartment number.
Yeah, because I'm bleeding. Yeah, it's 265. I'm bleeding like crazy.
All right, I'll go ahead and update the call. And Grady should be en route, so just wait for Grady. They've already been dispatched, so I'll go ahead and update the call with the apartment number.
Okay, can you tell them to come fast? Cause I have my stuff outside and all that shit, and I've been cut down bleeding like crazy, so I don't know. And she put bleach on my face, so I'm trying to get some of that help to actually like.
All right, hold on, I'll call Grady. We can go ahead and update the address.
All right.
This is the last return call.
Can you call?
1888 Emory, E-M-E-R-Y Street Northwest. Okay, yeah, so I just wanted to add that that's going to be apartment 265. I don't think that was included in the original call. You're welcome.
Yes, sir.
Okay, so I did update the apartment number, so Grady is en route to you, and they have updated information.
All right. And can you tell them I stayed in this apartment for a month and literally, like, you have put my name on it, I know that Georgia, and say, like, I was supposed to get the eviction notice, so I didn't get no eviction notice or anything to leave my house. You know what I'm saying? She just told me to take, I did take all my stuff, and she started fighting me, she stabbed me, all that. So I just need attention, I just need to, girls to go just that's it.
All right, so yeah, I will update all of that information.
Okay.
All right.
Officer Dillon, we heard some discussion on that 911 call about whether this occurred in Fulton County or DeKalb County. Was this in Fulton County?
Yes, ma'am.
So you respond to this 911 call. What happens when you first arrive?
When I arrived, I saw him in the hallway with no shirt on. He had pants on, and he's bleeding.
Okay. Was he in the hallway alone?
Yes, he was.
Was there anything else in the hallway?
There were a bunch of belongings on the floor, which he later told me that those were his belongings.
I'm sorry, Your Honor, I can't hear.
Yeah, if you don't mind leaning into the microphone, please. You can keep your hands in your vest if you want, but I need you to be near the microphone. Thank you.
Can you repeat about what you said about the things that were in the hallway?
Yes, when I approached him, he was alone in the hallway, but there were things on the hallway who he later told me they were his property in the hallway.
At that point, what were you doing?
I told him to step to the side because he told us which apartment the person who had stabbed him was in. So we told him to step to the side, and then we knock on the door for the person to come out. Once we knocked, the person came out of the apartment. I detained her.
Okay. And at this point, are you investigating? Are you trying to figure out what's going on? What are you doing?
It was me and an investigator, Skidmore, on the scene. I detained the suspect at the time, the person I believe to be the suspect.
Who's the suspect?
Miss McCall.
Okay. Why was she the suspect?
Because he told me that his girlfriend, Mr. Ten, told me that his girlfriend had stabbed him.
Okay. The person that you saw in the hallway when you responded to this call, is he in the courtroom?
Yes, ma'am.
Can you point him out for the jury?
Sitting right over there.
Can you describe what he's wearing?
Yes, he has no glasses. He has a blue, grayish suit, white shirt, burgundy tie, mustache.
Let the record reflect that witness has identified the defendant, Emmanuel Tezera.
She has.
All right. So you stated that you detained a suspect, and that was Miss McCall.
Yes.
Was there, who did you think she was, or what did you think she was a suspect of?
Well, according to Mr.
Tezera,
he told me that his girlfriend stabbed him, and that was his girlfriend who came out.
Okay. What were you concerned about at that time?
Well, after I detained Miss McCall, I was more concerned about Mr. Tin's safety, and I wanted him to get medical help.
Okay. Was anyone else on scene with you? You stated Investigator Skidmore was there. Was anyone else there with you?
Yes, when I arrived with Investigator Skidmore and the fire department, EMS. So.
What did EMS start doing when they arrived?
Render aid.
When you say render aid, tell us what you mean by that.
Well, they were tending to Mr. Tanzier's injuries.
Okay. What happened next?
After I don't know how long, but I went to tend to him. Grady came on scene. Once Grady came on scene, they said that they had to go with him. Mr. Tezera.
Grady said who had to go with them?
Mr. Tezera.
Mr. Tezera?
Yes.
Okay. Why did they say that?
Well, for whatever medical reason, I guess he had to go.
Okay. Because of his injuries?
Yes. Okay. So, but he told me that the things in the hallway belongs to him. Those are his property. But he was more concerned about his property in the hallway than him getting medical help. So he told me that his father was gonna come get the things in the hallway. And then he made a phone call to his father for him to come get the things, but he told me his father was in the shower. Then I said,
Objection, Your Honor. This goes beyond the scope of your ruling, as far as I can tell. Hearsay.
Okay.
Did anyone else show up in order to collect those belongings?
not while I was on scene.
When did you leave the scene?
I don't know how long I was there, but I left with Grady to go to the hospital. I can't tell you how long I was on scene before I left, but I was there for
But when
30 minutes or over.
when Mr. Tezera left with Grady, you left at that time.
Yes,
Did you go on the ambulance with him, or you followed the
I
ambulance?
followed the ambulance.
Showing you what's been marked as State's Exhibit 2. You recognize this disc?
Yes, ma'am.
Do you know what's on it?
Yes, it's a copy of my body camera video.
Have you reviewed your body camera, what's on that disc?
Yes, ma'am. My initials on it.
So you notated here on the disc that you reviewed it by your initials?
Yes.
What is a body
Body camera is this thing on my chest right now. It records when we receive a call, we press it so it record. It's a video recording of when we receive a call to them until the call ended. It's a video of everything that happened while we on scene.
And on June 11th, 2021, did you activate your body camera?
Yes, I did.
And how is your body camera, the video that it records, how is it saved?
Well, there is it automatically saved, and you just have to go and categorize it, saying with the case number, which usually that's how you categorize it, with the case number. And if it's we use numbers for signal, which is let's say if it's a fight, you put 29, which considering as a fight, or whatever it call you responded to, and you put it there. And if you did investigation, you put investigation. If you write a report, if you make an arrest, you put that down on the.
So when you respond to a call, is a case number assigned to that call?
Yes.
Okay. Is your body cam associated with that case number?
Yes.
Is it possible for you, either while you're wearing it or while it's still saved on your body cam, is it possible for you to amend or change anything that's on your body camera?
No.
After it gets uploaded and saved under that case number, is it possible for you to alter or amend the video that's saved?
No.
And you already say that on this disc is your body camera from June 11th, 2021?
Yeah.
When you responded to 1888 Emory Street Northwest?
Yes, ma'am.
It's in that state exhibit 2.
Any objection to states 2?
No objection, subject to your ruling.
Okay, it's admitted.
Permission to publish?
Yes, I don't know how long that is, and if you're going to skip around just so the jurors aren't surprised, maybe you're just press and play from the very beginning, but if there's lots of dead time, do you plan on jumping around, or what's your vision?
I plan on starting it at the relevant portion and then until it's
18 minutes, 40 seconds.
yes, and then until it's, I guess until she leaves the scene.
Okay, about how long is that? I'm just thinking about when we're gonna take our break.
I think it's about 30 minutes.
Okay, you all want to take your morning break before we have 30 minutes of body cam or after? Everyone good? After, I'm hearing after. We're feeling the power to get through it? Okay, if during the middle of it you need a break, let me know. Mr. Hirsch. Here for a second. This is the exhibit list. Mhm.
All right, for the record, we're going to start State's Exhibit 2 at 18 minutes and 24 seconds.
All right, before you press play, Officer Philemon, do you know either of the people on the screen there? Just orient us.
Well,
Is it not on your screen?
yes.
Just click stay muted.
Okay.
All right. So we got someone in a pink shirt and someone that says police.
Okay. The person in the police shirt is Investigator Skidmore. The gentleman in the pink shirt was the person who was directing us how to get to where we were going. So we then couldn't find the apartment, so we were asking for help. He was helping us to find out where we were going.
Not Mr. Tezera, not the person, not Ms. McCall.
No.
Okay.
Yes, sir. Shit, my was fire. So I had an argument with my ex. Yes, sir. I ain't even let go. I didn't let go. Yes, sir. Separate. Yes, sir. Yes, sir.
Have police open the door. Oh, watch the blind out here. Open the door, please.
Yes. Come outside, please. Come outside. I don't have that. Come outside. Come outside. This is the wall. I don't recall the police there. They're trying to go down. You don't like that? I have the camera. Who else is that? The agent came to make sure I'm okay, but I had to call them while he was choking me and pulling my hair out. Okay? Now you don't want to.
Stay right there for a second.
Now the police already had me on video. So I don't know. Oh, she said and I didn't have because you were putting your hands on me. You sound stupid. I have you on camera. On the bed on camera. You just pulled my whole hair out. Please tell him why you he was angry. I'm getting in trouble because he was saying for me. I hit him with the base of the story. He was on the base of the floor. That's how you see. Now I'm in trouble. I know what I'm trying to rip out the base and fall my house. I'm right there. He takes it for my back door. No, that's his. That's his. I have to protect myself. Yes. I'm fine. I'm just upset.
But exit to the road is the only way, is back this way and up the steps where the game, or is there another direction?
Sorry, I'm gonna
Deposit 2153. Who are we seeing right now in this video? Who's that talking?
That's fire, EMS fire.
Okay, and who was talking before the person that you put into custody?
Who was,
Yes, who was the person that was yelling? The person you just took into custody?
Miss McCall?
And what you're calling fire, that's different from Grady.
Yes.
Okay.
Okay, like I said, sir.
I don't know, I'm not sure, so I'm talking to you today. Now I'm saying it's okay, you know what?
Okay, we're getting now.
It's maybe another warning, the first time, right? No, because I'm mad, and I'm in trouble, like, you don't know that, you don't know that, you don't know that, you want this to go, chill out.
Excuse me. I'm trying to.
Okay, walk this way, and the very last left, we get an elite point, push your 20 button that says push the exit. You can go out there and
Right, who is that in the white t-shirt?
Associate of Miss McCall. I don't know. I never identified her. I don't know who she is. Associate of Miss McCall, because I don't know who she is. I never identified her.
Was she on scene when you arrived?
She was inside of the apartment. She came out later on.
This is a question that I need to, this is a question that I need to ask, and it's for Brady that's coming. What's the best direction for them? Is there a?
I don't let you hear you with my phone, that's what I'm saying. If they wanna come to the meeting and then you have to go walk in there.
Okay.
That's the way it's
All this that. So this way.
Yes, all the way to the panel. And that's, and when you put up that pineapple, it's a black thing. Just put the button and open it.
You need to write my phone number down? Cause they
What's
say
up,
you not.
Yeah, can you get my phone, my purse and stuff, and off my house, my keys?
Once I go through that gate, where do I go from there?
No, they don't have no warrant on my house, lock my door, my street.
Once I go through
They
that
get a
gate.
warrant, they can go in there.
Once
It's
I
so many for all.
Once I go through that gate.
It's on my car keys and my and my little purse. You ask me questions, you better ask me. You have to keep all the black things. Yeah, that's all you need. And y'all sometimes, it should be in the kitchen, if not the bathroom.
All right, so this is a pretty chaotic scene. What are the residents, Atlanta Fire?
Yeah, but yes,
Okay, what are they doing in a little further down the hallway with the defendant?
attending to his wounds, to his injuries.
I'm not ready.
I'm trying to confirm what you said. Once we go through the gate.
And you just pick the bus. Oh, he needs to be keeping his hands, I have no video, I'm personally hard. So, I'm like, he's a
I'm not talking about that. I am talking about Brady EMS that's coming here.
They only have to look at that gate, that's it.
Excuse me, I'm just trying to confirm. That's all I'm trying to do. You said go through the gate. Once I go through the gate, am I outside or what?
He's money, because you don't have any records or anything. So he
All right, I see you talking to another officer. Who is that?
Officer Sue.
Right. I'm gonna just scan forward just a little bit so that we can.
That's fine for the purpose of the record. Maybe I'm being overly tactical. Should you say when she stops and moves on?
It's just easier that way. So where is it that you stopped?
I stopped at minute 24:59 seconds.
Okay.
Okay. Sorry, I hate to be nitpicky. There's a timer up top on the right-hand side of accident, and then there is one on the bottom to show how far we are along. It's 24:59 on the bottom left.
Correct. All the numbers that Ms. Nix has been citing to, for the record, are from the counter from the media player and not anything on the Axon date timestamp for the purposes of the record.
I skip forward to minute 26:47 on the bottom left.
Yeah, I was understanding.
So I'm gonna follow right there, I'm following directions, he said, I'm gonna go ahead and see my phone, right?
Which hospital? I called my dad. Do you live here? Do you live here? Okay. Oh, was it? Is there another way to go on? Yeah. Anything critical Wi-Fi needs? No, this is not right now, the way I'm saying right now, I mean, it's exactly what I saw. They said that was a regular on scene. And then you got something there. Oh, easy. Is that where it was? Yeah. Okay. Oh, I was not looking that hard. I was not looking that hard. I saw the blue house. Yeah,
Stopping at 2942. Officer Philman, what are you doing right here?
I didn't have gloves on when I was holding Miss McCauley, so I wanted, just in case I got any blood in my hand, I wanted to wash it off.
Was Miss McCall bleeding?
No, but there was blood on her clothing.
And who was bleeding on scene?
Mr. Tenzin.
I got no room. I need something to draw my hand. You don't like that? Oh, no. Yeah.
Okay, I'm pausing at 32 minutes and 50 seconds. We see another person that's on scene in this hallway now that's not APD or Atlanta Fire. Do you know who that is?
Whoever was in the apartment. Don't know who they are.
Okay, so now you've asked the defendant to come over and talk to you, and he's concerned about his stuff.
Yes.
Okay.
Crazy, wavy and stuff. Where you go there? Where you guys go there? You go straight? Where you guys go there? Nope.
All right, the folks that just arrived in the gray uniforms, who is that?
That's Grady EMS. Grady EMS.
All right, the stuff that you referred to when you said that's your stuff right there, what was the stuff that you were referring to?
The property that was in the hallway.
And the defendant said, yeah, that's my stuff.
Yes.
But I paused it at 34 minutes and 50 seconds.
You cannot be started in a camera scene with all.
Yes, you know.
So how far is your drive?
I got it. Let me answer them for you.
What's up?
Who are these people that just came through the crime scene?
Resident that who live down there.
In the shower? You got it. Grab one bag, whatever the most valuable they want.
laptop, yeah.
No, you, Grady said you can take it whatever the most valuable you want.
Our kids are saying, where's that?
Okay.
You're gonna go Grady, the kids are saying right there, it's hard to find, so you have to be.
Okay, sir. You can go.
Who's going with them?
I'm not going.
You're going with them. Stop touching stuff. It's part of the crime scene. You can go to jail too. She's going with you, Grady.
Okay, sir.
Don't touch it.
Okay, I'm stopping at 3717. What was he reaching for in those belongings?
So I told him that he could grab a bag because Grady advised me that he could take whatever most important or valuable to him. So I told him he could grab a bag and put whatever most valuable and important to him, he could take them with.
Why was he only gonna be able to bring a small amount of his belongings with him?
Because all his property would not be able to fit on the ambulance.
And the person that said, no, this is a crime scene, you need to leave it, that was, who was that?
Investigator, his name just skipped my head right now.
That Investigator Skidmore?
Skidmore.
Sorry. I'm showing you what's been marked as State's Exhibit 3. Do you recognize this photo?
Yes, ma'am.
What is it?
This is Mr. Tenzina and Investigator Skidmore.
Is that a screenshot from the body camera you just watched?
Yes.
Exhibit State's Exhibit 3.
Do you have a bunch you're going to be doing the very same thing?
These are different photos. I'll do them all at the same time. This is the only screenshot.
Okay, so the rest will be in bulk. You're not going to go one after another. Okay, any objection to states 3?
No, Your Honor.
It's admitted.
All right, I'm showing you what's been marked as State's Exhibits 4 through 11. We look through these photos and tell me if you recognize what's depicted in them.
This is the apartment we responded to. This is a rain door camera. That's the property that was outside in the hallway. Properties that are outside in the hallway. Property that was outside in the hallway. Property that was outside in the hallway. Property that was outside in the hallway. And bloodstain and half of the property that was outside in the hallway.
These photos fairly and accurately reflect what you observed on the night of June 11th,
Yes, ma'am.
2021, when you responded to this 911 call.
Yes, ma'am.
Has it been altered or amended in any way?
No, ma'am.
Statements in that State's Exhibits 4 through 11.
Any objection to 4 through 11?
No.
Admitted.
State's Exhibits 3 through, we'll start with 3.
If it's admitted, you're free to publish it.
This is State's Exhibit 3. It's a little difficult to see because of the darkness, but is this the screenshot from your body cam that you looked at a second ago?
Yes, ma'am.
And the defendant, is that who is depicted in this photo?
Yes, ma'am.
What's on his hands?
Blood,
And what color is it?
red.
Does that mean that it's fresh blood?
Yes, it was bleeding. Yes,
I can't hear the answer.
yes.
We move to State's Exhibits 4 through 11.
No, Judge, sorry. Pass that.
Okay. We're good. Whatever you want to publish, you can publish.
Right, is this the door of the apartment that you responded to?
Yes, ma'am.
What do we see on while looking at it, the left-hand side? Is there a stain?
There's a blood stain on the left-hand side.
And for the record, I'm showing you State Exhibit 4.
So your screen can be a touch screen. If you tap your screen for a second, see a little circle in the lower left-hand corner that looks like a pencil?
Yes,
Tap the circle with it, no, lower left-hand corner, lower left-hand corner. See that circle with the pencil?
right. There's a pencil right
Did
there.
it go away?
No,
Okay, maybe that'll make it work, but you should be able to draw. It working?
yes.
All right.
Okay.
What is that stain?
Blood,
What's the apartment number?
6'5".
And what do you see on the door? Is that a ring camera?
Yes, ma'am.
Let's go to State's Exhibit number 5.
If you'll hit, there's a icon on the left that looks like a arrow going counterclockwise. That'll erase what you drew.
Is this a close-up of that same photo that we just looked at?
Yes,
We can see the red stain on the left-hand side again.
yes.
Let's move on to State's Exhibit 6.
I want to erase your things. There's a list of, is one of those an arrow that's sort of going backwards?
That one right here?
Yeah, tap that and see if does that, and one more time. There, thank you.
All right, we're looking at State's Exhibit 6. What do you see depicted in this photo?
Properties. There's a backpack, jacket, and a computer device.
And State's Exhibit 7? Is that the same property?
Yes,
Okay. Is that the property that the defendant claimed to be his?
yes.
On that green bag, what is that stain on the green bag?
Appears to be blood.
State's Exhibit 8. Is this more of the property that the defendant claimed?
Yes, ma'am.
State's Exhibit 9. Is this just another angle of the property that the defendant claimed?
Yes, ma'am.
State's Exhibit 10. What is this? What do we see here in State Exhibit 10?
Property, his property, and blood stain on the floor.
And Safety Exhibit 11.
Question.
Was there anyone else on scene that you observed to be bleeding?
No.
And the other people that we saw on scene, there were some people that walked through the hallway. There were some people that were in the apartment with Ms. McCall. Did any of those people touch any of the defendant's belongings? that you
No.
can see? Sir, can you answer?
No.
All right. Nothing further, subject to redirect.
Okay, ladies and gentlemen, before cross-examination, if there is, no burden, but there may be, we're going to take a quick morning break. We have to break for lunch at 12:30 because of the meeting I have to run. So if we wait till cross, we may just not have a morning break, but I want to give you that. But we'll keep it short. It's usually about 10 minutes, but I want to make sure we finish with Officer Philemon before we do break. So this is your first break. It's fine to talk with each other. Don't talk about the case. Talk about anything else. Feel free to use that hallway. Restrooms are yours, etc. We're going to corral you sooner than I normally would, probably about 5-6 minutes for this break. Your afternoon break will be longer, meaning the one you have after lunch. Okay, thank you.
All right, sure.
Sure.
Did you ask us to leave these?
You can do either way. You can leave them in your chair or take them with you. Ms. Nix, anything before we have our quick break?
Yes, sir.
Mr. Peoples?
Yes, Your Honor. You'll have Rick's come in. Your Honor, we'll have our investigator come in. If we could just take up a quick matter outside the presence of the witness as well.
Sure. Officer, if you don't mind stepping outside, we'll get you back in here after the break. Don't go too far. While we're waiting, Mr. Hurst, do you have anything you want to bring up before we take our break? Because we're using up your break right now. No? Mr. Peoples, why don't you, I know we're waiting on someone, why don't you share with me and Mr. Hurst together what the concern is?
So the concern, Your Honor, is that the Cameron McCall, who is one of the state's witnesses, who is the former paramour of the defendant, was contacted by defense counsel, as is their right to do so. However, the understanding is that she potentially felt a little bit coerced by some of the statements made by defense counsel. My understanding is something to the effect of, you don't want the defendant to get 15 years if he loses. Do you forgive him? All of those to the effect. We want to make sure that we bring that information to the attention of the court and let the court do as they will with that information. The state is, however, was concerned because it rose to the level that the witness felt compelled to let us know.
Okay, couple questions. You're not concerned about Ms. McCall not appearing?
No, she's here.
Okay, so she's still willing to go forward with her testimony?
Yes, Your Honor.
Okay. any reason you feel you wouldn't be allowed to explore that with Ms. McCall on direct exam or possibly redirect?
No, Your Honor, not at all. We just wanted to make sure that the court was aware and that we were able to explore that information.
Okay. And last question, then I'll hear from Mr. Hirsch. Did Ms. McCall say that these questions or statements came from Mr. Hirsch or someone associated with the defense, i.e. an investigator?
Our investigator spoke with him. 1 second.
Okay.
What she indicated, she believed it was Mr. Hirsch, I'm not sure if she knew who she was speaking with, as defense counsel.
Okay, this was a telephone contact. Okay, all right, I appreciate you sharing that. Mr. Hirsch, tell me your version of events, and if you think there is any issue with what we just heard, and then third, if there's any reason why the state wouldn't be entitled to explore that during direct or redirect.
When did she testify? Is it after lunch?
Yeah, we could take it up after lunch if, is she, great question, when is she testifying?
After lunch, Your Honor, we're going to take up Summer Hutton before lunch.
Okay, but I'd like to get your side of things, at least so I'm thinking about it in the interim.
Your Honor, I contacted her. I asked her a little bit about the case. She was cooperative. I told her that I represented Emmanuel Tezera. I spoke with her as if I was being recorded. I followed up with an email. I did let her know the statutory minimum for this in principle, because I believe when she testified, she could have been charged with this. And I'd like to get into it with her for bias, that she has a bias to be here, in which case the maximum and the minimum would be I'd be able to ask her about it. Obviously, I shouldn't say obviously. Prior to doing so, I was planning to have a motion outside the presence of the jury, but if the court disagrees with me, obviously that's a big deal. So I made sure she do all that. I mean, I can recount parts of the conversation if necessary. And like I said, I did follow up with an email.
Okay. Well, State, you should be thinking about a response to Mr. Hirsch's request that he's made it on the record, but we'll revisit it before Ms. McCall testifies, that he, Mr. Hirsch, be allowed to explore with Ms. McCall her understanding of the sentencing range for trafficking in cocaine, because there is a defense theory that she was somehow potentially charged. She could have been charged for the drugs as well. So you don't need to respond now. You can be thinking about it. My recollection is that she was in fact charged with aggravated assault, something in connection with the injuries Mr. Tezera sustained, but those charges were dismissed years ago, not on the eve of her testimony today, but long ago. That case was declined or dismissed by the state. But I don't ever recall there being a set of charges through a warrant or anything like that in connection with the drugs. But you're going to need to respond to Mr. Hirsch's angle. I get it. Hadn't thought about it that way. And I don't have a clear sense of how I'd rule on that yet. I need to think about it a little bit, but I'll certainly want to hear from the state if they think that Mr. Hirsch ought not to get into it. Ostensibly it's for bias, but obviously it lets the jury know what penalties Mr. Tezera might face, and that's not anything that they ought to concern themselves with. But that is a legitimate way to get it in front of the jury if in fact, not that he can argue it in closing, but if in fact it's a valid avenue to explore bias with Ms. McCall.
Yes, sir.
Did you want to add anything?
I did, Your Honor. I think I filed a motion to produce all information regarding that ag battery. When I look it up, it just says arrested for ag battery, then I can't find anything else. Given that, I don't know if it's out there, I don't know if it's been dismissed and expunged, but there should be some paperwork. I would ask the district attorney's office to produce that paperwork.
Okay. I can't speak to paperwork, but I remember looking in Odyssey and finding the dead end of the McCall charges. It was a CP case and never, meaning there were warrants, there was a complaint, but it never moved beyond that. And I don't know that there's ever anything paperwork filed. Outside the presence of the jury, we can talk about this. but it was either NPGJ, not presented to the grand jury, or something to that effect. I just don't know that there's a paper trail for that as opposed to a digital trail, which.
Digital is fine too.
Okay, well, we'll get that answer. I don't know that there's anything to hand to you, but there at least could be an explanation so you're not flying blind in that space. Okay?
Should I give while we're on it, I suppose. Under the same vein that I'd be able to question her for bias. I also think it's relevant that at the time of the incident, I'm saying that part of the defense theory is that she didn't want to go to jail. I think there would be some evidence of that. She told the police some things that aren't true. Also, of course, these drugs, which are hers, could have been found. And she had an additional incentive not to go to jail, other than no one wants to go to jail, which is that at the time she was a fugitive from justice for the offenses of assault and possession of a weapon out of Virginia. So I think that's relevant too.
Okay. Got it.
Would anyone like the state to respond?
Not yet. We'll talk about that probably when we return from lunch. I want to make sure we get Ms. Hutton in before, because we have to stop at 12:30. Okay. So I'm actually going to stay right here. If you need a restroom break, go take that restroom break. When you come back, we're bringing the jurors in.
Can I actually run down to the cafeteria, get some water and a Red Bull? I'll be back in 4 minutes.
If you make it 3, that's great.
And for Ms. Sutton, I'm not trying to make things difficult. I'll stipulate to, the videos and stuff. I am going to get challenged to the chain of custody, so I just want to let the state be aware of that since we're calling her out of order.
Oh, well, you go get your drink. Are we going to have to pause Philemon to get Hutton on the stand? If she needs to go before lunch, then I don't know how long the cross is going to be of Philemon. But we've got less than an hour before we have to break for lunch.
What time is it right now?
11:30.
11:30. I think it's possible. I mean, I guess it would depend upon what cross looks like, but our direction is pretty straightforward.
Okay, how long do you envision your cross of Philemon to be?
Not super long, 10 minutes.
Okay, then just go get your beverages and we'll get started.
Thank you.
I said I wasn't going to go away, but I got to go do one quick thing. In that side room.
Oh. It's cool. I've got a jacket on, but I'm freezing.
Keeps you up.
All right, I'm joining the Zoom. Better late than never.
Yes, please. Let's get rolling. I hope we can fit Hutton in. Here they come.
You printed that?
Yeah, I sent it to a printer. I haven't like.
All right. Ms. Nix, Mr. Peoples, anything before we bring the jurors back in?
Nothing, Your Honor, just,
we're tabling for now, you all have rightly put a lot on the table about McCall. And we'll close that loop, before she's called to testify, but that'll be after lunch.
Understood.
If there's nothing else, let's get Officer Philemon back in here.
If I want to use, sorry.
Someone needs to mute, Mr. Hirsch, you need to mute I can do that for you. Done. Okay.
If I want to play what's been in evidence, do you want me to do it from your computer or do you want to give it to me?
It's,
Either it's at the pier.
She can come on in. Thank you.
I'm gonna just pull it up here or. Okay. Do you know from where? What minute mark?
I recommend we do it through Mr. Peoples' machine. Mr. Hirsch.
Yes.
I recommend we do it through Mr. Peoples' machine because it worked.
Yeah,
I bet you've got a great computer too, but
No.
if we get one that works, let's use it. So you'll just need to guide him to where you want it to be and he'll get to 2409 or all the spots you want. Okay? Can we bring the jury in or do you need him? Well, why don't you let him know where you want it teed up?
3552.
We good?
Yes.
All right, let's bring the jurors in, please. And officer, if you stay close to that microphone, you're good at leaning back and tucking your hands in, you're best.
All right, the jurors. Jurors are present in the county court.
Thank Thank you, Deputy Gordon. Everyone can be seated. Welcome back, ladies and gentlemen. It took a little longer than I had forecast because something came up that we talked about while you were on the break. Give you a B-ish for changing seats. Good to rotate. We still have Officer Philemon under oath on the stand. It is time for cross-examination. Mr. Hirsch.
Thank you. Officer, I'm just going to play what was played before, but I want to do it on the big screen so that you can see the bottom as well.
Starts at 34, 36.
Can you pause for a sec? All right, we're at 3443 on State's Exhibit
2, Your Honor.
2. All right, play away.
You ready? Yes, please.
So I need them to see the full screen. Oh, okay.
Oh, that's your stuff right there? You can't have these stuff in the ambulance anyway, so.
Yeah.
So how far is your dad?
My dad, let me ask you one thing.
All right, so
He's in the shower? He got it.
okay, so you heard him say, that's my stuff right there. Is that correct? Did you hear that?
Yes, ma'am.
All right.
Yes, sir.
And that was about 3457 into the video, the body cam.
Yes.
And when you're saying that he claims his stuff, is that the manner in which he did it? He says, that's my stuff right there?
Yes.
There was no elaboration on it, is that right?
Just say that's his stuff right there.
All right, and when he says it, he is how far down from where the bags are out in the hall?
Not that far. You turn around, you could see him,
Yeah, no, I know you can see it, about 40 feet.
I guess. Not sure.
And was there any other conversation about what bags there were his, if whether it was 1, 2, or all of them?
All of them.
And because he said, that's my stuff, you're saying that means it was all of them?
He didn't say the bag was his stuff, this bag. He said, that's my stuff.
Okay. Now, do you recall previously being here regarding a motion, probably a couple months ago?
Yes.
All right. And the judge asked you a similar question and you said he didn't specify which of the items were his. Do you recall that?
Yes.
Okay. So, all right, I think we're in agreement. The totality of what he says is that's my stuff, right?
Yes.
All right.
I'll say here, this is a person that I got your laptop, you know, this is important.
Yes. Grab one bag, whatever the most valuable they come.
You see this? My laptop? Yeah. Sometimes I
You put that on. No, Grady's taking him, taking whatever the most valuable.
I guess I say, where's that?
Okay.
You're gonna go to see you after the meeting.
Okay, everybody, my laptop here.
Put it down.
Okay, sir. You can go.
Who's going with it?
I'm not going.
You're going with it.
Okay, then I close my mouth.
Stop touching stuff.
Hi, sir.
That's part of the crime scene. You can go to jail too. She's going with you drink.
Okay, sir.
Okay, so he goes, you tell him he can take one bag, the bag that's most valuable to him, correct?
Grady said he could take whatever most valuable to him. So grab a bag, put the most valuable things to you in that bag.
All right, and you relay that message to him, and he goes, what bag does he grab?
He grabs multicolor bag.
Multicolored bag.
There's white in it.
There. And when he grabs it, what do you see him take out of it, if anything?
He opened the bag. He pulled out something that looks like a laptop or computer or whatever, and some electronic thing. Try to stuff it in it.
Okay. He opens the bag so people on the outside can see into it, is that right?
I was not able to see inside of the bag, and I was right next to him. I don't.
Okay. He opens the bag so that if someone went to look, they could see into it. He didn't conceal it, is that fair?
He did not conceal the bag. He opened it.
And do you know what bag, if from your personal knowledge, not that you were told, do you know what bag alleged drugs were found in?
I have no idea.
Okay. Do you know whether it was that bag or not?
I have no idea.
And I'm gonna show you what's been marked as State's Exhibit number 10. All right, and just take a look at this.
We can put it up on the screen if that's
Yeah,
easier for you. Can we put up States 10, please?
Thank you, and I appreciate the state helping me with technology. All right, so States 10, you pretty good now with the,
Yeah.
can you circle the bag he takes? Okay. Does he, when you say let's go, does he go to any other bag?
The first one he picked up was this bag, and he
what?
opened it.
Okay, it's the same bag you're talking about. He picked up that multicolored backpack. We saw the video and he opens it up. Okay.
Okay. Did you, now I'm gonna move away from the bags. Did you at any time go into the apartment?
No.
You said that no one was messing with the bags, but were you watching the bags the whole time?
No, I was not watching the bag the whole time. However, the people who were coming through the hallway, we monitor their movement.
Okay. Did you, how many people inside the apartment other than Cameron McCall when you got there?
I don't know how many people was inside of.
All right, you know there was a woman in a white t-shirt that we saw in the video. She had been inside the apartment, correct?
Yes.
Do you know when she entered the apartment?
Nope.
Do you know whether she was there for some of the altercation?
Nope.
Do you know whether Ms. McCall said anything to her before the police arrived?
No.
But she would be a witness of importance, correct? Potentially.
Maybe. I don't know.
Well, if you get to a crime scene and there are two people in there, one is the stabber and the other is talking to the stabber, would it be routine procedure to interview the person who is talking to the stabber?
Well, as you could see, the investigator did interview her.
Okay. Thank you. So I think we agree. She is an important witness to interview. Is that right?
Yes.
As far as you know, is there any cash or scales inside the apartment?
Never been inside of the apartment.
Okay, well, an investigator could go in the apartment and bring it out, right, in front of you? That didn't happen?
Sir, I was never inside of the apartment.
Okay. As far as you know, is there a knife inside the apartment?
Objection asked and answered.
She's covered. She didn't go in and she didn't see what was brought out. So everything on the planet could fit into that category.
All right. He was not free, obviously, to bring his stuff to Grady at the time, right? But at the time you left.
According to investigator Skidmore, no,
All right. And was investigator Skidmore taking the lead on this case?
yes,
All right. So he would be the one calling the shots, right?
yes,
So if he had just said, well, I'm not going to go to Grady, I'm going to take all my stuff and go home, he could not have done that, right?
well, according to investigator Skidmore, no,
All right. And you guys are a team, you work together, right?
he was the lead.
I understand you're following the chain of command, but in following the chain of command, you and I agree that had my client said, all right, I'm just going to go home and take what is mine and leave, he could not leave. Is that right?
Objection asked and answered.
Well, I'll let you answer it, but I'm going to ask it differently. Did Skidmore say to you, Mr. Tezera is not free to go, or the stuff in the hallway is not free to go?
The stuff in the hallway.
Okay.
When you went to Grady, was that were you getting off work at this point? Was your shift over?
Almost,
All right. When you went to Grady, did you do anything else on the case?
no,
Did you follow Detective Officer Skidmore to see what he did on the case?
no,
So this is the totality of the statements by Emmanuel Tezera that we heard. Is that right?
yes,
That's my stuff.
yes.
Thank you.
Any redirect, Ms. Nix?
Yes, sir. Officer Philemon, were there any other type of belongings in this hallway other than like personal belongings?
No.
And how long have you been a law enforcement officer?
3 years,
Are you post-certified?
yes, ma'am,
Have you responded to cases or calls like this where items are left?
yes,
In your experience, does a person normally specify, this is my stuff, or those 3 items are my stuff, or they just say, yes, that's my stuff?
Objection, Your Honor. Improper question calls for speculation not relevant to this case.
Asking about her experience.
Why don't you ask it in a different way?
When the defendants indicated the stuff in the hallway was his,
yes,
did that indicate to you that all of it was his?
yes,
Objection as to what she thought, Your Honor.
Overruled.
So, Mr. Hurst asked you about what bag the defendant went to first, and you said that it was this colored bag.
State's Day.
From State's Exhibit 10, you had circled, showing you what's the marked State's Exhibit 10 and admitted evidence. This bag, on the screen again. All right, that's the bag that you went to first.
yes, ma'am,
But we see on your video, on your body cam video that we just watched, that investigator Skidmore says, no, stop getting into the stuff because it's part of the crime scene, right?
yes,
So did he have a substantial enough time to go into any other bag?
no,
Did the defendant make any statements about the other individuals that were in the apartment when you and investigator Skidmore arrived?
not to me, no,
And we heard on your body cam, Ms. McCall saying something about drugs being in the items. Did that make you think there might be drugs, or were you still investigating just the aggravated assault?
I was just more concerned with the aggravated assault.
Okay. Was this a call where you were expecting to investigate drug possession?
No,
What were you expecting to investigate?
domestic violence.
We'll play State's Exhibit 2, starting at 3711. 3700. 3700.
So it's not up on the screen. But this is the body cam video, states 2, and you're starting at 37 minutes, 0 seconds.
3703.
Okay.
Correction on 3613.
Okay.
$36.14.
All right. We see it.
What did Ms. McCall just say?
Tell them how you sell drugs. Something about cocaine.
And at this point, you're just on scene looking for evidence of an aggravated assault, right?
Yes.
Thank you. No further questions.
Mr. Hirsch, any recross?
Miss McCall saying something about cocaine does make you believe that Miss McCall knows there's cocaine around. Is that fair?
No.
Objection. That calls for speculation.
Well, she's answered the question. I think it's an appropriate question, and her answer was no. Any other questions, Mr. Hirsch?
If she didn't know there was cocaine around, why would she say something about, tell them about cocaine?
So that does call for speculation.
Okay.
All right. Anything else?
No, that's all.
All right, jurors, if you have any questions for Officer Philemon, now would be a time to write them down on note cards. Anyone have questions? And when you're done, if you pass them sort of to your left, and Deputy Gordon will collect them. Can I have the other ones while we're waiting? Take your time. I'm just gonna start working on these. Thank you. Is that it? All right, be at ease for a moment. I have to talk with the lawyers out there so we can go over this. Counsel? That was on the audio. Reason why I'm thinking 6 is appropriate. It's a question. What Mr. Paul said. You're gonna Officer, a few follow-up questions. Let me. Okay. During the body cam footage that we saw, we had it showed investigator Skidmore announcing himself by kicking the door. You remember that instead of knocking with his hand, he kicked with his foot? He also, with his foot, swept some objects out of the way of the door. Can you explain to the jury, if you know, why he did that? And if you're speculating, say, I don't know, you need to ask him.
I don't know.
Okay, well, if he's here, we can ask him. When you put Ms. McCall in handcuffs, you detained her, did you see any bruises or marks or injuries on her?
No.
Do you recall from reviewing your body cam footage, Ms. McCall ever explaining the time at which the other people in the apartment arrived? So there was the woman in the white t-shirt, there may have been someone else. Did she explain that you recall they came after X or before Y?
I recall she said something about after you beat me and pull my me sewing. I'm not sure, but she said something to them coming. I can only assume they came afterwards, but
Okay,
I'm not sure.
but you're assuming it wasn't something that you're recalling from listening to the video. Okay, or the audio. There was reference to a vase that was supposedly thrown. Did you ever see or recover that vase? If someone recovered it from law enforcement, it would have been someone other than you.
Yeah.
Was there ever a time when Mr. Tezera had a piece of paper in his hand that he was trying to show you or that he was reading off of?
I think he had a piece of paper, but it was not trying to give it to me or anything like that.
Oh.
I think it might have been his driver's license, ID, or because before you get the hard one, you get a full copy.
Okay, you don't recall what that piece of paper was?
No.
Did, you were asked a question earlier about Ms. McCall saying something about cocaine and drugs. Did Mr. Tezera ever say anything to you during your interactions with him about drugs?
No.
When you are on scene at a situation you're called to, can the nature of your investigation change while you're there? In other words, you get a 911 dispatch saying there's a fight, but you show up and you're in the place and you see a scale and a big bag of marijuana on the table.
Yes.
Was there any reason why you did not go into the apartment to see what could be found there?
Because at the time, I was instructed to just go with him to Grady, so there was no need. There were other officers in there.
Okay.
My instruction is to go follow him to Grady.
And that's an instruction you received from Investigator Skidmore? Okay, so if he testifies, he can explain if anyone went in or who he told to go in from law enforcement. That was not your role? All right. Ms. Nix, do you have any follow-up questions for Officer Philemon based on the exchange she and I just had?
No, sir.
Mr. Hirsch, anything based on the conversation Officer Philemon and I just had?
No, Your Honor.
All right, ma'am, thank you for your time.
Thank you.
You are free to go. All right, we have about 15 minutes, a little less, before we have to break for lunch. We can start with a witness. It'd be great to get a little bit of that testimony in, but we probably won't finish whatever witness is next.
Yes, sir. The state's next witness is Summer Hutton.
Okay?
Please sit and turn and raise your right hand. You swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth. Swear without ceasing.
Yeah, the chair doesn't have wheels, so it's a little bit of a heft.
You stand and spell your name for the record.
Yes, my name is Summer Hutton, Summerhutton.
Good afternoon. Good afternoon, Ms. Hutton.
Had to check, it's still morning.
Thank you so much for joining us. Ms. Hutton, where are you, Mrs. Hutton? Where are you currently employed?
I am employed at the Georgia Bureau of Investigation in the Division of Forensic Sciences, also known as the State Crime Lab.
Okay. And talk a little softly.
It's on.
So you just want to speak up just a little bit, so we can hear you.
Okay.
So you work for the GBI, and what, how are you employed with the GBI?
I am a forensic chemist at the GBI in the chemistry section.
And what education and training do you have in chemistry?
I have my bachelor's degree in chemistry from Augustana College, and I underwent the drug identification training program at the GBI, which is approximately a year and a half long. Augustana College.
And what is forensic chemistry?
So forensic chemistry is basically when we take the science of chemistry, you know, figuring out what a substance actually is and what it's made of, and we apply that to the law. That's the forensic part.
Okay. And have you had any training experience with respect to analyzing any substances for the presence of drugs?
Yes, I have.
And can you explain to us about that?
So the drug identification training program basically encompasses different blocks where we go through different types of scheduled and non-scheduled substances, such as stimulants or depressants. At the end of each of these blocks, I underwent a written exam, an oral exam, a practical exam. And at the end of my training, I underwent a competency test, which I needed to get 100% accuracy on in order to keep my job.
Okay. And have you performed tests on samples to determine the presence of any controlled substances?
Yes, I have.
Okay. Approximately how many times?
I've tested over 1,500 samples.
Okay. And have you previously testified in courts as a forensic chemist?
Yes, I have.
Thank you. Your Honor, the state moves to tender the witness as an expert in forensic chemistry.
Mr. Hirsch, do you want to voir dire this witness in that space? Or do you have any objection to qualifying Ms. Hutton as an expert in the field of forensic chemistry?
I will pass on voir dire and I gladly accept her as an expert.
All right, Mrs. Hutton, for the purposes of this proceeding, you are deemed an expert in the field of forensic chemistry.
Thank you, Your Honor.
You're welcome.
Mrs. Hutton, in June of 2021, let me back up. On or about June 16th of 2021, do you recall if you received any analysis that you would have needed to test?
The crime lab received a piece of evidence on June 16th, 2021, but I did not receive that evidence personally to test until later.
Okay, thank you for going there. Can you describe the protocol for handling evidence when it comes to the GBI?
Yes, so when evidence is received by the GBI, it's done through a lockbox, which is essentially a two-way locker. On one side, the submitting agency will place the evidence and any accompanying documents and close the door. Once that door is closed, it can no longer be reopened from the outside. The evidence is then retrieved from the other side and pictures are taken, the documents are checked, everything is entered into our case management system, And once all of that has been checked and documented, then it's placed into the vault or secure location until it is assigned to the scientist.
Okay. And do you recall when it's not followed that way, is there any documentation of that?
Yes, if anything was wrong with the evidence, it wasn't packaged appropriately or anything like that, it would be documented in the case file.
Okay. In on or about June 16th of 2021, when the GBI received a package to be tested, how might the sample look when you receive it?
So samples most often come in evidence bags, whether that be a paper bag or a plastic evidence bag. The agency will seal it and place any accompanying information that might be necessary on the bag. So the case number, the officer will usually place his or her own name on the bag and any individual names, or they might include a brief description.
Okay. And are there any other identifying numbers or anything that the officer or even the GBI might place on the sample itself?
Yes, so normally they place the agency number on the actual evidence bag. Again, if that's not done, then we would contact and that would be documented in the case file. And then once those pictures are taken, the GBI will place their own barcode sticker after we assign it its own unique barcode and case number at the GBI, just to ensure that there's no duplicates of any case number or anything like that. And so every time I refer to the case for my testing, I use the GBI case number.
Okay. And excuse me. How might one, is there, in the course of your testing and analysis, do you generate any reports?
Yes, I do.
Can you talk to us about that? What's contained in the report?
So after I conclude my testing, I generate a report, and that includes the agency information, such as the case number, the officer, individuals. It includes a brief statement of when it was received at the GBI and how, so via the lockbox that I explained earlier. It includes a brief description of all of the items and sub-items that were included in the evidence. I state my results, what I confirmed, whether that be a controlled or non-controlled substance. I state the weight, if I took a weight. If I did a purity testing, that would also be on there. And then I sign my name.
Thank you. Do you recall if that was done on June 16th? Well, I take it. Do you recall whether or not Atlanta Police Department would have submitted a GBI testing request for to have anything analyzed on June 16th by yourself?
Yes, they did request the evidence that they submitted to be tested.
Okay.
Yeah, and I'm going to object as to what they requested. It's hearsay, not in evidence at this time.
Well, Your Honor, she's not speaking to.
Hold on. How is making a request a statement?
Well, I think making a request is more than, hey, will you do this? You're identifying something. This is X, Y, and Z. Will you test it?
Okay.
This is X, Y, and Z that, you know, from with this case number from such and such a case.
Understood. I'm going to allow it in as evidence that a request was made. There may be chain of custody issues. It may be that I provisionally admit what was tested through this witness, and then we'll litigate chain of custody through other witnesses. So,
thank you, Judge.
Answer stands. You can keep going.
Thank you, Judge. And did you test that? Did you test the substances as requested in the request?
Yes, I did.
Thank you. And did you generate a report for those?
Yes, I did.
Thank you. Showing the witness what has been previously shown to defense counsel, what has been marked for identification purposes as State's Exhibits 18 and 19. Take a look at those for a moment. And then explain to the court what those are.
This is the original report I produced for this case, as well as the amended report.
Okay. How do you know that it is a report that you generated?
So I can see the case number, the item descriptions, the results, my name that's signed on there, as well as comparing it to the own copy that I printed.
Thank you. And permission to publish as well. Sorry, I apologize. Is it a true and accurate depiction of the reports that you generated as well?
Yes.
Have there been any substantial additions, changes, or deletions?
No.
Your Honor, state asked to admit states exhibit 18 and 19.
Okay, the witness list just says, I mean, the exhibit list just says report 1 and 2, but I'm assuming 18 and 19 doesn't matter for this list. It's the 2 reports.
Correct.
Okay, Mr. Hirsch, first, any objection to the admission of states 18 and 19?
Yes, Your Honor.
Okay,
I don't want, I mean, obviously, your chain of custody hasn't been laid. I understand the state is taking Mrs. Sutton out of order. I do not want her to have to come back.
okay,
So my objection is this, I do not object to her findings. I do not waive objections as to chain of custody, all the hearsay that's on here, et cetera. So if they otherwise meet the burden in having it come in, I don't object to what Ms. Sutton says is the finding.
okay. It's Hutton and
I'm sorry.
that's okay. It's Hutton and I'm going to admit 18 and 19. I don't know that they're publishable. I don't know that they'll go back with the jury, but I don't mind making them part of the record. Should Mr. Peoples ask to publish them, then your hearsay objection I need to work through. But I agree with you that it's a proper basis for the expert witness's testimony and the sharing of her opinion. And I typically do make the expert reports part of the record, but whether they are published to the jury or go back with the jury are things we'll talk about when those present themselves. So 18 and 19 are admitted.
Thank you. And now permission to vote.
Any objection to publishing the reports?
Yes, Your Honor, there's hearsay in them.
Okay,
Your Honor, it's not hearsay because Ms. Hutton is present. She is in court to testify to her as an expert to testify to her own findings. Additionally, Your Honor, no one has explained to her or told her anything about the information itself. She performed the testing. There's no out of court statements and it's not hearsay.
okay. The report itself is an out-of-court statement, and I'm assuming you'd be offering it because you think it's truthful and not because you're going to impeach her with it. So it's in evidence, as in it's in the record, but I'll sustain the objection as to publishing.
Thank you. Mrs. Hutton, there are 2 reports. Why are there 2 reports?
So the original report was peer reviewed and released, and upon later inspection through the instrument logs, there was an error noticed that caused some of the data to be invalid. And so the evidence was resubmitted. I completed the testing again and released an amended report.
Thank you. And what processes did you perform in order to test these substances?
So after I opened it to begin my testing, I took a weight. I did a preliminary testing known as thin layer chromatography, or TLC. I did gas chromatography, mass spectrometry, or GCMS. And then to get a purity or a quantitative measurement, I did high performance liquid chromatography, or HPLC.
Okay, so all those are really big words, and I don't know exactly what that means. Can you clarify exactly what is happening with any of those?
Yes, so just to go through the entire thing, when I take a weight of the material, I do it without any packaging. So I remove any bags or anything like that, and I get a weight of just the solid material itself. So that is called a net weight. After that, I take a small portion to begin my quantitative testing and qualitative testing. So the first thing I did was the TLC, which essentially just shows me how many different components are in the sample. So when I do that test, I can compare it to a reference or use my own experience to tell me what might be in the sample. From that, I went to the GCMS, which is another separation technique. So the first part, the gas chromatography, essentially just heats up the sample and breaks it up into all the different components that might be in the sample. The next part that goes on is the mass spectrometry. And so it takes all of those individual components and breaks them down even further. And I'm able to get structural information to confirm the presence of whatever substance might be in there. And then from that, I move on to the HPLC, which is the purity testing. So that one gets a little bit more complicated. So essentially how it's performed is the GBI makes known concentrations of cocaine for this specific quantitation. So they make specific concentrations, and that's plotted on a graph. And then I take a known amount of my sample and do the same thing, and that's plotted onto that graph to determine what the purity is.
And what was submitted to you to be tested?
So there were 3 different items that were submitted. There was 1 bag of leafy material. There was another bag with 2 bags of solid material and another item with 1 bag of mushrooms.
Okay. Were all of those items tested?
No, they were not.
Why might, if multiple items are submitted to you for testing, why might you not test them all?
So in order to get through cases efficiently at the GBI, since we test cases from all over the state, we only test the one that has the highest schedule and the highest weight. So I would make a visual determination based on my experience, which item would need to be tested.
And you said a green leafy material and then mushrooms. How would you know that it's mushrooms if you didn't test them?
So I might not know what is in the mushrooms, so I couldn't say if there was any scheduled substances or no scheduled substances in the mushrooms, but I am able to determine what a mushroom is and what it looks like and could make that as my description.
So what was tested out of those 3 items, out of the green leafy materials, the mushrooms, and you said something else?
The 2 bags of solid material were both tested.
Were you able to make a determination of what those were?
Yes, I was.
And what were they, what did you find them to be?
Both bags were positive for the presence of cocaine.
All right. And with that, we have to pause because we need to break for lunch now. Mrs. Hutton, I believe you need to be testifying somewhere else later today.
Yes, at 1:30.
If I need to have my staff reach out to that judge or whatnot, if you can get contact information. But I told these lawyers we had a hard stop at 12:30 because I'm running a meeting. So we're going to take our lunch break, but we need you back after that lunch break. So it'll be 1:30. As soon as you're done with the examination, I need to get both sides all the time they need. And we get the jurors' questions, we'll get you on your way. But if someone gets me a number, I'm happy to reach out to let that proceeding know that Mrs. Hutton is not dilly-dallying, but she's stuck because we started with her first, okay? But if you'll stay put, ladies and gentlemen, we're going to take a 1-hour lunch break. Please be back by 1:30. If for some reason you're running late and you're stuck, I don't know where you'd be stuck. Call, did we put the chamber's number? We're gonna put the number for my office up there. You should call that tomorrow morning, or I guess it would be tomorrow afternoon if you're running late. That's the way to reach me and my staff. So we can know you're okay, but you're stuck somewhere. And if we need to send in Deputy Gordon and his SWAT team, we'll do that to get you. During lunch, don't talk about the case. Talk about anything else. Don't do any outside research. When we come back, we will wrap up the direct examination of Mrs. Hutton, any cross-examination, and then any questions you might have for Mrs. Hutton. Thank you for your patience, and we'll be back in an hour.
All right, sir.
tomorrow close or today close?
Okay, we're back on the record in State versus Tezera. We're at the back end of our lunch break, and I want to talk a little bit about Ms. McCall's testimony. And I wanted to adjust this. Ms. Nix or Mr. Peoples, did you want to add anything to the record about the state's response to Mr. Hirsch indicating that he intended to explore with Ms. McCall the fact that she could have been prosecuted for the drugs that necessarily were in her apartment and then were found outside her apartment?
Your Honor, the state doesn't see the relevance of that part. The actual drugs themselves were found outside. And as the state is putting on its case, the state is attempting to lay the foundation that the defendant himself is saying, that's my stuff. So I understand defense counsel's argument that at some point it was inside of Ms. McCall's apartment and she could be prosecuted. But first off, that's not why the law enforcement responded to the resident. They responded for an aggravated assault call. I could see if defense counsel wanted to get into that itself. Additionally, the aggravated assault, was declined by our office back in May or March.
May 19th, 2023.
May 19th of 2023. So, I mean, we could get into the specifics of that, any charges that would have come from that incident, but the state is opposed to getting into her to speculate about charges that would have come from something that didn't happen. They didn't find drugs in her home. They found them in the defendant's stuff in the hallway.
Which bag from the screen? Is it the public's bag that ultimately has the drugs in it?
No, Your Honor, there's a white sort of, I guess, it would look like a
reusable grocery bag.
Like a reusable kind of grocery bag.
Can you put up States 10, please?
Pull up 1 second, Your Honor.
Mr. Hirsch, there were two topics I wanted to cover on Ms. McCall, maybe more, but I'm remembering two. One was your suggestion that you might explore as a basis of exploring bias, the penalties for trafficking in cocaine. And the other was you wanting to get more information about the disposition of the aggravated battery charge. I've now heard, and it refreshes my recollection, that there was a declination, which I think is a purely digital thing, in May of 2023. Let's stick with that second topic. Do you need any more information about that?
Your Honor, that's exactly what I wanted, and they turned it over today. There's a piece of paper, it is filed.
Oh, great, you've got it, okay.
Yeah. And I think the reason I couldn't get it is, my guess is the record has been sealed. So, yes, but this is what I've been looking for.
Got it, okay. Any objection, I'm gonna just stick with you, Mr. Peoples, to Mr. Hirsch exploring with Ms. McCall the fact that she was charged and then your office declined those charges. This would not be do with drugs, it would be the physical assault on Mr. Tezera.
No objections to that, Your Honor, and I believe we'd get into that ourselves in
Okay.
direct as well.
Got it, that would be a wise move on direct. Then back to you, Mr. Hirsch, your thoughts, having heard from Mr. Peoples about the drugs. Oh, I had asked this question before we get there. So we're looking at States 10 on the screen. There is to the, oh, I can do this. There's a garbage bag, I'm calling it a garbage bag, leaning in someone's doorway. You see I've circled that. Is that the bag that had the cocaine?
No, Your Honor.
Okay.
You can't see here what will the state expects to show in its evidence is that you'll see it more clearly through other witnesses in their body cam. You won't be able to see it in these photos, but through their body cam, it's much more clear. You won't be able to see it here, but that's just a trash bag.
That's not where the drugs were found.
No, it is not.
Are the drugs somewhere inside my second circle?
Yes.
Okay. Are they with the laundry basket, which is the little circle inside my second circle? Or are they in the stack that had the backpack and the laptop, which is the second circle inside my big circle?
Second circle inside your big circle.
Okay, so where I put the X, somewhere in there is this white reusable, I know it's sort of, the Publix bag is a reusable grocery bag. This one just happens to be white.
Correct.
Okay.
It's unmistakable. It's white and covered in blood.
Okay, and it's in the pile marked with an X.
Yes, Your Honor.
Okay. Mr. Hirsch, tell me why you think you should be able to engage Ms. McCall in questions about her liability for drugs that are marked by the X there.
Your Honor, she could obviously have been charged with party to crime in this event. The testimony is going to be that these items were inside of her apartment, that my client and her had been staying there for a while. She shows she knows about it, right? So she has knowledge.
She in fact said, I'm sorry to interrupt, but I think this will resolve it. She said, tell them about how you sell drugs.
Right.
Okay. All right. That's all I need to hear.
And well, you want more?
I don't want more. I'm going to allow you to explore that with her. All right. Okay.
Do you want to go over the next issue, related issue?
Sure. What's that?
Well, she has motive to lie because she has the drugs in the house, but she also does because she's a fugitive.
Oh, the Virginia situation.
Right.
Did she know she was a fugitive? Maybe we need to establish that outside the presence of the jury.
Well, she knows she has charges pending in Virginia.
Did she know that?
I don't know, maybe we need to establish that.
Okay, let's have her address that outside the presence of the jury. Okay?
Would you like to do that now or?
Nope, I'd like to get Ms. Hutton on her way. Who is the witness after Hutton?
Ms. McCall.
Oh, okay. Well, we'll take a super quick break after Ms. Hutton testifies. Well, let's just knock that out. It's very simple. This Virginia, if Ms. McCall is here, is she far away?
She's down, she's across in our office.
Okay, we'll just take a break after Ms. Hutton. But if you could have your investigator have Ms. McCall right outside as we're wrapping up with Hutton, because then the jurors can step out. We'll touch upon Virginia. Okay? Mr. Hirsch, anything else?
No, Your Honor.
Okay. Mr. Peoples, are you ready for the jury?
Yes, Your Honor.
Can we have Ms. Hutton come back in?
Yes.
Your investigator nodded. He'll do that. Great.
Thank you.
Mr. Hirsch, you ready for the jurors?
Yes, sir.
Okay. Jurors, please.
In Floyd County that she still does. Stickers.
Did we clear up the cab for you? Or are you in trouble?
No, it's just.
Great.
All right, for the jurors. President of the County Court.
Thank you, Deputy Gordon. Everyone else can be seated. So how was lunch? Did anyone risk American Deli? How, did people go out or everyone had brought their lunch?
We went to, this place across the street.
Fuda?
No.
No.
They were sold out of everything.
Bua, not Fuda. Okay, they're not supposed to be out. What was the vendor today? What had they tried to?
The ramen place.
Okay, and they were out.
Yeah.
Bummer. Okay, but I don't know of another place across the street. You just walked till you found food? We're hungry. There is a cafeteria up, if you go up Mitchell and turn, it's called like 244 Watt. You have to go through the largest metal doors ever. That's great. That's a great cafeteria, good price. Was that on a piece of paper or you just knew to get there? You followed who?
We followed,
Oh, Debbie Gordon. Yay. We'll pay him this week then. Excellent. All right. Glad you guys got something. When we broke for lunch, Mrs. Hutton was on the stand, had just talked about what tests revealed. You may want to repeat the question that we ended with, and then you'll wrap up your direct. We'll see if there's any cross, and we'll go from there. And you're still under oath.
So, Mrs. Hutton, I believe before we broke for lunch, I asked, and I'll ask again. What was the substance? What did you determine the substance that was submitted to be?
The 2 bags that were tested were both confirmed to have the presence of cocaine.
Okay.
I'm sorry, I can't hear.
Yeah, can you talk into the microphone?
Yes.
You have a soft voice.
So both bags were tested and they both confirmed the presence of cocaine.
Okay. So now, as we discussed before the break, there were 2 reports. Okay. Do you recall the dates of those reports?
Could I refresh my memory?
Yes.
The first report was dated November 28th, 2023, and the second report is dated January 29th, 2024.
And I'm so sorry, could you say it one more time?
Yes, the first report is November 28th, 2023. The second report is January 29th, 2024.
In the first report, was the presence of cocaine detected?
Yes.
In the second report, was the presence of cocaine detected?
Yes.
Now, we talked about how there are 2 reports. Let's talk about the first one first. The one that I believe you said that you conducted and the results came back November 28th of 2023?
Correct.
The presence of cocaine was detected. What about, you stated earlier that you're also able to determine weight and purity. In your assessment and the test that you conducted, were you able to determine weight and purity as well?
Yes, I was.
And in the first report from November 28th of 2023, what was the weight of the cocaine?
The first bag weighed 176.541 grams. The second bag weighed 118.533 grams.
Math is awful. Law school, not math school. How much is that?
Put things together.
I would need a minute to have them up.
You need a calculator or a pen?
I don't know if this works, but I'm handing the witness a calculator as court's exhibit 0.
Thank you.
That would be 295.074 grams.
So 295, roughly a little bit over 295 grams, 295.04.
Yes.
Okay. And what about the purity?
The purity for the first bag was 53.2%, and the second bag was 60.5%.
Okay. You say there's separate bags. Were you submitted 2 separate bags?
So they came together in a paper bag all together as one item. So that would be item 2. That's the parent item. And then once I opened that paper bag, and I think there was another sealed paper bag within that, then there was 2 individual plastic bags, and that would be 2A and 2B. So that's what I'm referring to as one bag and the other bag.
Understood. Now, there was another report done, and I think you just testified and told the jury that report was conducted and the report came back January 29th of 2024. Why was there another test conducted?
So essentially what happened is the instruments that are used, that HPLC that I was talking about before lunch, someone went through the instrument logs to make sure that the quality control was done appropriately, and they noticed a small typo which resulted in the data being marked invalid or being marked valid instead of invalid. So all of the cases that were connected to that specific sequence were then reanalyzed only for the purity.
Okay, and was that done here?
I conducted the reanalysis.
So you conducted the analysis, the second analysis yourself. So you yourself did the first one and you did the second.
Yes, I did.
Okay. And what was were there any changes that occurred in that?
So the presence of cocaine was already established using different methods, so that TLC and the GCMS had already confirmed cocaine. So those, it did not need to be redone for a qualitative perspective. Only the purity needed to be redone because that was the sequence that was affected. The weight also has its own quality control and that passed. So the weight did not need to be redone. It was only the purity testing.
Understood. And did you conduct that second type of testing?
Yes, I did.
And what was the difference?
So the first bag was 51.6%. So I believe that's a 2.6% difference. And the second bag was 58.9% pure, which would be a 1.6%, I believe.
So you're talking about the difference. So you're saying that on the second percent purity, there's a change. Does the purity go? Did the purity increase or decrease? Can you just tell the jury what the purity is? Tell the jury again what the purity was of the first one.
Okay, so for the first bag, the initial testing showed the purity as 53.2%. And after a reanalysis, it was 51.6%, so slightly lower.
Okay. Then in the second?
For the second bag, the initial testing showed 60.5%. And the reanalysis was 58.9%. So again, slightly lower.
Are those large margins to see a difference of?
No, those are still within the measurement uncertainty. So I would not consider that a large margin.
Looking at those, having done the second analysis, is the substance that was tested, is it cocaine?
Yes, it is.
In the weight that was measured, as you testified, it was over
295 grams.
And the purity and the purity was still above 50% for each testing?
Yes.
Now, you spoke to the jury about how things are submitted in the lockbox and about how you conduct the testing. Your Honor, showing the witness what has been previously shown to defense counsel. Thank you. Previously shown to defense counsel and what is now marked as State's Exhibit 20. Yes, you take a look at this guy. Let the record also reflect that State has provided with this as well.
Okay.
Can you take a look whenever you're ready? Can you take a look at the outside of the bag? Are there any indicators on the bag of how you might perform any testing or to label it for your own records?
Yes. So whenever the evidence is submitted to the GBI, like I was explaining earlier, and it comes in through the lockbox, a picture is immediately taken of the evidence in its original state, and then this barcode sticker is placed on it. So it has the GBI case number as well as the item number that is unique to this piece of evidence and won't be repeated in the GBI database.
And let me stop you right there. What is the number on there?
So that is,
Your Honor, it's not in evidence.
Okay, it doesn't have to be in evidence for her to say the number that's on it.
May I go up and look at it?
Sure.
so this barcode that was placed on it by the GBI is 2021-1022928, and it has sub M number 002, which would be the item number.
Does that correspond with, excuse me, does that correspond with the information generated in your report?
Yes, it does.
Let me ask you specifically, does it correspond with the information in the first report
Yes, it does.
from November 28th of 2023?
Yes.
And the second report from January 28th of 2024?
January 29th, but yes.
I apologize, thank you. Now, before we get into that part, the second report, there's specific information. Does it override that second report that you generated where you retested for the purity? Does it override the first report?
Yes.
And did you make note of that in your the drug report, in the GBI drug report?
Yes. So the amended report has on it that it replaces the first report entirely, and it still says that the analysis confirmed the presence of cocaine, and it has the same weight as the first report.
Okay. So you were able to test the presence, and I believe we addressed this before with lunch. 3 things were submitted. You said the green leafy substance, the solid material, and the what you perceive to be as mushrooms. And you stated that only one thing was tested, and that was what?
The solid material.
As you're taking a look at the bag there, can you take a look inside and take a moment and tell me what that is?
Am I okay to remove?
I didn't hear what you said.
Am I good to take it out of the bag and everything?
Just follow Mr. Peoples' directions.
Okay, so from the first bag, I can see the openings that I've made, and every time that I sealed that paper bag, I placed my initials and the date on it as well, just to document when I was entering the evidence and when I was sealing it again. So this is what was placed in the paper bag, and you can see, again, here's my initials with the date from when I opened it. And inside this are the 2 bags of solid material, as well as you can see 2 test tubes here. And those are actually 2 test tubes that I placed in this bag. So whenever I'm doing a purity testing, I'm taking a representative sample. So I'm just taking a little bit from all over. I'm making sure that it's real mixed up and I'm getting a good accurate purity for this entire sample. And the 1 gram portion that I took, I placed in this test tube so that it would be known that that was separate from the bag.
And is it sealed?
Yes, it is.
Why might you seal it?
I seal it so that it's evident if there has been any tampering or if anyone else has opened it. So I seal it and place my initials. That way, if there was another opening or anything like that, I would know that I didn't make that opening.
And have there been any tamperings, or is it in the same condition to which you sealed it after you tested?
It's in the same condition.
Thank you.
And this would be after your January retest for purity.
Yes. So
Okay.
you can see that there's 2 different openings, because the first one was when I tested it in November. It was reanalyzed in January. So you can see that there's 2 different openings with my initials.
So you sealed it yourself twice?
Yes.
And to your recollection, after the first time, had there been any changes or tamperings?
No.
And as you look at it now, after the last time that you tested, have there been any tamperings or changes?
No.
From the state moves to tender States Exhibit 20.
Okay. Mr. Hirsch, any objection to the admission of states 20?
Similar to what I said before, I know the witness have to come back. It is to the extent that she testified that she tested the substance and tested as she says, I don't object. Anything beyond that, I would object.
Okay. So I'm provisionally admitting states 20. It's certainly admitted for the purpose of these are the things that Mrs. Hutton tested and the results that she got. Where they came from, that's nothing she can testify to, and that hasn't been established yet.
Right, thank you. So as we address that, you explained about that you received it from, is it a lockbox?
Yes.
And where is this lockbox located?
So the lockbox at the GBI is located on the first floor, and any, excuse me, law enforcement agency can come and enter and access this lockbox. So they go in and they place it. It's essentially like the post office where you have the two-way locker, and they're able to place it in there.
Once they place it in, once a law enforcement agency places something inside the lockbox, are they able to take it back out?
No, the door cannot be reopened once it's closed.
Okay. And are you able to determine, if you determine that something has been tampered with, or that something doesn't look the way that it should in your professional experience and opinion, do you make notation of that?
Yes, it would be noted, as well as there are pictures taken as soon as it enters the crime lab. And if the evidence receiving team notices anything, that would be documented in the case file. Pictures would be taken. And before I begin even opening the evidence, I review those pictures. I make sure nothing has changed. I make sure that all of the seals are intact before I even begin testing.
And would any of that information also be included in your reports?
Yes, if the evidence was not sealed appropriately or any other submission guidelines weren't followed, it would be noted in the report.
And was that an issue here?
Yes, the evidence did not have a initial on the seal.
Okay. And what's the importance of a missing initial?
So, like I was explaining earlier, why I initial the seals that I make is so that way, if any new openings occur or any new seals occur, that they're accounted for. So when the evidence came into the lockbox, the submitting agency hadn't initialed on the seal. And so the lab staff initialed it for them at that point, took a picture of it, so that way it could be tracked going forward.
Okay. Is that uncommon that a law enforcement agency may forget to initial, or have you seen it prior?
It is common to see.
It's common to see that someone may forget to initial or not initial?
Yes, in this specific circumstance, it was initialed slightly below the seal, which is not proper protocol. So that's why an initial was placed on it. But we have a very specific standard for where we want the initials on the seal.
So there was an initial, it just wasn't in the right place.
Correct.
Per GBI protocol, it was in the wrong place.
Yes.
Understood. So, understood, as you just, that's my thing, Judge. Now, as just briefly, a couple of other questions. As you talked about all of the testing that you've done, you conducted all of those same tests on the first from the first report that was generated November 28th of 2023, correct?
Only the high performance liquid chromatography would have been redone for the second report.
Understood. And it still confirms the presence of cocaine?
Yes.
Confirms that it's over 200 grams?
Yes.
And confirms that the purity is over 50%?
Yes.
Was anything else? You stated that a couple of other things were also submitted, but they weren't tested. Would those also show, or would you make note of those in your report?
Yes. So anything that I opened, I would describe. So that is why the related items of the leafy material and the mushrooms are on the report, even though I did not test them.
Okay. Showing the witness what has been previously shown to defense counsel and marked for identification purposes as State's Exhibit 21
And States Exhibit 22. We'll take a moment, please. You're welcome to go as well. You take a moment and take a look at those. And then explain to the jury what those are.
So this is the item 1 that was received by the crime lab. So you can see by the sticker, it has the same case number and really small, it says 001 for item 1. And you can see, again, here's my initials at the bottom from where I opened it. And inside is what I described as a bag of leafy material.
Okay. And as you testified earlier, that wasn't tested, correct?
Correct.
Okay.
Okay, so for item 3, the same thing. There's the barcode that the GBI placed on it as item 003. And you can see here at the bottom where I opened it, as well as my initials. And inside is what I described as a bag of mushrooms.
Thank you. And are those the, all of the items that would have been submitted to you for testing?
Yes.
Have there been any changes or tamperings to your knowledge to those items?
Just that they've been reopened where the agency seal was, but other than that, no.
Let the record reflect that I opened them here in the courtroom today. And why might they be sealed again? Why might you have sealed them? Or why might evidence be sealed in general?
So every time a piece of
I'm gonna
evidence.
object to that. I don't, first of all, he can't testify to, I don't know that it's true, there's no one for me to cross-examine.
Why the bags were sealed again?
No, he said that he just gave testimony that he opened them in court.
Oh, we had moved beyond that. And you'd already gone on to your next question, so I'm finding that not to be a timely lodged objection. So your question, the question before you is why would these things be resealed?
Yes. So every time a piece of evidence is opened at the crime lab, an tamper-proof evidence seal of some kind is placed on them. So in this instance, you can see that I used evidence tape. And so evidence tape is very flimsy and tears very easily. So that way, if anyone was trying to access this piece of evidence through the opening that I made, it would be evident through the evidence tape because it would tear. It's made to tear very easily. Another type of seal that we use is a heat seal. So that plastic bag that I had earlier, I placed a heat seal on that, which basically just means I stamped it and melted the plastic together and then placed my initials on that. And all of that is done just to make sure that there is no tampering done to the evidence and that we would be able to see any new type of opening or if the openings I made were altered in any way.
Thank you. And that was done here?
Yes.
And have there been any changes or tampers?
No.
Government, the state was to admit states exhibits 21 and 22.
Any objection beyond the foundation issue that either will be tied up or won't be tied up? These are things that this witness saw and handled. She can't talk about where they came from.
Same objections I had, Phil. I have no objection to, but I don't, same as I said last time.
Okay, got it. So I'm conditionally admitting them insofar as there's been testimony from Mrs. Hutton that these are what she received and tested.
Thank you. That's it. Thank you. That's all for now, subject to redirect.
All right. Mr. Hirsch, questions for this witness?
Okay, so you talked a lot about the initials and tampering and how the bags are sealed, correct?
Correct.
All right, but so there's a process when a substance that's going to be tested at the crime lab is found at a crime scene. There are a few stops it makes before it gets to you, correct?
Yes, there are things that happen in evidence before it comes to the crime lab.
So what you know is you receive a bag and you know what happens to that bag once it's in the crime lab's control, right?
Correct.
So when we're talking about, is this the vacuum seal with these initials? Are those your initials?
Yes.
11/29/23?
Yes.
Okay, so when we're talking about it being sealed with your initials, we're talking about what happens to this substance after it's been tested. Is that right?
Yes.
When you test it, I see that you have some tubes in here.
Yes.
Tell me, why you have these tubes?
Yes. So whenever I am performing a quantitation, like I explained earlier, I take a representative sample, and that is of 1 gram of that solid material. So I'm taking a little
Hold on
bit-
1 second. Can't rustle the bag while she's talking. Thanks.
So I'm taking a representative sample and I'm just taking little pieces from all over, making sure that, you know, it represents the whole, because I can't test every single speck of the solid material that's there. And then after I take that representative sample and do my purity testing on it, I then place it into a test tube, just to keep it separate. And so that if anyone were to retest, they would see the portion that I sampled from. And then I place that back into the evidence bag.
Okay, so what happens to the test tubes from the first testing from November 28th, 2023?
The reanalysis was done on the same representative sample.
Okay, so you take a gram from each bag, correct?
Correct.
And then you tested that gram on November 28th, 2023.
Yes, slightly before that.
Okay, that's when the report was done.
Yes.
Okay. And then that gram, you keep it with the larger sample.
Yes, so around slightly before November 28th, I placed that gram into the test tube. Once the case was done, I placed it back with the original evidence. And then when it was reopened in January, I used that same representative sample that was kept separate in the test tube.
How did you find out that there was an error with the machine between the two samples?
So the instruments have logbooks and instrument operators. Different people have different day-to-day duties at the crime lab. And once the instrument controls were checked at a later date, they saw that there was a small error or a typo in one of the logbooks, which had caused the run to be invalid. And since all of the data is traceable, we were able to isolate the cases that were affected by that mistake.
Was that in the gas chromatography machine? And
that was in the high performance liquid chromatography.
High performance?
Liquid chromatography.
Okay. Now, these machines, you outsource them from a different manufacturer, right?
Yes, they are technically instruments because they produce data and they are bought from an outside manufacturer, yes.
All right, and you depend on the machine to tell you that it's working, correct?
Yes, so anytime we use an instrument, there is quality control associated with it to make sure that the instrument is in proper working order, which is why later on when the logbooks were checked by someone else, they saw that the quality control had not actually passed for that run.
Right. So, and the machines operate a diagnostic test on themselves to say, yes, I'm working, right? I have the machine, I'm working.
The instrument itself cannot determine if it's working properly. That's why we conduct quality control and we check that quality control, but there are human errors. The entire process is not fully automated, so there is human error of reading or transposing numbers, and that's what had happened.
The error that occurred here, was it a human error or was it something, or was there an issue with the calibration or some other functioning of the machine?
So how it works is there are different quality control checks for the purity testing. And once those quality control checks are done, 2 different scientists will review that quality control data and make sure that everything is in working order. And so when those do not pass, we cannot use that data because it does not meet our standards. And so for this instance, that data did not meet our standards and needed to be redone.
Okay, I think your explanation's over my head. Could you dumb it down for me a little bit? Was it the machine that should have done something differently? Was a human didn't write something down and should have done something differently, or was it a combination or something else?
So the instrument, we put in the sample and the instrument is going to give us a response. Whether that response meets our quality control is up to the scientist or the human to determine if that sequence or that data should be usable, if that makes sense. The instrument is never, I guess, telling us it's okay to use it. We need to verify that that instrument is in working order.
Okay. The weight of the substance, do you weigh it with the bag?
No, I take a net weight, which is without any packaging.
Okay, and the packaging that it came in, it basically came in one of these cellophane bags, like a lunch bag?
Yes, it was like a vacuum seal and then the Ziplocs.
Okay. And the bag weighs 5-6 grams, is that about right?
I wouldn't be able to say how much an empty bag of that size would weigh.
Okay. Does that sound about right to you?
It would weigh more with the packaging. I just don't know an exact value of those size bags.
The weight of the mushrooms, did they look like chanterelle mushrooms to you?
I wouldn't be able to say. I'm not an expert in, botany or whatever mushroom growing is, but I can determine what a mushroom looks like.
Okay. It came to you because in case it might be what they call psychedelic or magic mushrooms, right?
Yes.
Right, but you didn't test it?
I did not test. I would not be able to say whether those had any controlled substances in them.
All right, the green leafy substance that looks like marijuana, that came to you also to be tested, is that right?
Correct.
Right, and during this time, there was a product, a flower product that came from the marijuana plant called Delta 8 or Delta 9 that was legal, is that right?
Delta 8 is not necessarily grown, but there are different flowers.
Okay.
Products.
You would often get plants that look like this to see if it was something that they legally sell in tobacco stores in Georgia, is that right?
Yes, I wouldn't be able to say anything about what the leafy material actually contained.
You say you couldn't say anything because you didn't test it, or there is no known test to ascertain if that was marijuana as opposed to Delta 8 or Delta 55?
I would be able to test it, but I did not in this case. We do a threshold testing to determine the purity for the leafy material.
You do one,
Yes, it is offered.
but you didn't do it in this case.
Correct.
Same thing with the mushrooms.
Correct.
The initials from APD, can you show me where that was done? Can I bring?
Yeah.
Which one's the, let's use the one that you tested. I'm gonna hand you the market states exhibit number 20.
Yes. So initially, whenever this had been received, this would have been taped down. And you can see that the agency had initials below the actual seal. So when I was talking about earlier with the evidence tape, how it rips really easily, we would like those initials to be on the seal. So once it entered the crime lab, that's what this green piece of tape is. Somebody at the crime lab added their initials so that we could keep track of the seal after it was entered.
And at the crime lab, they added their initials, but they also added the green tape.
Yes,
right?
correct.
And the reason law enforcement is supposed to initial higher up is so that if the seal is broken before it gets to the crime lab, you will know, is that right?
Yes, that is why we like the initial to be actually on the seal.
And do you teach law enforcement that? Does law enforcement know that?
Yes, there are different submission techniques that are available to them.
So in this case, they violated the submission technique.
It was not up to the GBI's protocol for the initial placement. So that is why the initials were added once it got there.
All right, and the purpose of the initial technique is to make sure that the right sample from the crime scene or wherever is what actually gets to you. Is that right?
It is one portion of that. It's so that we can see who made the seal, see if the seal had been tampered with or anything like that, which is why they used the evidence tape so that it would break easily. But I am checking the agency number, individual names, and that the contents are matching with the agency submitted.
Okay. I'm just gonna ask you some questions about the barcode, and I think I'll be done. You had mentioned, something that the barcode was given a specific barcode number, and each barcode number was just for one case or one item. Is that right?
Yes, once the case is submitted to the GBI makes its own case number so that it can be entered into our case management system. And each piece of evidence will have a barcode, and those barcodes will go with the number of the item.
Okay, so even in this case, 01 as opposed to 02, as opposed to 03, they'd have 3 different barcodes.
They would all be linked to the same case number, but they would have different barcodes to be kept track of in the chain of custody.
Okay, so can you, I'm gonna pull D20 up again. Can you show us which barcode is it that the GBI has?
This one.
Okay, 2021-102-2928.
Correct.
And then that barcode matches the barcode on the crime lab report?
Yes, they're all linked to the same case number if I were to scan it into our case management system.
And is it the same barcode that is on this other label down there?
No, that was already on there whenever the agency submitted it.
All right, and it looks like there's a barcode on the back too.
Yes, that is the same GBI barcode. We place it on both sides of the evidence, so that way whenever we're transferring or placing it anywhere, it's easily accessible.
All right, and then if I understand right, so you know what the barcode says, a computer scanner reads it, and if another barcode has the exact same configuration, then you know it's the same barcode. Is that right?
Yes, if the barcodes were the same, they would be the same barcode.
They would look alike.
I mean, all barcodes look similar, but yes, I would not be able to differentiate a barcode.
Okay, but the scanner can, because the barcode on the front of that package and the back of it are exactly the same.
Yes.
Thank you very much.
Mr. Peoples, do you have any redirect?
Just very briefly, Your Honor. Mrs. Hutton, how often is a quality control check of the instruments done?
Every sequence.
Every sequence, and what does that mean?
So every time that a sample is run, it is run on the instrument, and the instrument has that specific sequence of those samples. And when they go onto the instrument, a quality control is done before. And when they come off the instrument, a quality control check is done after to make sure that the instrument is working in between those 2 times.
Okay. And with that quality control check, as you were explaining, and I think if you can explain it, because I thought I missed it, you're saying that the instrument does its own quality control check, and then 2 other scientists do that as well?
So the quality control check is something that we run on the instrument. The instrument is just producing data. The instrument is not thinking for itself. It can't tell me if the data is good or not. We're the ones that need to determine that. So we're running an instrument or a quality control check on that instrument. And whatever the outcome is how we determine if it's valid or invalid.
I see. And you said that there are 2 separate scientists that do that.
Yes.
And why are there 2 separate scientists that do that?
That's just part of the quality control to try to minimize for human error, since it is, we do deal with a lot of different case numbers and different, quality control checks. Each instrument has a different one. So just to minimize any human errors.
Okay. And again, the substance that was confirmed to be cocaine was tested without any packaging.
Correct.
Thank you.
Mr. Hirsch, we good for juror questions?
Yes.
Jurors, if you have any questions for Mrs. Hutton, you mastered the technique, write them down. You can have more than one question on a card, only write on one side of the card. And almost everyone was legible. We did have to have a little group deciphering of one of them. But if you have any questions, write them down. Anyone?
It's,
Okay, looking at that.
yeah, I just asked. And I just.
Deputy Gordon, can you hand the speaker back to Mr. Peoples? Thanks. You can always put it back up there if there's more audio. Anyone else? Take your time. Just want to make sure you could be doodling instead. You. Thank you. All right. Council, see you right outside, please. Okay. Mrs. Hutton, can you tell the jurors the date the items you tested and otherwise visually examined were delivered to the crime lab?
Yes.
Is that in your report somewhere or in your head?
It's on the report.
Okay.
So the evidence was received on June 16th, 2021 through the lockbox. And after I had released the first report and I needed to do the reanalysis, they were resubmitted on December 13th, 2023.
So June 16th, 2021. And when did you perform your first batch of tests?
I have that in my notes if I could.
That's fine.
The first batch, I opened the evidence on November 7th, 2023.
Okay. Explain to the jurors why it took so much time from June 21 to November 23 to get to these tests.
So the crime lab has a very significant backlog. We receive a lot more evidence than our staff is able to handle, which is part of the reason why I was only able to test one item. That is part of just trying to be efficient and try to get through as many cases as possible. But unfortunately, with the backlog, we do have a lot of items that sit in the vault, which is a secure location until a scientist is able to test them, because we don't have enough staff to get through the amount of cases that are submitted.
You may have answered my next question, which is, where were these items held after June 2021 when someone put them in that locker with the two doors? You said something about a vault.
Yes. So once the evidence is received and after, as I explained earlier, all those pictures, everything is taken care of, then it's placed into the vault at the GBI. I work at the headquarters location, so it's placed into the headquarters vault, where it sits until it's ready to be assigned to a scientist. Once that item is ready to be worked, it will be brought up to my section, the chemistry section, and I place it into my secure personal locker that I only have keys for while it's under my custody.
You tested the white solid substance, not the green leafy substance or the mushrooms. The white solid substance that you tested, is there any chance that you understand from your expert perspective that its composition would have changed over the 2.5 years almost that it sat in the vault?
So since it was sealed in an evidence bag, in my experience, I don't think the humidity or temperature would have affected it. If it did affect the substance, it would have broken down, and we do see common breakdown products of cocaine, but that would have only lessened the purity. So we try to operate at the GBI where we try to give the benefit of the doubt. So if the cocaine had deteriorated at all, it would have only lessened the purity. It wouldn't have added anything to it.
Something that wasn't cocaine when it got brought in wouldn't deteriorate into cocaine.
Correct. It would deteriorate into BZG, which is benzyl ecodine.
All right, I'll get you to write that down for the court reporter before you go. All right, last question. If you were describing the quality control that goes on, if two people quality controlled, checked the machine that had that little glitch such that you had to retest, does that mean both of them missed? You've referred to a typo in a log, that both of them missed it?
Yes. So unfortunately, mistakes do happen, and so how the GBI works is there are, everybody has their own day-to-day jobs. So that is under someone's umbrella to make sure that that quality control is checked. And essentially what happens is one of those quality control checks is called a certified reference material. It is from an outside source, and that's brought in to make sure that that calibration curve that I was talking about earlier is done correctly. And it's about an 8-digit number. And what happened was the last digit was incorrect. So that was missed just by human error. And once those instrument logbooks were checked once again, that is when it was noticed, and we did the amended report.
Mr. Peoples, do you have any follow-up based on what Mrs. Hutton and I just discussed?
No, Your Honor.
Mr. Hirsch?
No, sir.
Thank you for your time. All right. Are you still calling the next witness that you plan to call?
Yes, sir.
All right. Ladies and gentlemen, we need to take a quick break for you because the lawyers and I need to work through one thing before you can hear from the next witness. This probably won't be your afternoon break. We'll still try to fit that in as well, but it is a break. Don't go too far from the jury room. I don't know how long this will take. It shouldn't take too long, but we'll get you back in here as soon as we can. Usual rules, don't talk about the case, no outside research. Thank you.
All rounds observed.
Hello.
Well, he lost his, you had done a swearing in for him.
Oh.
Shatavi's here. He lost the certificate.
Okay. My thought is we bring in Ms. McCall. I'm gonna ask a few questions about the Virginia situation, and then I'll allow both sides to do so as well. Was there anything else, Mr. Hirsch, you thought we needed to cover with Ms. McCall in advance?
Not for me, no.
Okay, and then she might as well just stay on the stand once she's in here, and we'll bring the jurors back in.
Okay.
Can you grab those gloves? Don't creep anyone out.
Wanted to address scheduling, Judge. It's already 2:30, and I believe Ms. McCall's testimony might take a while. We've got other officers that are here. They appeared.
Come on up, Ms. McCall. Right, just stand by the deputy, please.
Due to me thinking that this, we would be getting to their testimony sooner than we are. And so I wanted to kind of just get y'all's opinion on whether I could let them go and say, come back tomorrow.
I wouldn't let them all go. If we finish at 4:15 with Ms. McCall, I'd want to use the remainder. This seems to be going a little more slowly than you all have forecast. Maybe it's not, but we'll finish Tuesday and you won't have rested. In fact, you've got multiple witnesses left. So I'd ask that you keep at least one witness who's not a 30-second witness to testify after Ms. McCall. If you want to release others, I'll eat it if we finish both Ms. McCall and that next witness, and it's not yet 5.
Okay, thank you, Judge.
Sure.
Skipping would be our next one.
Thank you.
Thank you.
Yes, please swear Ms. McCall in.
Cameron McCall, Cameron, last name McCall.
Ms. McCall, I'm Judge McBurney. I'm presiding over the case of State versus Tezera. And in a moment, you'll be testifying in front of the jury. Prosecutor will ask you questions. Mr. Hirsch will be able to ask you questions. But there was one topic I wanted to cover outside their presence to see, so I could learn a little bit more about it. When this incident happened between you and Mr. Tezera in June of 2021 in your apartment, were you aware of outstanding charges against you in the state of Virginia?
At that current moment, no.
Okay. When did you learn that you had charges out of Virginia?
The first day that we went to, I believe it will be bail hearing. Yeah.
A bail hearing. I'm sorry.
Once we were arrested for that incident, that's when the first time I heard about it at the bond hearing.
You had a bond hearing because you were charged as a result of the incident with Mr. Tezera. And at your bail hearing, someone told you you had charges out of Virginia?
Yeah, I believe the state told them, yes.
Okay. What were the charges as best you remember?
It was a peace order. Peace order.
Okay. Did you ever go to Virginia to deal with them?
Once I was released from Fulton County, they picked me up and I got on a plane and was extradited there. Once I got there, they pretty much dismissed it.
Okay. So there's no conviction flowing out of Virginia?
No, not as that I know of.
Okay. Well, you'd know better than we would.
Yeah.
So you were not actually released from custody. You just were transferred, extradited from Fulton County up to Virginia and dealt with that. And the way it was resolved is it was dismissed.
Yeah, I was let out that night once I arrived, and once I went to court, they pretty much dismissed it.
You were released once you got to Virginia. Got it. You were not released from Georgia, had to fly up there effectively in custody and were released up there.
So here I paid bail here, and then once I posted the bail here, I went there, and then of course they did no bail hold, and then I just received a court date.
Okay. Maybe I misunderstood you. Your flight up to Virginia, was that a ticket you bought or were you escorted by?
The Virginia Marshal.
Okay. I better understand that. Who will be handling Ms. McCall as a witness?
I will be Judge. You could just give me 1 second. We don't have any questions about this particular issue.
Okay. Mr. Hirsch, do you have any questions about this issue?
Yes, I do. Hi, Ms. McCall, how are you?
Hi, how are you?
Good, my name is Max Hirsch. We haven't met in person before, you may recognize my voice.
Yeah.
All right, can we talk Saturday?
Yes.
The question I have for you is.
Judge, I'm sorry, I can't hear her.
Okay.
Yes.
Okay. Yeah, just you're going to need to get friendly with the microphone because the jurors are going to need to hear you in just a little bit.
I'm going to turn the microphone up.
It's not a volume situation, it's a proximity situation.
So when you got to Virginia, they didn't give you bond, right?
I believe no.
But shortly thereafter, they dismissed the charges?
Once I went to court for it, yes.
All right. And prior to you getting to Virginia, how long had you been in Georgia before this, before June 2021?
I'm not really accurate on the day that I moved here. I know it was only for a few months. I wasn't here for that long.
Okay. And you came from Virginia, is that right?
No, from Maryland.
From Maryland. Were you, not after what happened in Atlanta happened, but before that, were you ever arrested or given a citation for these charges in Virginia?
No.
So when were you in Virginia?
So
prior to the charges being dismissed, when had you been in Virginia?
Maryland and Virginia and DC is a small vicinity area. So they're all near each other. Right. Yeah, so Virginia is nearby. So before I moved away, the incident, I guess, apparently happened.
All right. Do you remember the incident?
Yes.
Did you know that they were likely to take warrants out for you based on the incident?
No, because the warrant wasn't originally for me anyway. Yes.
All right. Thank you, ma'am.
All right. Ms. McCall, if you'll step outside real briefly, I need to talk with the lawyers about what we just discussed. And I'm going to have the deputy swear you in again in front of the jury, not because I'm trying to treat you any differently, but all the other witnesses in this trial will swear to tell the truth like you just did, but in front of the jury. I'm going to want them to see that as well. Don't say, wait, I already was sworn in. We'll just repeat that process, but in front of the jury, and we'll get into the substance of your testimony from Ms. Nix as well as from Mr. Hirsch, okay? Thank you. Mr. Hirsch, anything you want to add concerning the Virginia situation?
Argument.
Yep, not testimony.
Yes. Okay. Your Honor, I believe that it comes in the case law on questions like this, of course, stems from Alaska versus Davis. Then there's Hine versus State, 249, Georgia 257 from 1982. And then there are a whole bunch of cases saying, talking about that line.
Talking about what? Because we have someone who didn't know she was wanted and then ended up there. So unless she says, I've never been in trouble or extradited before, I'm not sure how you get into this.
I think, Your Honor, because it was pending during the pendency of this case, she cooperates with the state. They then dismiss her aggravated battery. So the question, I think, dependent, as Alaska v. Davis says, in order for me to get it in, it's got a big broad umbrella about bias, right? And I agree with that. But it is. I mean, Alaska versus Davis talks about the witness could consciously or subconsciously think about how them helping the government might affect this case, an unindicted case where they're a co-conspirator, the cocaine case, and other pending cases, sometimes when they're on probation. So the cases were pending at the same time. She shows up and it magically goes away. She could consciously or subconsciously think, well, I really need to cooperate with the state, so I keep this clean.
Got it. Okay. I find from the record that was just made and the opportunity you had to make a record that it would be inappropriate without some other door being opened for the defense to ask Ms. McCall about the Virginia situation. The record that was made just now is that Ms. McCall was unaware of charges pending in Virginia, and that they were resolved before she then had any subsequent interaction with the district attorney's office here in Fulton County. So please stay away from that topic unless you think something has changed. We can have a sidebar and revisit it. Anything else, Ms. Nix, that we need to cover before we bring the jurors back in and you call Ms. McCall?
Judge, I wanted to clarify the, earlier ruling about whether it's appropriate for the defendant to mention what the range of punishment is for this case, which the defendant is being charged with. That is not an appropriate thing for the jury to consider. And so I just wanted to clarify your ruling that while I understand that the defense is going to accuse Ms. McCall of being a co-conspirator, that even if she were to be a co-conspirator, talking about the range of punishment for her to be found guilty of this, if she were, which that's not what we're here about, but that would not be relevant. And so I just wanted to make sure that I was clear on what your ruling was earlier about what can and cannot be gotten into with.
Okay. Thank you for flagging that, because I didn't mean to be unclear. I believe that the record as it exists now and the case law that discusses the latitude that a defense attorney has in a criminal trial, or prosecutor, if it's a defense witness, to explore the potential bias of a witness encompasses, in this case, a discussion with Ms. McCall about her understanding of whether she could have been found liable or as party to a crime or whatnot, the trafficking in which you allege, the state alleges, Mr. Tezera was involved. That carries with it, per the case law, a discussion of, and if you were found charged with and potentially found criminally liable for the trafficking, here's the sentencing range. It's not one without the other. And so it's really by operation of law that Mr. Hirsch would be able to talk about the sentencing range. The threshold is there any potential connection in Ms. McCall's mind, reasonably, to be thinking, whoa, I could be on the hook for what Mr. Tezera is on the hook for. So I have an incentive, a bias to be more cooperative or shade my testimony or say things that are in my interest, Ms. McCall's interest, and against Mr. Tezera's interest. And I think from what I've heard, it's appropriate for defense counsel, not defendant, but defense counsel, to explore with Ms. McCall her connection to the alleged cocaine sales. She's the one who says selling cocaine, not Mr. Tezera. And what flows from that, from the case law, is he can explore with her, well, if you were found to be connected as a party to a crime, as the host of the drug sales, because it's your apartment, you'd face X and Y and Z. That's just how it plays out. So it is not germane to the jury's final ruling. And it would be error and sanctionable. And I would fuss at Mr. Hirsch if in his closing, he says, and you better take this seriously because you know what the penalty range is for Mr. Tezera. He is a wily defense attorney, and he may well in his closing say, you should not believe Ms. McCall because she was facing 15 to 30 for trafficking. That's a legitimate argument, and the case law supports that. And it's a wink and a nod, but I am instructing Mr. Hirsch not to make an argument that goes to the jury specifically with, this is just too close for you to side for the state, given that my client's looking at 15 years. There will be a subtext of that, but that's why defense attorneys love getting in sentencing ranges. And it's what happens when witnesses who are arguably connected to the charges are called to the stand. And that's where we are, I find.
Okay, thank you, Judge. I just want to make sure that the state does object to the defense getting into that because it is more prejudicial than probative, but I understand that that's true.
Got it. Okay. Mr. Hirsch, do you need any fine tuning of my ruling so you don't run afoul of anything?
No, sorry.
Okay. Ms. Nix, can we bring the jurors in?
Yes, sir.
Mr. Hirsch?
Yes, please.
Great.
All right, so jurors.
Thank you. Deputy Gordon, there is, I think it's a even older set of gloves behind that monitor. Do you mind grabbing, see it? Throwing that away. Thank you so much. Ms. Nix, if you would call your next witness, please.
Yes, Judge. State calls Cameron McCall. I can't get it into evidence, but this is the ring video. Get rid of photos of the stuff. 10 or something. It's in the hallway.
Raise your hand. Swear affirm that the testimony you will give truth, the whole truth, and nothing but the truth that you are. Can you state this really name for the record?
Cameron McCall, CAMERON, first name, MCCALL, last name.
Ms. McCall, you have a soft voice, so please make sure you stay near the microphone when you're answering people's questions.
Okay.
Thank you.
Good afternoon, Ms. McCall.
Good afternoon.
How do you know the defendant, Manuel Tezera?
We used to be in a relationship.
Is he in the courtroom?
We used to be in a relationship, and yes, he's right there.
Can you describe what he's wearing and what he looks like for the jury?
I'm kind of short. I can't see beyond the computer. He has a blue shirt on. I mean, a blue suit on.
So we've got three gentlemen with blue suits at the table. Is he on the left, the right, or in the middle?
He's in the middle with the blue suit on.
Let the record reflect the witness has identified him.
She has.
How do you know, or how long have you known Mr. Tezera?
We didn't date long, like maybe a week, two, not long.
How did you meet him?
Out one night at a party with some friends.
And about what year, maybe month was this?
I believe 2001, 2002. I'm not about 3, 4 years ago, I believe.
The 2001 was 24 years ago, 23 years ago.
Yes.
Are you trying to say 2021?
Yes, I'm sorry.
So in 2021, where were you living?
In Atlanta, Georgia.
You still live in Atlanta?
No.
In 2021, you stated that you met Mr. Tezera,
Yes, ma'am.
and you described your relationship as y'all were seeing each other.
Yes.
Was that in June of 2021?
Yes.
Did y'all ever have a fight that had to have law enforcement called?
Yes.
Do you remember the date of that incident?
Unfortunately, no.
I said June 11th of 2021. Would that sound right?
I'm just not sure if it's accurate, but it may be around that time frame.
Tell us what led to that fight.
Just I was asleep. I woke up. He was in my house and he was on the phone with someone, and I overheard the conversation. I didn't like the contents, so I asked him to remove himself out of my home.
Let's take that one at a time.
Okay.
So you said he was in your house. Did he live there?
No.
And where was this? Was it a house or an apartment?
Apartment.
And what was the address of that apartment?
1888 Emory Street, Atlanta, Georgia.
Is that in Fulton County?
Yes, ma'am.
So, did he live there as well?
No.
Was he staying over sometimes, or did he get stuff there?
Yes, when we first started talking, yes, he would stay frequent.
So, you said that you were asleep. What happened next?
So prior to going to sleep, we went out, we went to eat, things like that. Had a good day during the daytime. Again, I went to sleep. He stated that he was going to leave to go handle some business, which he did leave. I guess in the course of me sleep, he did return. I woke up, I heard a phone call conversation. He was talking to another individual on the other line. I overheard this person tell him that they were on the way. I was just eavesdropping from my room, honestly, I was. And I came out, and then he pretty much ended the call.
Why did this call upset you?
Because the contents of the conversation wasn't like a friendly conversation. It was just more so like he was flirting with someone else, and if that's what he chooses to do, I just asked him to leave out my home.
So you overheard this conversation, and it sounded flirty to you, which you didn't like.
Mhm.
What did you do after you heard this, and what did you do after that?
I came in, he seen me standing there. He ended the call once he seen me. Well, my figure standing in on the, like, it's the curve of the living room. So he hung up the phone. Once he hung up the phone, I basically repeated myself again for him to remove himself, because if he's going to talk to other people, he can go do that elsewhere. He then threw his phone at me, and can I curse?
You should say whatever you remember.
He threw the phone at me and was like, "Bitch, you always want to say something." And I was on the phone with my mom. So he gave me the phone. I think because he stated that he was on the phone with his mom, he thought I wasn't going to look at the phone. I ended up still looking through the phone once he threw it at me and said it was his mom. He saved like other people's names under mom, auntie, cousin, sister, and the conversations wasn't giving mom, auntie, cousins, and sisters.
So you got upset,
Mm-hmm.
and what did you do next?
At that point, I began to just scream at him to get out my house. First, it was just an arguing match, going back and forth, back and forth, back and forth. And then that's when he first hit me.
Tell us about that.
in the kitchen of my old apartment is an island between us. He was on the other end. On this side, I was on the opposite side of the island. So we were like face to face, talking across the counter. That's when he first hit me. I started like,
Across the island front?
yeah, like, cause we were talking like this, so he leaned forward and just smacked me. Yeah, pretty much. So at that point, I started like trying to run from him. At that time, I had my hair sewn in. He grabbed me by my hair and like pulled me. For a second, probably about for like 5, 6 minutes, he was like just fighting me, and at that point, I just was. I just was mad because I just never thought he would do that. And so while he was just hitting me, I just had to, once I felt like my hair being torn out my head, like still to this day, I still have the ball spot in the back of my head from him.
What happened next?
So as I was sitting there, I was crying. I couldn't get to my phone at that point. So at that point, it was more so I was thinking like, he can kill me. He can do anything to me right now. And like, I don't have family here. I literally moved here because my dad died. I just wanted a new start. I just wanted to find myself. And so after that, I just had to remember like, I'm very feminine into who I am. And I had to just remember my natural born sexuality. And at that point, I just was like, I have to fight him like a man. Like, he's not gonna let me go. I felt like he was overpowering me because I'm very feminine. So I don't know if he thought just, oh, because you're feminine, things like that. So at that time, I just would start grabbing things that were in my reach.
And did you strike him back?
Yes.
With what?
First was my fist. And he still was coming at me. Even after I struck him back, I thought he would stop, at least like, okay, like she's gonna put up a fight back. Thought he would at least leave, because the whole time we're fighting, I'm still asking him to leave. Again, chasing me around the kitchen, chasing me. It got to a point after my fist, only thing I had was the frying pan, the skillet that was on my stove. And then, yeah, I started beating him with the skillet at that point because he kept trying to fight me.
Now, this skillet, is it just a normal skillet, or were there indentations or anything like that on it?
It was just like a regular frying pan that you can buy like Walmart, Target. It was a basic standard frying pan.
Okay. And did any of those blows cause Mr. Tezera to bleed?
Yes, and then yes, that and maybe also the marble tray I hit him in the head with.
Okay. So you struck him with something else after the frying pan?
Yes, because even with the frying pan, he still was like, none of that was stopping him.
What did you do?
Once I hit him with the marble tray, he started to bleed. I think before even the fight, he already called 911. So they was already supposed to be on the way, but it was taking so long for them to get there. So in the course of that call of him making, we pretty much was fighting the whole single time till they got there. So he, from chasing me in the complex in the hallway, from me jumping the gate to get back in my house in the backyard because he was chasing me in the complex. It was just a lot going on.
So at this point, you hit him with the frying pan and with the marble base or
the tray, yes.
And is it, at this point, is he bleeding?
Yes.
What injuries did you sustain?
Other than my scalp bleeding and things like that, nothing major. Like he had major.
Okay. And your scalp bleeding, was that a lot or just a little?
Just because the hair blockage and things like that, it wasn't like pouring out like, but it was blood coming.
And other than hitting you with his hands and pulling out your hair, did he attack you in any other way?
No, just fighting me, just making his little small threats, but no.
So after this fight, he's struck you and pulled out your hair. You responded with frying pan and with the marble tray. What happens after this?
So after this, he begins to grab his things, put his things in the hallway. As he was getting his things, again, I'm still yelling, "Get out my house!" It doesn't like at this point. I'm not giving you courtesy time to get your things. Just get out. Of course, we're still arguing, still trying to fight. He's still trying to fight me because at this point, I guess he's angry that he's bleeding or whatever the case may have been. So he kept trying to fight me. At that point, all I had was myself. My grandparents has a adopted daughter that happens to be here from her original family is from here. So my mom instructed me to call her because she's the closest relative I had, which she drove from Lithonia.
Did you contact her
On FaceTime. So she was on FaceTime of the call. And even on the FaceTime call, he was still trying to fight me. Upon their arrival, he still was trying to fight me in the hallway, even with them there and them asking him to leave their cells. He still wasn't. That's when he began to chase me in the complex. That's how that happened.
Showing you what's been previously admitted into evidence as State's Exhibit 4.
Mhm.
Do you recognize that photo?
Yes, that's my old front door.
And I'm showing you what's been previously admitted into evidence as State's Exhibit 5. Do you recognize that photo?
Yes, that's my Ring camera property.
Right. And I'm showing you what's been marked as State's Exhibit 7. Do you recognize those items?
That's his stuff.
Okay. Is anything that belongs to you in that file?
Not at all. Other than the camera and the door.
Other than
On this picture, no, ma'am, nothing at all.
7, there's a pile of items.
Yeah,
Do
none
these
of.
items depicted in State's Exhibit 7 belong to you?
No.
How do you know they don't belong to you?
I just know I wouldn't put my things in bags like this.
Do you recognize any of those bags as being yours?
No, they're not mine at all.
I'm showing you what's been marked as State's Exhibit 12. Do you recognize that?
This is the Ring camera footage.
Have you reviewed that Ring camera footage prior to your testimony today?
I haven't really seen it in too long. No.
Did you watch that earlier today?
Yes.
Okay. So does the video recording that you watched previously today that's on that disc, does it fairly and accurately, what is a Ring camera?
A Ring camera is a security camera that can catch live footage in your home just to capture things. It was just honestly for my safety, again, because I was here alone.
Does it have a online account that you can access the videos?
Yes.
Is that your account?
Yes.
And how is the Ring camera activated? Do you have to turn it on? Is there an app that you turn it on, or is it automatic?
So with this Ring camera, it did work 24/7. It would just go straight to my phone to get feedback.
So what causes the Ring camera to save a video? Is it movement?
Anytime there's any motion in front of the camera, it can be someone just walking past my door in a hallway, it will capture it, long as it's motion there. Or if I do log into the app, I can activate and turn it on to see what's live feeding right there in that moment.
How are the videos saved?
I think it's just automatic through their programming. As you can pretty much rewind the feedback to that day and Pacific time.
Okay, so you have access on an app on your phone to go back to a specific date or time and save the video from the app.
Yes, ma'am.
Did you save any videos that depict something that occurred on the night of June 11th, 2021?
Additional to this,
Just any videos.
yes, I believe I have more videos from that night.
So this is the video that is this the video that you downloaded from the app and provided to you on?
The night of, yes, because at that current moment, they wouldn't, of course, with the severity of everything that was going on, they wouldn't allow me to truly like look through my phone. But the footage for the incident I do have, yes.
So this video that you provided to law enforcement on the night of June 11th, is that the video that is on that disc that we looked at earlier?
Yes, ma'am.
And has it been altered or amended in any way from its original recording?
I would just say it's shorter. It is missing a few details. But yeah.
But the pictures that are being depicted, that's what it.
Yes, that's accurate.
Is it possible for you to change the video, like use AI or something to make it look like something happened?
During that time, AI wasn't invented.
Statements to admit State's Exhibit 12?
Mr. Hirsch, any objection to states 12?
I'm assuming it's what I've been given, which is 13 seconds long, in which case I do not object.
That is correct.
Then it's admitted. If it is some other length, we'll have to have a discussion.
Permission to publish?
Yes, ma'am.
So the video that we're going to watch in just a moment is from your Ring camera, correct?
Yes, ma'am.
And
Does it have audio or it's just video?
I believe that one doesn't have the audio.
Well, I didn't ask my question well. Your Ring camera on that apartment at 1888 Emory, did it have the ability to record sound as well?
It does.
Okay.
all right, so just gonna pause it. Who's that person that's depicted in that video?
Emmanuel.
And is that the front door of your apartment?
Yes, ma'am.
We can see some items already in the hallway. Do those items belong to you?
No, those are his items.
So the door with what looks like home plate from a baseball field, that's not your door, that's across the hall.
Yeah, that's my neighbor's. At that time, my neighbor, yes.
So was that Emmanuel Tezera throwing his belongings out into the hallway?
Yes, ma'am.
On the night of June 11th, 2021?
Yes, ma'am.
Did you throw anything out there, or anything that was out there came from Mr. Tezera?
No, as far as his bags and stuff, no. Just his crates, as far as the clothes he had that was left in my room.
You did put some things outside?
Yes.
All right, tell us about that. You said the crate, you put something out?
Yes, he had clothes as well. So those items there wasn't, I don't think those was his clothes because those wasn't in the closet. Those were in the foyer closet in my house that he had put in the closet over there.
So let's talk about the timing of all this. This video we just watched, was the items that you put out there already out there?
No, ma'am, not at all.
So after we see him throwing his items out, at this point, have you put anything in the hallway?
No.
What you put out in the hallway came after this video?
Yes, ma'am.
So we can see on the bottom right-hand corner, there's a date and time stamp. Do you see that?
Yes, ma'am.
Is that accurate?
Yes.
So it reads, well, it looks like it's backwards. So it says 2021, 11/6. So that's June 11th, 2021 at 22:02, sorry, 22:03. And that's military time. Do you know what 2200 is in military time?
Yes, ma'am.
It's, what time is it?
That is 3 p.m., around 4 p.m.
So,
No, you said 23?
2200, so, would that be 10 o'clock at night?
Oh, yes, sorry. Yes.
All right, now you said that you contacted your grandmother's adopted child?
Yes.
Is that correct? And you said that she came over to
Yes.
the apartment?
Her and her child's father.
Okay, and, in relation to the video we just watched, is that before or after the video?
That is after he was moving some of his things out. So they arrived in the course of him still moving stuff out.
And where did she come? What is her name?
Her name is Anaja.
Can you spell that?
Anija.
Thank you.
And where did she go when she came to your apartment?
Well, they were stopped in the hallway because it was, of course, it was blood all in the hallway. They were trying to her child's father was trying to ask him to leave multiple times and letting him know that he doesn't live here, that he should just go ahead and go. He wasn't trying to listen to their advice. He still was trying to attack me while the people are trying to tell him to leave. So.
They go into your apartment?
So she approached the door, but because of so much blood, she didn't want to come in.
Did she, was she in your apartment? Law enforcement arrived?
Yes, a law enforcement allowed her to go inside to get my phone, my house keys, and my credit card.
Can you describe your aunt?
Yes, she's younger than me. So she's, at that time, I believe I was 22. So my aunt had to be about 21, 20. She's 5'4", brown skin, dreads.
You remember what she was wearing that night?
I believe either leggings and a white top.
I'm going to show you what has been previously marked as State's Exhibit 2. Now let's be on the screen.
Okay.
But previously admitted into evidence as State's Exhibit 2.
Okay. Yes.
Is that her?
Yes, that's my aunt.
And this particular, so we've stopped her at 2229. behind the man in the blue COVID mask.
Hmm.
Can you see the person behind him, not the white officer, but the person between the two of them?
Yes,
It's, who is that?
Emmanuel.
So I'm not talking about the person that is behind, Officer Skidmore, the white officer. I'm talking about, the person whose head you can just see above the officer in the blue masks.
So you can annotate on your screen.
Oh, yes.
You
So
wanna-
here, directly behind him is my aunt's child's father.
I think you can, I know I can as the host. I don't know if you can annotate. I don't want to mark anything up, but you might make it clearer to everyone involved.
We'll hit play so that maybe we can get a better angle on this.
Okay. So you can pause it. I'm gonna ask a question. There's the woman with the pink Crocs. You've already identified that person.
Yes, sir.
Then there's a guy largely blocked by this fireman with the blue mask, but you can see he's got white slides on his feet.
Yes, that's my aunt's child's father,
Okay, and what's his name?
Kareem.
And were they present in your apartment while this initial fight was happening?
They were only present when he was chasing me around the complex because he's actually the one that grabbed him to stop him.
Now, in this video, this is Officer Philemon's body cam. I posit that you can hear a lot of commotion.
Yes, ma'am.
Were you upset with the defendant while this was happening?
In this moment, yes.
Tell us why.
I feel like he just put his hands on me. I've never been in a relationship with somebody actually put their hands on me. So I was more so also embarrassed because I felt like I have to call my family with this foolishness. My neighbors was outside. I was just I think the anger came from more so embarrassment.
And you were taken into custody, correct?
Yes, ma'am.
How did you feel about that?
I didn't like it at all.
So while you're talking with the officers in Officer Philemon's body cam, we can hear you tell the officers that the defendant sells drugs.
Mm-hmm.
Say that.
Yes.
Why did you tell officers that?
In the initial state, when they first originally came to the house, they were treating him as he was the victim. And it kind of triggered me because I asked them a question. Was he also being arrested? They stated, I believe, that he was the victim or something. And that just triggered me because I seen them assisting him, trying to get his stuff together to move it. And it just triggered me to let them know what they were helping him move in.
So before this, had you seen him selling drugs?
No, of course, I never asked him where he got his money from. I was just under the impression that he had a wealthy family. That's what he told me.
Did you ever suspect him of selling drugs?
No, he doesn't give that personality. Like you wouldn't expect him to do that.
So why did you tell officers that there were drugs in his house?
Because when he was trying to leave, he called, I believe at that time, his family's driver. That's what he was calling him. And telling him to hurry up because he know he has the stuff.
What did you take that to mean?
That he got something in that crate that he didn't want the police to see. But he was the one that called them to my home.
Okay. So did you actually hear him ask someone to come to that location to pick up his belongings?
Yes.
And what did you hear him specifically state the reason to be?
He told them that he just got in an incident with me, that he needs to hurry up and come get the stuff because the police is on the way.
If you had never seen him with drugs and didn't know
Mhm.
why he didn't think that he did sell drugs, why would hearing come get my stuff because I've got the stuff in it, how would that make you think that he had cocaine in his, or drugs or anything illegal in his possession?
The way he was acting,
Tell me
like,
about that.
he was trying to just move too quick. He was hiding the stuff in the parking garage. Like, it was just weird stuff he was doing. So, and then once at that point, of course, I call and let people know that I just got an incident with him. And someone that I know mutually that knows him from being out just warned me to be careful with him.
So, you said earlier that you were pretty mad at him when all of this happened.
Yes.
Are you still mad?
Honestly, no. I've been through therapy. But like that was the lowest point in my life. I feel like I don't hate him. I don't think he's a bad person. I just think he made the wrong decision that night. And I sometimes, I think people may regret what they do to others, but yeah.
When in preparing for your testimony,
Mhm.
did you speak with anyone about your testimony today?
No.
Did you and I speak about kind of what happened? And
Oh, yes. Yes, ma'am.
so we see you arrested. You said that you were arrested this night. Are those charges still pending?
No.
Or what happened with them?
They were dismissed.
Were they dismissed in any kind of agreement for your testimony today?
No, ma'am. They were dismissed way before this case was told to me.
And in your discussions with state, any of our investigators or us, has anyone promised you anything to be here today?
No, ma'am.
Has anyone threatened you with prosecution for this original case or anything like that for your testimony today?
No, ma'am.
Were the drugs that were found in these bags, were they yours?
No.
And you already stated that the defendant was bleeding from this altercation that
Yeah.
the two of you had. And you said that you were bleeding a little bit.
Yes.
Was the blood that's in the hallway, was that from you?
No, that was his.
Was the blood that was on all of his belongings, did that belong to you?
No, that was his.
Between when these the defendant's belongings were thrown out of your apartment by the defendant, as you just saw on the ring video, did you or your aunt's child's father, or anyone that you observed go into those belongings?
No, they barely wanted to be standing there at that moment.
And did you know that there were drugs in the defendant's belongings?
No, not until, like I said, I put two to two together.
Did you
Yes.
know that there were drugs in your house at all?
No, because he just brought that stuff that day.
When he arrived at your house that evening, you said that you were asleep, and are you saying that the items that we just saw depicted in the photos and that video, those were brought with him that day?
Yes. We went out earlier that day on a date. He mentioned, like, I guess he wanted to go a little further. I was a little homesick and he knew that, so he offered to take me to DC back home the next day. So during that time, we enjoyed ourselves. He went home. He said he was going to get a few things so we can leave the next day. And then, yeah, we never made it to the trip.
Why not?
Because of this incident that happened.
Can you repeat that?
From the incident that happened, that's why we didn't go.
Okay.
And you said that y'all hadn't been dating for very long.
Yeah.
And was he living there?
No, he would just stay over frequently. I just like this company, so he would just be there.
Why did you let him stay overnight, even though you'd only known him such a short time?
I was young and dumb. Simple to say it. I was just being young and dumb and just, at that time I had my own place. I moved to a new city. I was just exploring. And when I met him, I gravitate. I'm not a social person that much. So when I am, I kind of cling to people and I kind of cling to him. So we was just like in this clingy thing where we would be together every day.
As we stand here today, are you upset with him today?
No.
Do you have any reason to lie about what happened or what you observed that day?
No.
When you were talking to officers, did you tell them any lies?
No.
No further questions, I'd like to redirect.
Mr. Hirsch? Since you're already in position.
Well, now I have to go back to my desk. Afternoon, Ms. McCall.
Good afternoon.
All right, I hope you had a good trip in from Virginia, is that right?
Yes.
All right. If you could, would you speak up a little bit for me?
Yes.
Thank you. So, at the time of the event on June 11th, you were interviewed by the police, is that right?
Yes.
All right. And you had an opportunity to tell the police what happened, correct?
Yes.
And you did tell the police what happened, is that right?
Yes.
Now, I'm actually going to lead off here at the back. The state says you have no motivation to lie, right?
Yes.
Right. But you were arrested on the night of the incident with aggravated battery, correct?
Yes.
Right. What's that?
Yes.
All right. And by cooperating in this case, your case for aggravated battery was dismissed, is that right?
Incorrect.
Okay, why is that incorrect?
Because my case was dismissed before I even knew about this trial date. Okay. I didn't know about this trial date until 2 weeks ago or a week ago, and my case been dismissed for over a year.
All right. You were arrested June 11th, 2021. When was your case dismissed? Was it close to that period of time or more recently?
My case was dismissed in 2023 in the early of that year.
Okay. And did you find that out today?
No, I've been knew that.
All right, you knew that. So this case was indicted December of 2023. But right before that, May of 2023, they dismissed your aggravated battery case. Is that right?
I believe that's the month. Yes.
Okay. And that would be 2 years after, almost 2 years, May of 2023, almost 2 years after the incident, which occurred June of 2021. Does that sound right to you?
Accurate. That's accurate.
Okay. In addition to that, you know that you had said to the police, there are drugs there, or tell them about selling drugs, right?
Yes.
And that you have a ring camera showing all the movement that happened that day and the days before that.
Yes.
Now, did the police subpoena your ring camera so they could find out all the videos that were on it?
I gave the footage voluntarily.
And when you say you gave the footage that we saw here today, 13 seconds, is that right?
Yes, of what they asked for.
They
Yeah.
just asked for 13 seconds.
No, when I gave them the footage, I was explaining them to what happened, and that's how they received that clip.
All right. Now, someone else, there's a blue bag in the hallway. Do you recall that blue bag?
Yes.
At some point, was that blue bag that you know of, was that blue bag in your apartment?
When he brought the stuff, yes.
When he brought it earlier that day?
Yes.
Right. So if that were the case, your ring camera would have picked that up, correct?
Yes.
And you have control of your ring camera on that day, what videos you showed the police, right?
Back then, yes. But they never asked me about no bags.
Also, when that blue bag made it from inside your apartment to outside your apartment, that movement would be picked up on the ring camera, is that right?
Yes, that's what you see him moving.
See him moving the blue bag?
You can see your client moving them on the camera.
Okay, do we see him, do you recall, does he move the blue bag?
You can see him moving, yes.
All right, but specifically, the blue bag, do you see him moving the blue bag?
Yes, on my camera footage, yes.
Okay, and is that what was played here?
Not today. They didn't play that here today.
They did not play that today?
Yes.
But you have camera footage of Emmanuel Tezera taking the blue bag from inside your apartment and putting it out into the hallway?
Yes.
Where is that?
On my phone.
On your phone, okay. Is your phone here?
Yes.
Have you showed that to the police?
No, because once I knew what was going on today, I asked them, could I submit the videos? And I guess you guys have a time frame when things are supposed to be submitted.
And when did you have this conversation?
Today.
With whom?
Prosecution.
You say that he chased you around the complex, is that right?
Accurate.
What's that?
Accurate.
That is accurate.
Mm-hmm.
All right. Did you mention that to the police the day of the incident?
They seen the blood trail all through the apartment complex.
Okay, not just right outside, but they saw blood all through the apartment complex.
Yes, in the hallway. Yes.
So you told the police that they had that he chased you all over the complex.
Yes.
Right. Did you tell the police that he was acting strange and that he had put stuff in the parking garage like you testified to?
No, because once I stated to them to check, they opened it and I didn't hear, they didn't ask me no questions about what he had going on.
All right, Ms. McCollum, I don't think I quite
So
understood
once
that.
I let them know about the bag, they took it, they searched his items themselves. Once they discovered what they discovered, I was sent to a patrol vehicle. So I did not speak on anything that was going on with him since that day.
Okay, so you did not tell the police that he was moving bags into the parking garage?
No, because once I let them know to check the stuff that they already had, they did their own thing at that point.
What bag did he move to the parking garage?
He was moving these small bags here. This white bag, this green bag and stuff.
Okay, and when you say this
From
bag,
Exhibit 7, he was moving all of those things down the hallway.
all right, may I see that? You said, we're talking about State's Exhibit number 7, and you said he was moving the green bag and the white bag?
He moved all that stuff. Everything he owned, he moved it.
Okay, he moved it to the parking garage?
He moved those items there towards the parking garage. Because if you go towards the left of my camera, that's only going towards the parking garage. If you go towards the right, that's where the visiting parking lot in the front of the building is. in the video, you can see him keep constantly going towards the left, and all his things are disappeared at that point.
Okay, so in the video, you can see him going to the left, and then these items are no longer in the hallway in front of your door. Is that
You can
right?
see him on the camera carrying them. Yes,
All right, so before the police get there, he actually moves this stuff away from in front of your.
correct.
And how far away was this stuff, when the police got there, was this stuff all the way, the things in State's Exhibit number 7, was that stuff all the way in the parking garage?
So once they arrived, that's when I believe the driver, whoever it was, finally arrived. So he was trying to go take the stuff to the car. So as he was passing through, I was on the side in handcuffs. He was just walking past, taking his stuff to the car.
Mr. Tezera?
Yes.
All right. So, and you said he took the green bag, the blue bag, the white bags, right?
Yes.
So show me, I don't, and you said what was in State's Exhibit number 7, right?
Yes.
So I don't see a white bag here.
It's right there behind the green one. It looks tan.
What is that?
That bag right there behind the green one that looks tan.
So we could put it up on the
Yeah, that'd be
screen
great.
and
Great.
then we can use the touch screen.
Which one is this?
What exhibit is it?
Exhibit number 7.
So Ms. McCall, the screen in front of you is also a touch screen. You should be able to mark on things once a picture gets put up there. Is that the right picture? You can't move it. They have to move it. You're able to, your finger will become like a pen. Let's wait till we get the right picture up.
So the white bag is there with it.
Okay, don't testify right now. We're waiting for Mr. Hirsch to dial back in.
Thank you.
You back?
Show us the white bag.
It's under the burgundy bag right there.
All right, so.
So use your, if you.
Oh, right.
Whoops, no. Whoa, you did make it move. Stop double tapping and everything. I don't know how to make it small again. Oh my gosh, I've never seen that before. Try tapping it again like that to make it back to normal size. Okay. Now, see that circle in the lower left-hand corner that looks like a pencil? Tap that once. Now your finger is a drawing device.
Here.
Okay.
Thank you.
All right, so that white bag is the bag he was taking along with
It
the blue
was-
bag and the blue bag for parking.
It was multiple bags. It was a lot of bags.
So we were talking about, the state asked you if you had a reason to lie, and we talked about the aggravated battery charge, which is now dismissed, right?
Yes.
In addition to that, these bags were in your house prior to this, right?
These bags arrived less than an hour or two before I woke up.
And you told the police something, you seem to acknowledge that there's drugs in the bags?
Yes.
And you understand that in some situations, the state could charge you with trafficking in cocaine, since I know you have an explanation for it, but because you had drugs in your house and you say you knew about them, a sort of possession.
That's
right?
inaccurate. I didn't know about them until he called his ride.
Okay, I understand. Okay, you understand regardless of whether you're innocent or not, or you have a defense or not, you could be charged with it. It looks bad, right?
Oh, it was a question?
Yeah, that's the question.
Yes.
Okay, all right. But you never told the police because you didn't know, you just suspected it might be drugs. So you just said it's drugs, but you didn't know what drugs, if any, were in that blue bag or green bag or red bag or white bag, right?
Yes.
Right. Now, do you recall telling the police the night of the incident, got you all check his stuff? He got Molly, shrooms, weed, coke, everything else in his bags. You all ain't check his bags.
So I said that to the officer.
I'm asking if you remember saying that to the officer.
I don't remember giving them a list of things. I did tell them to check his bag because he had drugs. That's what I did say.
You understand that if you were charged with possession of trafficking in cocaine, this level, that there would be a mandatory minimum sentence. Is that right?
I'm not sure because I don't sell drugs.
Okay, I'm not asking if you sell or not, I'm just saying, you understand that if you were charged with this offense, that you'd be facing a certain sentencing guideline. There's a minimum and a maximum.
She said she's not familiar with that.
Okay.
Yeah, that's what I'm pretty much saying. I'm not familiar because I don't indulge in that.
All right. You understand that the mandatory minimum sentence for trafficking over 200 grams of cocaine is 15 years in prison, not probated to do 15 years in prison, not probated or suspended, 15 years in prison. You understand that's the minimum?
Yes, that's what you called me and told me about your client the other day. Yes.
Okay. So before you testified here today, you knew that was the minimum.
You told me that was the minimum your client was getting. Yes.
Okay. So what I think one of the things I said is anyone charged with trafficking cocaine over 200 grams, the minimum is 15 years in
So
prison.
you've covered that very thoroughly.
Oh, she said that's, okay.
Let's move on.
All right. So you mentioned you and I spoke on the phone the other day?
Mm-hmm. Yes.
Okay, that was Saturday. Was that Saturday?
Yes.
We spoke for about 15 minutes and 45 seconds roughly.
Maybe longer. You made more than one call.
And one of the things we're talking about is that you said, well, if I come down there, maybe I'll just say I don't remember. Do you recall saying that?
So when you called me, what I do remember was you called me and you let me know that your client let you know how much he still misses our relationship and how sorry he was. And you asked me, was I promised anything for your client? And then you let me know what he was facing. I felt like you were pulling my heartstrings at that time. And so the call ended at that point. So we didn't really have a conversation. So when you didn't call me back and said, hey, we can't talk to you, I did let you know because you said, do you still feel this way? Because you don't have to go. That was your words. You told me I don't have to go. And I let you know that I did receive what I needed to receive to come to court. And then we had the conversation, but it was never you voluntarily, you were speaking on for your client to have me, I guess, make me feel bad of what he was receiving.
Okay. Do you remember saying, well, if I do have to go to Georgia, can I still not testify?
So at the time when you called and said that he will be facing 15 years, I said I didn't know nothing of that, or the state never called me and pressured me, telling me what his involvement of how far it was going to go. They asked me, do I have time to speak on what happened? And I feel like out of everyone, you gave me the most details of what was going on. And I think it was more so you persuading me not to come so I wouldn't testify against him. That's how I felt about the situation. Because during the call, I text state prosecution about the phone call. And I told them that, hey, I don't feel comfortable at this point because I don't know what's going on. I think I'm here speaking on my situation that happened in my home. And you told me something else. So I didn't know that until you spoke to me about that.
All right. So I gave you some more details.
You gave me the most details.
All right. But you felt pressured by me?
To make a decision not to come, or if I cared about him and you try to tell me that he still cares about me and that he misses our relationship. And once this is over, maybe it can be more. That's what you stated to me on the phone. Yes.
Okay. Well, it's one of the things you said that you were upset, and you were only, for one of the reasons you wanted to come is you were upset because he hasn't contacted you in 3 years.
So what I said was, you asked me, how did I feel about coming to testify? I said, I still feel strongly about it because I have not talked to him. He never mentioned an apology to me or anything from the incident of him putting his hands on me. He has passed messages as I talked to you and told you of him saying he's sorry for doing what he did. That was it, and that's all. You asked me, would I not So do I want to be on his defense or not testify against him? And I stated to you, if he calls and he can apologize, maybe then I can have some sympathy for him. But I stated that he didn't have sympathy for me as he dragged me around my house. And you said that he was very apologetic for it.
Okay. Do you recall me telling you why he couldn't contact you over the last 3 years?
Yes, because you emailed me the bill and everything else. Yes.
I sent you an email with his bond.
Yeah, his bond hearing and his release form. Yes, she did.
And I explained to you that as part of his bond, he couldn't have contact with you directly or indirectly.
Yes.
It would be a crime.
Yes.
Right. But then you talked to a lawyer about whether you actually had to come because the state sent you some papers that looked like a subpoena, right?
Yeah.
To object to hearsay and outside the scope of this hearing, and
Scope of direct.
if it's an attorney, then it would be potentially.
We'll see where he goes with it. It's pretty much a dead end if he wants to know what a discussion with a lawyer meant, unless by lawyer he meant talking to the prosecutor. And of course, you wouldn't be giving Ms. McCall advice, but you should keep moving.
Okay. And give context, she said that I told her she didn't have to come. So
I heard what she said. Your question was, and then you reached out to an attorney. My ears perked up. We got an objection from the state. And I'm telling you to move forward with caution, mostly move forward.
Prior to talking to me, you had talked with someone who gave you legal advice, right?
Yes, accurate.
And you also talked to the state about whether you had to come or whether it was optional.
When I spoke with the state, they explained to me what the waiver was, even though they explained it to me, as I stated to you also on the phone. My grandfather works at the Upper Marlboro Courthouse in my state. So he connected me to a law advisor there, and I asked them to read over the waiver. They pretty much confirmed everything.
So I don't want you to get into what anyone confirmed or said who might have been serving as your lawyer. I know you're getting pulled in that direction. I'm going to tell Mr. Hirsch to pull you away from that direction.
Before you and I spoke, or when you shared with me that it was your understanding from speaking with the state that it was optional whether you come.
Yes.
Okay. Now you said, but if I do come, I may have something for you. Do you remember that?
No, what I stated was when you asked me who was I coming or not, I said, if I don't decide to come and I am issued an apology from him, then I can let them know that, hey, at least he was apologetic in some type of way. Because we couldn't even finish the phone call conversation because in that moment, before I even stated that, you mentioned that he missed me and this, that, and the third. And I text the appointed person that was talking to me from state, and they gave me a call and I ended the call with you. So I never continued that conversation with you at all.
Okay.
But before you go further, I want to make sure I understand. Ms. McCall, you texted the prosecutor or you texted this legal advisor that you mentioned?
I text your state prosecutor.
Okay,
Yes,
not
sir.
mine, but
Oh,
the
yeah.
district
Georgia,
attorney's
yes.
office of Fulton County.
Yes, sir.
Got it. Okay.
All right, thank you. You recall then telling me right before we hung up, I can give you something that will seriously help you.
I did never say that.
Your Honor, do you allow attorneys to approach?
We could talk. Why don't you finish your cross, and then if we need to have a conversation, we can maybe have the break for the jury, the afternoon break.
Right. You told when you and I agreed that my client's the one who called 911. Is that right?
Yes.
All right. And when he was calling 911, what were you doing? Where were you?
I was in front of him in the kitchen as he still was fighting me while he was on the phone.
Okay, so while he was on the phone with 911, he's fighting you?
Yes.
All right, was he choking you?
It was so much going on.
Okay. Do you recall telling the police that he's literally on 911 while he's choking me?
Because that's what he was doing.
Did you ever hit him with any sort of weapon?
Other than the frying pan and the marble tray, no.
Frying pan and marble tray?
Yes.
Is the marble tray the vase?
It's literally a tray, but it's made of marble.
Right. And where on his body did you hit him with this marble tray?
I don't even recall.
Did you hit him in the head?
Maybe the head, the shoulder, I'm not sure.
He was bleeding a whole bunch from what looked like his arm. Do you recall?
I think he did put his arms up when I had it, and it just, yeah.
Okay. And your injuries, again, your injuries were that he had pulled your braids and it caused your head to bleed a bit?
Minus scratcher, like everything was able to heal.
And were you able to show the police so they could document your injuries?
I know that day when I went in, they took photos. I'm not sure what happened or what they did with them.
Okay, but you had an opportunity to describe everything that happened to the police?
Yes, in interrogation, yes.
Did you say in interrogation?
In the thing when they interview, once they arrest you, I'm not sure what it's called.
Oh, so when they arrested you, they took a statement from you?
Yes.
And you gave a statement?
Yes.
All right. In the time that you were with him, did you know that he took medicine for epilepsy?
No, I didn't know he had epilepsy.
Objection.
Yeah.
It's not relevant.
What's the relevance of whether it overruled? We overruled.
All right. You, at the time of the incident, you were not working, is that right?
I had a trust fund.
Trust fund, okay. And he was working at Google Data Center?
I never seen him go to work.
You've never seen him go to work?
I never seen him work.
When my client threw the phone at you, you're saying he threw his phone at you?
Yes.
And then you wanted to look through it, is that right?
He gave it to me to look through it.
Okay. So did he throw it at you or he gave it to you?
He threw it across the room. He was sitting on the couch. So the living room and the kitchen is not too separate from each other. You can literally throw something off the couch and it can hit the counter. So he just threw it because I was making a big fuss about who he was on the phone with. So he threw the phone and stated it was his mom. He told me I can go through the phone. I went through the phone. The last call did say mom, but when you hit the text messages, it's not a conversation you would have with your mom.
All right, did you take a photo? I'm not saying you should have, I'm just asking. Did you take a photo or?
That was a few years ago.
Don't talk over Mr. Hirsch. He won't talk over you. Court reporter can only write down one speaker at a time.
Did you, I'm not saying you should, but did you happen to take a photo of those text messages?
No.
You, in order to get into his phone, you needed a passcode. He gave you the passcode, is that right?
He unlocked it and gave it to me.
You told the police, I mean, you testified that he's the one who called 911. You did not call 911, right?
No.
Okay. Do you recall telling the police that you did call 911?
When I did, I called them during the call for them to come. They already were coming. So when I gave them a call, they already said dispatchers are on the way to this address. So I didn't make an accurate report on the call.
Where in the complex was he chasing you?
Right where my door is, pretty much where all his stuff was in that hallway. It's like a garden style open flow apartment. So on that hallway, right there where all his stuff was lined up, it's an opening. I pretty much ran where the pool hall is and hopped the back gate. I had to go through the bush and hop the gate.
All right, so you hopped the back gate and went over the bush?
Yes.
And did he have a weapon?
No, he just wanted to keep fighting.
All right. And I think you had said, tell me if I'm right, you're the two family members were there at that time when he was chasing you all over the complex.
Yes, so they were there as soon as like I hopped the gate and stuff because they were talking to him. And then once I got out and I heard them talking, I came out and told them to tell him to leave. And he was ignoring the guy telling him to leave.
What is Anaya's last name?
Young.
And I don't know that I heard you real well. The father of her child, what's his name?
His name is Kareem. I
Kareem.
don't know his last name.
Right. And do you have a phone number for Anaya Young?
No.
All right. Did the police or the district attorney's office, the investigator there, ever ask you for contact information for them?
No, because we weren't involved in this at all.
Okay, but they saw him chase you all over the complex. They could corroborate some things. Is that right?
Yes, but with our case, again, he decided to drop the charges on me.
Who decided?
Emmanuel.
Decided to drop the aggravated battery charges on you?
Because I guess he was under the impression if he does it to me, I would do it for him.
And why do you believe that?
Because he dismissed the case.
2 years later.
I don't know when he did it, but that's when I got it back.
But why do you think it was him as opposed to the state? Or...
Because it was a mutual party arrest. We both were arrested for the same charges.
Okay.
So he felt if he didn't do it on me, I wouldn't do it on him.
All right. And what you're saying now is what you believe. No one's told you that. That's just what you believe in your head, right? That what you put together.
Because we never made it to court. I've never seen a courtroom about it.
All right. So since you never made it to a court, you're assuming that he dropped the charges on you.
Yes.
Okay. Now, when the police arrive at your apartment, they go into your apartment and take photos. Is that right?
Yes.
And you allow them to do that. They ask you to do that?
Yes.
But then after they're in your apartment for a little while, you use some fancy words, rescind your consent. You say, hey, you know what? I don't want you in my apartment. Go get a warrant.
Because at that point, when they first came in, I was in handcuffs at that point. They were concerned about me at first, and then it became I was not somebody they were concerned about. It was more so his concern.
Okay.
Mm-hmm.
Well, when they were more concerned about him, then why would you? But when you say concern, you mean they were treating him like a victim?
Yes.
Okay, I understand. All right. Now, when they were searching, before you said they couldn't search, did you know that they found money and scales in your house?
Money and scales in my house?
Let's take it one at a time. A large amount of money?
What was the amount of money?
I don't know, just as a large amount.
Yeah, that wasn't my property. The money that they found, that wasn't my stuff.
Okay, so whatever they found in your apartment, money-wise, a large amount, if there was a large amount, they didn't give it back to you.
It was never mine. That was all stuff that they intake. That's his items. That was his stuff.
All right, but I guess what I'm asking is, being there, did you know they found a large amount of money in your house?
No.
Okay. You said you knew that or assumed he must have drugs because he was telling someone on the phone something about the stuff, come get the stuff. Right?
He said, the police is on the way. I need you to come hurry up and get the stuff. That's what he said.
Right. I know that you testified to that, but you never told that to the police at the time of the incident. Is that right?
You can hear at one point on the video him talk about his stuff.
So the question was whether you, beyond telling the police in the hallway that, I don't remember exactly how you worded it, search his bags or he sells cocaine or something like that. Did you ever tell the police about that phone call you just described to the jurors?
No, again, they never asked me any questions after I let them know what was in the bags. Once they found what was in the bags, they separated us at that point.
Did you have a knife in your apartment?
Kitchen knives, yes.
All right. Was the knife used in the altercation?
No.
I'm going to show you what I previously marked as defendant's exhibit number 1.
Mhm.
Judge McCurney, may I approach?
You may.
Just take a look at that. If you recognize it, just let us know you recognize it.
That's the frying pan.
All right. Does that look like a true and accurate depiction of the frying pan?
Yes.
Your Honor, and is that the frying pan you hit him with?
Yes.
Your Honor, at this time we move to admit to evidence D1.
Any objection to defense exhibit 1, Ms. Nix? Have you seen these photos?
Yes, they were provided in discovery, so no objection.
Okay. Defense exhibit 1 is admitted.
All right. I'm going to show you what I previously marked as defendant's exhibit number 2. If you recognize that, please let us know what it is.
Yes, this is my kitchen stove.
And is that appear to be the kitchen stove after the fight?
Yes, you can also see the bleach she threw on me on the stove.
I'm sorry, you can see what?
You can see the bleach she threw on me on the stove.
Okay, so he threw bleach on you?
He poured bleach on my couch and everything. They should have photos of that as well.
All right, did he put bleach on you?
Yes, I was an attendant target for the bleach.
And did it actually hit you?
Yes, a little bit, like in my
What part of
face.
your body?
In my face, just on my clothes.
Judge, I think I'm just going to do a actually, so the issue I want to approach on, I can't rest until I approach on it.
Okay. What are we doing with defense 2?
I move to admit defense 2 into evidence.
Any objection to defense 2?
No objection.
It's admitted. Why don't we take our afternoon break? It'll be as long as it takes for me to talk with the lawyers about what we need to talk about. Please, no discussion about the case, no outside research.
Call out for third.
All right. Would you like Ms. McCall to step outside?
I think so, Judge.
All right. If you don't mind, ma'am, stepping outside, you can leave everything right there. And the investigator will get you back in here when it's time. Thank you. All right, Mr. Hirsch, it's time.
Judge, I would ask that
You all can be seated if you want to sit. I'm standing because I've been sitting all day. Sure, thank you.
how long is the afternoon break?
As long as it takes us to resolve your issue.
Some things just sort of happen on the fly. Would you give me 3 minutes, 5 minutes to configure in my head what my strategy is?
You had some things you wanted to talk about. I'd like to talk about those first so that I can give you my input as you do your strategizing. Although we're in the middle of a witness, we're not going on to the next witness. So the amount of time will be brief.
Well, there's an issue I may or may not want to bring up, and just the way the testimony is going, that's what I'd like to strategize with my team about. If you give me a few minutes.
Meaning the reason why we're taking this break, we may not even talk about based on the feedback you get from your team.
Yes.
Okay, then why don't you guys talk for a couple minutes?
Thank you.
And if Ms. Nix or Mr. Peoples, you need a quick break, now's the time to take it.
Yes, I just wanted to, for the record, object to stopping in the middle of a witness's cross-examination in order for him to.
Right, that's why he's gonna get maybe 30 more seconds to confer, because we don't do that just because something got complicated. So don't go anywhere.
Thank you.
All right, Mr. Hirsch, you've had a chance to confer with both rows of your team. So tell me if there's something we should discuss or if we should get Ms. McCall back in here.
Your Honor, I think for the sake of simplicity, I think we'll just move on.
Okay. Then let's see, once the jurors are ready, let's get them back in here. Are you good? We're only going till 5. Do you want a break or are you good? Okay. What's up, Mr. Rao?
Hey Judge, how are you?
All right, just dropping in.
Me and Joe are working on our trial for next week, so wherever he goes, I go.
Wise move.
It's too much sugar. My blood sugar is gonna crash.
That's why I need it.
Thank you, guys. Appreciate that. Judge, if I would packet of photos, do you want an individual sticker on each one?
Yeah, I mean, they can be 3 A, B, C, D, E, but they need to be individually designated for purposes of the record.
Just 3, 4, 5, 6, 7.
I don't want to go through anyone's best. I'll wait for mine for reporters.
Yeah, I'll authorize you to open that top drawer further to see if you find stickers. That's where, and if you don't find them there, then look against the edge of the other edge. No, although that envelope says exhibit labels, not that one. Put that back. On the other edge now, where you were. Doesn't that say exhibit labels?
Oh. It works perfectly.
I have some national tree journals.
You may want to leave money in there too. Yeah.
Training when I was when that PA's office. I use
County made copies of these for all the attorneys, and I'm not sure if I was allowed to print it with me, but it ended up with something, so that's why I still have it.
That's perfect.
Still have it there.
So Jonathan Melnick is suspended from practice for 6 months. And Anthony Van Johnson is no longer a lawyer.
No, really?
Yeah.
I just saw Melnick like the other day.
I just saw him yesterday.
Well, it's effective today, so
I literally saw him last week.
once Ms. Rivers comes back, we can bring them out. So keep them on warm standby.
Oh my gosh.
What was your question?
Not going to court, commanding funds,
For whom?
either or.
I didn't, the Melnick one I read this morning because I have a case of his. It was, he had a client in a family law case and didn't show up for a hearing and didn't inform the client about not being there and that there were adverse consequences of that. And it wasn't his first, so it was 6 months out. Van Johnson, it was actually a voluntary surrender, so whatever he was up against was a good case.
I almost had to testify in one of those back in Alabama about an attorney who repeatedly failed to show up to court, but he ended up
Doing the right thing.
was actually right before I started this job, and I was like, I'm gonna be in Georgia, so I can't come to Montgomery. We haven't gotten into the appointment with the officers. Those are
If you're telling me.
All right, let's get Ms. McCall back in here, please. We're good.
We'll get to see more. Oh, it's. He doesn't stop in the middle of his testimony. Just give him. Yeah.
Rise for the jury. President County Court.
Thank you, Deputy Gordon. Thanks for being ready promptly. Did you have were you just raising your hand? Nope. Did you have a question? Not for the witness, a procedural, logistical question? No? Okay. Thought you raised your hand. Sorry. You did. Okay. Let Deputy Gordon know and he'll let me know. Mr. Hirsch.
Thank you.
You are in the midst of your cross-examination of Ms. McCall.
Ms. McCall, I'm not going to ask you too many more questions. I'm going to ask you to look at some more photos. If you can identify them, please do so. If you don't recognize them, that's fine. And I'm going to do what's been marked as 3, 4, 5, and 6.
Next.
Do you recognize those photos? And if you want, we can take them one at a time.
Yes, photo 3 is the aftermath of photo 3 is the aftermath of the marble tray.
Okay.
Photo 4 is a picture of the stuff that's on my foyer. Picture 5 is another photo angle of my foyer. And number 6 is some more aftermath of broken up pieces from the tray.
All right, as far as you recall, do those appear to be true and accurate depictions of your foyer, what's in your foyer, and the photos you described as the aftermath?
Yes, that's my home.
All right, Your Honor, at this time I move to admit defense 3, 4, 5, and 6 into evidence.
Any objection to defendants 3 through 6?
No objection.
They are admitted.
Just 2 more rounds, 5 more photos. Let me hand you 10 and 11. Those will be easy ones. Do you recognize that person?
This is me.
All right. Does that appear to be a true and accurate picture of what you looked like when the police arrived?
Yes.
And these photos, those are the pure, like what the police saw or would have seen?
Yes.
All right, I'm going to move to admit defense 10 and 11 into evidence.
Any objection, Ms. Nix?
I don't know if she can testify to the, what the police would have seen.
No,
So the
but whether
foundation-
10 and 11 should be, I'm not asking if you object to the question. You didn't object to the question. I'm wondering if,
I object to the foundation.
okay, why don't you lay a different foundation for the photos?
Defense exhibit number 10 does that appear to be a true and accurate photo of what you said it was you at the scene when the police came?
Yes,
All right, same question for number 11.
yes.
I move to admit 10 and 11.
They're admitted.
And let's do these last 7, 8, and 9. If you recognize those, please identify them.
This is a dirty counter. This is blood on the floor. And this is the aftermath of how my kitchen looked after.
Okay.
The counter that you described, which is probably picture 7, is that your counter or just a counter?
That's my kitchen counter.
Okay, so your kitchen counter, is that your floor or the hallway floor in 8?
This is, I believe, the floors in my home, in my apartment.
Okay, and then you described 9, so
Yes, sir.
I'm understanding.
They appear to be true and accurate depictions of what you said they are the night of the incident.
Yes.
At this time, I move to admit 7, 8, and 9 into evidence.
Ms. Nix, any objection?
No objection.
They're admitted as well.
Ms. McCall,
Yes.
when it looks like from 7, 8, and 9, did you start to clean up your apartment a little bit when he was locked outside and the police were coming?
No, the stuff was already like that.
All right, so let me see the fence here. All right, so you have an altercation in defense exhibit number 7. There are a couple of rooms that are leaned up against the counter.
Mm-hmm.
They were leaned up against the counter before.
Yes.
Altercation?
Yes, that apartment doesn't have a utility closet. So it was placed on the counter on the side.
Defense 8, it looks like there's a blood smear on the floor, but that just got smeared some other way. You weren't cleaning it?
We had no shoes on. It was blood on people's feet, shoes. It was, and then it was in like pores of blood.
All right, and defense exhibit number 9, that appears as though blood has been sort of cleaned up with a rag or something else. Did you, now that I show it to you and say it that way, do you remember if you may have started to clean up?
This is not anything that's cleaned. This looks like his blood is dry. This is the same counter that he was chasing me around. And that's why the blood is only on the edges and the surrounding. Like when someone's trying to chase you around the counter and they're going like this, his blood is all on the trails. His handprints are on the side.
All right. So when the police come, Emmanuel Tezera is inside your apartment or outside?
He was still basically, the door was open. At this point, my door is just open. Like basically my whole downstairs neighbor, my next door neighbor, he was having a party at the time and him and his guests came outside. So pretty much the whole floor was outside.
All right, so when the police come, your door is open and there are a whole bunch of people who live at the apartment complex outside your door.
Yeah, well, people were watching, yeah.
Sure. How many people do you think?
I don't know. They had to tell the people not to walk that way.
So at any point, was he locked out of the apartment or he could always come in and out?
I did lock the doors. I opened the doors because at one point he was trying to rip the camera off my door. Once he tried to do that, he pretty much he walked away, came back, and he was like, I just want my stuff. Which I'm not trying to hold your stuff hostage. You can have it. So I was thinking, and once again, he just attacked me again once I opened the door.
All right, so if he was outside and you were inside, was the door locked when he tried to rip the camera off?
Yeah, at that time, yes.
So how do you know he was trying to rip the camera off if you were on the
Because when someone is grabbing your Ring camera or is in front of your Ring, it alerts your cell phone. So I was talking to him through the camera, telling him that the police can see what he's doing.
Okay, and that was all recorded?
Yes, that's on my Ring files, yes.
When the police took you down to the police station, how long did they interrogate you for? How long did they ask you questions about the incident?
Not long. Less than 30 minutes, honestly.
Thank you so much. No
You're
further
welcome.
questions, ma'am.
Ms. Nix, do you have any redirect of Ms. McCall?
Yes, sir. Ms. McCall, I wanted to clarify something that.
Yes, ma'am.
That you said, when, there were people outside in the hallway. Was
Yes,
that
ma'am.
when law enforcement came or after law enforcement?
It was one bystander that walked past. He was going to the party that was 2 doors down. More people did proceed to come out once the police and the investigators. It was a lot of people in the hallway at that time. Yes.
Okay, so you observed people just walking through the hallway. It wasn't like there was a ton of people.
Oh yeah, no, it wasn't like a line of people. The biggest group of people that walked down was about a group of 5 or 5 or 6, but they were going to that party that was there. So just they were already in the facility before the incident happened. We just happened to overspew it into the public area where everybody happened to be.
Did you see any of those people touch the bags that belonged to?
No, ma'am. Nobody wanted to get near because again, the blood was all, he had blood on everything. Yeah.
Okay. And when the police arrived, at that point, was your door closed?
No, I don't. It wasn't locked at all.
Okay. Let's make sure we're understanding. So, when I'm saying closed, I mean that it's closed, not that it's locked.
Oh yes, it was physically closed. Yes, ma'am.
Okay, so when you say that, we testified earlier about how when police arrived, the door wasn't closed, you mean it wasn't locked?
Yes, it wasn't locked.
So when, Officer Skidmore, or Investigator Skidmore and Officer Killiman arrived, they knocked on your door and asked you to come out?
Yes, well, they identified who they were from and then asked what was going on. And then they seen pretty much the scene, and then they just separated both of us. He was in the hallway and they left me on the other end of the hallway.
You also talked about, Mr. Tezera moving some of the bags into the parking garage. And we're looking at a photo of some of the items that were in the hallway. Those items that were in the hallway, or do you believe that his intention was to take them to the garage, or was he just, did you actually observe him taking them to the garage?
So I believe his intentions was for the package, the stuff, everything to be picked up. But due to him calling the police and they were already on their way with the overseeing calls from neighbors and also the 2 that he already placed, they were already coming. I think he had to spring into action to get them out. But in the parking garage in my community, only residents can open the garage. So if you had someone that wanted to come to the garage to get anything from there without anyone seeing them, you still would need me to open it up with my phone.
Okay, so I'm showing you what's been marked as State's Exhibit 7. This is the photo we looked at.
Yes,
earlier
ma'am.
Of the defendant's belongings.
Yes.
Those items stayed in the hallway, right?
Objection waiting.
Stop. Okay.
Where were those items when Mr. Tezera was taken to the hospital?
I'm not sure. I left before him.
Okay, so when you left, where were those items?
In the hallway. They had all his stuff lined up. I believe they're CSI. They were there. They were taking photos, and especially in the drug task force, they were there.
So just at that point, only law enforcement had collected those.
Yes, ma'am.
He had not taken them to.
No, some of the things that he was already moved out to the car, they checked them, and I don't know if they grabbed those things from the car. I wasn't privy to seeing that.
Okay, but what we're looking at in State's Exhibit 7, those items are still in the hallway.
Yes, by the time the police got there, yes.
Great. Don't lead, please.
You said that you and Mr. Hirsch had spoken on Saturday.
Yes, ma'am.
Tell us a little bit more about how that made you feel.
Objection relevance.
Overruled.
It made me feel like I needed to make a decision. I feel like I'm a person that wear my heart on my sleeve, and that's one thing I feel like his client did let him know. Um, when he did call me, he introduced himself. Um, before he asked me what was my stance or anything. He wanted to let me know that his client was very sorry, that he told me that if he could take it all back, he would. We will still be together. I was a good person to him. These are things that I already know I am. I feel like I'm good to people, but they're not good back to me. So,
Did you feel like he was asking you not to?
absolutely, I feel like him telling me the severity of what can happen and things like that. I felt like he was playing the cards where it was like, even when it came to the waiver, the multiple questions of the waiver, who did I have to look at the waiver? I knew trying to tell me that I needed appointed counsel before signing or someone to look at it. Like just discouraging things. So I got to the point where I was just irritated with everybody calling me because I feel like I moved on with my life. I started a whole new life. I'm in a better position than I was then. And I felt like it's just bringing back up my past that I moved forward with. So I text everyone and was just like, I just don't want to be bothered. And I did end up letting your office know once they gave me a call to say what was going on. I did let them know the conversation I had with him.
And when you say that you texted our office, was that either me or Mr. Peoples?
No, ma'am. The advisor that will help oversee with me when I was coming.
Okay, it was an investigator that had.
Yes, ma'am.
And you also said that you received what you needed. By that, did you mean the subpoena?
Yes, ma'am. Well, I didn't tell him I got the subpoena. So when he was questioning me about the waiver, it gave off like, don't come, or if you come, this was going to happen to him. And I didn't really want to tell him I already signed the waiver early that morning. So I kind of played it off like, yeah, I have to think about it. I'm thinking about it. Like, I just didn't want to give him an answer because it's kind of weird that he called me. So when we did talk, I told him, well, your client never apologized to me for what happened. And he was like, well, I can see, but he's like, I don't think you guys can talk to each other at all. And I was like, okay, that's fine. But he passed messages through other people before to let me know things. So once we had that conversation, he told me he would give me a call back, I believe around 3:30. He texted me and asked me, was I busy? I let him know I was at work, but he can give me a call because I have a private office. I can still take calls. So I took the call and he didn't let me know why his client couldn't call me because the charges of the restraining order still stands with us. But he wanted me to know that he's sorry and, pretty much just, I felt like he tried to make me hold on to the hope that we will have a relationship after this. And that's not what I'm looking for at all.
Keep talking about a waiver. What do you understand that to be?
So the waiver that I understood it to be was because I am in another state, that you guys cannot just sentence me as a regular citizen or resident of Atlanta. So you guys, the office contacted me first and asked me my story of what happened in the situation of this. And then I was given the choice, hey, we are doing this, we're doing this. It didn't feel like nobody was pressuring me on your end to make a decision. She was very nice the whole time she talked to me. I did let her know, your whole team actually, I let her know I was kind of scared to do this because I moved on. I don't harvest things like this in my heart with people. So, and she just let me know that it is just the due diligence that I will have to do if it's my choice though. She made that very clear. It's my choice. And when she just made me feel like I could be heard and I have a choice to finally speak on what happened, that's when I made the decision to sign it, but I didn't tell him that.
You also mentioned something about dropping charges. Did anyone tell you that the defendant had dropped charges?
No, I just kind of assumed it because with me now working a government job, I had to do a background, and I thought that would still be there. And that's how I got the information that the charges were dismissed on my record. I just thought maybe he did that because, you know, I didn't know. So that was something I'm not totally % accurate on why it was dismissed, but I just know it is.
Did you drop charges on him?
And they never asked me.
Okay, so if I tell you that it's not your decision or his decision whether these charges go forward, would that make sense to you?
Yes.
Now, you were talking about, you know, something about if the defendant did apologize to you for this fight you all got into, that you might have some sympathy for?
Yes, I believe even without the apology, even talking to you all in private, I remain to not damage his character from this night. I speak on the person that I originally met, the person that I thought I was in a relationship with, the one that I thought would protect me no matter what. That's the person that I told you guys about. I don't try to remember this as him. So I still feel like even without the apology, I made it clear that I feel like he does make bad decisions, but he's not a bad person.
And would having sympathy for the defendant cause you to not tell the truth today?
Absolutely not.
Let's talk about some of these videos.
Yes, ma'am.
That law enforcement didn't ask you for any videos?
So they didn't ask me did I have camera footage. In that moment, it was more so I was trying to prove that I was trying to remove him from my home. I physically showed them on the phone more so before they asked me to email the investigator that video clip. They seen the whole incident the whole night of how it went. And I pretty much was hoping me showing them the full video would then will see he came. I did ask him to remove. You can see me standing in front of my camera, holding my front door open, asking him to move. You can see him trying to rip it off. So I was just trying to show them.
The video that you showed officers on scene, that was a video that we watched earlier?
Yeah, a portion of it. Yes, ma'am.
And that was the video that you provided to the officers?
Yes, ma'am.
And you didn't provide us or the police with any other videos?
No, ma'am. I wasn't asked for anything from you all. No.
Did anyone, you said that you spoke with officers after you were arrested. Did anyone ask you about drugs?
No, ma'am. No.
Have you been truthful today?
Yes.
That's all I have, Judge.
Mr. Hirsch, do you have any recross?
Your Honor, based on how she recounts our conversation, I would like her to listen to the phone call and then put it into evidence.
This is happening in recross?
They just brought it up, yeah.
Oh, outside the scope, and there has been a reciprocal discovery motion in the file for months now, and defense never turned that over.
This happened Saturday, Judge, and it's not evidence unless I use it for impeachment, which I don't have to bring back in. But I mean, most of it's just the manner in which he says it happened. I think the phone call itself, is the best evidence.
And she described the conversation as she understood it. And she told him that, it's not appropriate. She's described the phone call as she understood it.
Right. So here's your dilemma, Mr. Hirsch. One, I think you probably should have disclosed it, but I hear you on the impeachment side. But if you're going to use it for impeachment, then you are using
pieces of it unless every single word is impeaching. And I suspect it's not. And then it's hearsay. So you would need to excise things that are not prior inconsistent statements. If you believe that from start to finish, it's all inconsistent, then you could play the whole thing. But I'm guessing that's not what you're going to represent to me.
It's not a specific thing. To me, it sounds like I was doing the way it was question asked, like how she felt, right? She said how she felt with the phone call. I think I knew that this might come up and I might be in court and might have to play it in front of you. I made an effort to be nothing but professional and courteous and give the information and
okay. I don't want you to testify on your behalf.
No, it's not okay. It's not a specific
I've not heard of impeaching sentiment or tone. It's typically witness says, nope, on the phone, I told you I wasn't there. And then you've got the phone call and the witness said, oh yeah, I was there. That's impeachment, but the how do you feel and how are we interacting? You can ask her about that, but I don't think the way you try to demonstrate what you're trying to demonstrate is have the jury listen to what would be, I guess, prior inconsistent sentiment as opposed to statement. That's my ruling.
Okay. May I briefly explain? And
yes.
Then move on? If she's like feeling coerced, then I don't get that's how it feels, but it comes off as objective. Whereas, you know,
you might have had a very conversational tone and you said, hey, how is this going? Understood. But that I think is not impeachment land. That's impressionistic. So if you want to ask if you raised your voice or this or that, we can explore that.
All right, Ms. McCall, I'm just going to ask you a few things about the phone call as you recall it, okay?
Mm-hmm.
All right. Was my tone more or less what it is right now?
No, it's the same.
It was
pretty much the same, yeah.
Okay. All right. And I told you that I represented Mr. Tezera, right?
Correct.
And that you could talk to me or not, right?
Correct.
Right. And that we did talk about like the subpoena and the waiver and whether you had to come or not.
Correct.
And I said a number of times, probably 5, 6 times or more. Well, you've talked to a lawyer. Talk to a lawyer about this. I cannot give you legal advice.
Well, you asked me, did I talk to a lawyer? And then I said yes. And then I think you was asking me another question. So I asked you. I said, hey, so what does that mean? You said, well, I'm not your lawyer. You asked me what was the lawyer that I talked to? What's his contact number?
Right, because I told you I couldn't give you legal advice. I said, let's have a conversation with the 3 of us, more or less, so we're all on the same page, right?
Yeah, but it was like multiple times you asked me for his number.
Okay, right. And again, it was in the context of, I don't want to put you in a bad position. I want you to know that I'm not trying to coerce you. Let's get an ally of yours here, your lawyer.
Yeah, I think it was more so about like the conditions of the waiver while you were, it wasn't like you were you were telling me what the waiver was, but then you also would let me know that it's optional, and then it was the bad stuff that can happen to him. That's why I feel like it got weird in the conversation, because it went from you trying to educate me on what the waiver was to you trying to, I guess, express some form of compassion I should be able to show him.
I think we agree on this. Let's see if I'm right. Multiple times I said, hey, let's not just have this conversation with the 2 of us. Let's get your guy here, your lawyer here to be involved also.
Yes, but there was, yes.
All right. Thank you, ma'am.
Thank you.
Jurors, if you have questions for Ms. McCall, write them and send them to Deputy Gordon, please. that it? Nope. Thank you. Oh, sorry, I mean to keep you waiting there. Ms. Nix, if you want to release whoever is still here, you can do that.
Thank you,
And
Judge.
then I will meet the lawyers. I just got to finish numbering these. Right outside, you all be at ease. Jurors, stay where you are, be at ease. We'll be back shortly. Where? Ms. McCall,
Yes.
few questions. First,
Yes.
can you tell the jury how long you had known Mr. Tezera before this incident? And don't get a little too close. I appreciate you getting close to the microphone. You're a little too close. Give it like inch and a half.
Either that same week or the week prior. So it's been a 2-week span before that.
That's as long as you all had known each other.
Yes, sir.
You mentioned you met while you all were out somewhere.
Yeah, we normally just meet out, but that was like probably our first 2-3 days together, like at my house. Yeah.
But when you first met, as in, hey, I
Yeah,
that was interesting. That would have been maybe 2 weeks before this situation.
Yes.
Okay. And then you're saying 2 or 3 days leading up to the incident, you'd been spending much more time together and he'd been at your place.
Yes.
The belongings that he was taking from your place, some of which we saw in the Ring video, there were some soft items like clothes. There was some black thing that went clunk when he threw it out the door. Were those everything something he had just brought over while you were asleep?
Yes, all his stuff was just brought to my house that day because he wanted to meet my family. Like at that point, we were thinking about furthering it, like the relationship. And I'm not sure if he had his own home at that time or not, but I think I was the one with my own place. So he.
But did he bring everything all at once while you were asleep, or did he bring things while you were awake and then some other stuff showed up?
No, it was all that day, all that night. He brought all new stuff that day.
Okay, but you say that day and then that night. Listen to my question. You talked about how you guys went out, you fell asleep, he went somewhere else, and then you woke up, he was on the phone with someone. Did everything that was out in the hallway come into your apartment while you were asleep, or did he bring some of it earlier in that day?
While I was asleep.
Okay. I need you to help a little bit with the timeline. So
help me put in order the following events. You are awakened to hearing Mr. Tezera on the phone and you don't like what you hear. So that's one.
Yes.
You guys start yelling and arguing.
Yes.
Is that next in order?
Yes.
Okay. And then it gets physical. You mentioned he swings at you across the counter and you guys are fighting in the apartment.
Yes.
When comes, and then he's chasing you around outside your apartment.
So as far as time frame, are you referring at what time of day was that?
No, not is it 10 o'clock or 3 o'clock. I'm trying to understand the sequence of events.
Oh, you pretty much laid it out, correct.
So chasing outside your apartment
happened after the fight inside the house.
Okay.
Yes.
You also talked about Mr. Tezera trying to get some of his belongings to a parking garage.
Yes.
Where does that fit in all those events? Before or after what?
So that was before he chased me, because he didn't start chasing me until I entered myself in the hallway.
Is it after the initial fight where he pulled your hair and you hit him with the tray?
At this point, he's bleeding when he's chasing me. Yes.
Okay. But my question was about you describing him trying to get his belongings to the parking garage.
Yes. So all of this happened after that. He was bleeding while he was moving those things. So it happened after I did it.
Okay. So first to the hallway after he's hurt, then to the parking garage.
Yes. And then come back.
Then run stuff back.
Well, he took that stuff to the parking garage. He came back for more things, and he was moving those things in the course of everything going on. He had a lot of stuff.
Okay. And when was it then that your Ms. Young and the father of her child arrived? Where does that fall in those different events?
Before he started chasing me.
Okay. Before he moved things to the parking garage?
This was in the course of him doing this.
Okay.
Yes.
They arrived while he was already bleeding, but moving things out of the hallway to the parking garage.
Yes, because she has the spare garage key and the spare key. So she goes in through the garage to enter to my building.
Okay.
Yes.
Can you describe for the jury, if you're standing with your back to your door, which way do you go to the parking garage?
To the left. So anytime you see someone on the ring camera go towards that way, they're going to the parking garage. If you're going that way, you're pretty much entering the building, heading to the resident center.
Okay. How far, estimate, if I turn to the left to go to the parking garage, is it 100 feet, 100 yards, 100 miles?
About 150 feet is literally next door to the apartment that you can see right in front of my apartment.
So basically it's just a couple doors
down. It's literally like next door to that apartment.
Okay. Was there anyone else living in your apartment besides you?
No.
And at the time, you and Mr. Tezera had initially the verbal argument and then it got physical. Was there anyone else in there?
No.
Other than seeing Mr. Tezera chase you around outside the apartment, were Ms. Young and the father of her child present for any of the physical contact you two had?
No, just the running.
Did you have a scale in your apartment?
No.
The Ring camera video, we got to watch 13 seconds of it. Is that video that you gave to the police or they seized it with a warrant or something?
I gave it voluntarily to the police.
And describe physically how you did that. Did you hand them a thumb drive or?
No, in the moment, that's how my aunt entered the apartment. I told him I had the footage on the phone. He let her go in. She brought me my phone. I was able to email it over to him.
Okay, so you electronically transferred that clip?
Yes, sir.
Did the police ask you for more footage from your Ring camera?
I honestly haven't heard anything about it since the night of the arrest.
Okay, so is that a no? They didn't.
No.
They didn't say, well, what about 13 seconds earlier or 13 seconds later?
No.
Okay, and I think you testified, you told the jury, what were you trying to convince them of by sharing that 13 seconds with them?
in that moment, I was the only one placed under arrest. So I was trying to show them that it wasn't that I just woke up or I just attacked them for any reason. It was more so to prove to them what led up to the events of the physical attack.
So that you sharing it with them was while you were still in the apartment complex before they took you away in the police car?
Yes, sir.
Did you stab Mr. Tezera?
No, just the frying pan in the marble tray.
Can you share with the jury your understanding of how Mr. Tezera ended up with, I don't know which arm it was, but he was bleeding heavily from one of his arms?
Am I allowed to show them?
Sure,
the
please. You want to demonstrate? Or you have a photo?
The photos.
Which photo would be helpful? Is it one that's there in front of you?
Yeah.
Okay, so tell the jury what number that photo is.
This is photo number 3.
Is that defense 3 or statement?
This is the defense photo number 3. For that photo. This is the marble tray that I use. It's normally like an IKEA's or Wayfair, the heavy duty type of marble tray. He just put his arms up, and as it broke, the pieces is like glass, so it cut his arm.
Okay, so you're not denying that you hit him. You're saying it was with a tray, not a knife.
Yes, truthfully, I did hit him, but it was not with a knife at all.
Thank you. Ms. Nix, do you have follow-up based on those questions?
No, sir.
Mr. Hirsch?
No, Your Honor.
Ms. McCall, I appreciate your time. You can leave all those photos. We'll get them in order. You can take your bottle of water and you are free to go. Thank you.
Judge, may Ms. McCall be excused from her subpoena now that she has testified?
That is something you should discuss with Mr. Hirsch.
No objection.
Okay. You are excused from your subpoena. Thank you. So, ladies and gentlemen, we are just a few minutes before 5. I told you we typically go 9 to 5. I asked the state to keep a witness here because I wasn't quite sure how quickly we'd get through Ms. McCall's testimony. I thought we might end closer to 4:30, but we got where we got. And it doesn't make sense to get a witness on the stand for 4 minutes and then say, you got to come back tomorrow. So I let the state release the witness who did stick around. I did speak with the lawyers for both sides when we were going over your questions that you had for Ms. McCall, and the state let me know what they've got left, and they think they'll likely get through all their remaining witnesses tomorrow, and then we'd see what remains for the defense. I think that you will still get this case to deliberations on Thursday. It just will be a little later on Thursday than I would have forecast. But I still think we're on schedule for you to have time to deliberate on Thursday. Again, your commitment was through Friday, and I'm committed to keeping you posted as I see things stretch out or contract. And I've got a better sense of these lawyers' pace now that we've gotten through some of the witnesses. There'll be several state witnesses that are pretty quick tomorrow. One will take a little bit longer on both direct and cross. Eventually the state will rest, and we'll see if the defense has any case they want to put up beyond what they've already shared through cross-examining witnesses. Reminder, no obligation for the defense to put on any case at all, but they have the right to do so. With that said, we are going to start at 1 o'clock tomorrow. The jury room is actually open. We get here before 9. So if you really like that space and want to show up by 9 tomorrow, go for it. Just know that I will be doing drug court until around noon. And I'll have the lawyers here ready to go by 1, and the state will have their remaining witnesses here by 1. I need you all here by 1 because we can't start unless all 14 of you are here. We're going to just go to 5-ish tomorrow. I know I had said, hey, could people stretch it till 6? We don't need to do that. So we'll go to 5-ish. We won't interrupt a witness if he or she is testifying at 5:00. If we can finish it up, it's always better to let that witness finish and not have to come back. So that's where we are. Any logistical questions from anyone? The shuttle may not run as frequently midday. It's, I think, every 15 minutes-ish when you show up in the morning. Well, how does it work midday? Every half hour. So if you roll into, I don't know if you're one of the red or green or yellow lots, whatever the colors are, if you roll in a little bit before 1, you'll be here a little late. It would be rolling in around 12:30 that you'd want to do to catch that 12:30 shuttle. If you're an underground parker or you take MARTA or someone drops you off with a parachute, just be here a little before 1 so that we can get going. Okay? Take your notepads with you to the jury room. Leave your notepads in the jury room. Please remember my incessant but important instructions. Don't talk about this case with anyone else. This can be your first test with outsiders. People are going to say, how'd it go? What was it like? And remember, some one-word answer, super, great, fine, but don't say, I need to get your impression of something like that. And no outside research. You have mastered the art of writing questions down. Good questions, all. And that's the way you scratch the itch of, I need to better understand something. Do it that way and not a different way. Thank you so much for your time today. We'll see you at 1 tomorrow.
Ross, adjourned.
Thank you, Deputy Gordon. I have just received a draft of the charge. So if I have time tonight, I'll go over that. But once I've put my own fingerprints on it, I'll push it out to both sides. My thought is that if we end early tomorrow, if the state rests at 4, we'll have to have the motion for directed verdict. I need to talk to Mr. Tezera about his rights. We'll probably just do the charge conference then and let the jurors go home. I'm not saying you need to rest at 4, but if we've got a cushion of time, rather than forcing a pivot to the defense, it's a natural break, and we would knock out the charge conference then, assuming I've gotten a draft to you all of the proposed charge. That's my vision and aspiration. Ms. Nix, anything else for the state at this time?
No, sir.
Mr. Hirsch, anything else for the defense?
No, Your Honor.
Okay. Please, both sides be here a little before 1 so that if we get all our jurors by 1, we can get started. Thank you.
Just a quick question. How does the court want to proceed with the admitted drugs?
The drugs stay with you. Ms. Rivers doesn't keep drugs, loaded weapons, volatile things. So if you would please take exhibits 20, 21, and 22. And everything else, if you guys could kind of organize, Ms. Rivers will be the chaperone for all those other things. All right. Oh, yes, a fresh cover. Yeah, she owned that. Thank you. Ms. Hansford, do you want more of these? Oh, you got a lot? I'll leave that. Okay. Yeah, we're getting feedback from others about that. Thank you. Okay, if there's nothing else, thank you all for your focus today, and I'll see you tomorrow a little before 1.
We gotta put that in our evidence.